20
But MD, 3 times a mood memo till today posted.
3 times your move.
Yes, please. And accommodate tomorrow.
Read your move, yes, 3 times. Tomorrow.
B group matter, my lord, the matter has become infectious.
Give. Unless it is 2:30, don't mention. Just give.
Number 1. Page number 5, clear number 29 and 30. Page number 6, clear number 31 and 32.
Serial number 32 minutes.
Mhm.
For petitioner, 3-4 weeks of accommodation. I found
32 at the request of counsel for the petitioner, relist on third Rajana.
Third is the fourth Raja.
3rd April.
Page number 7, serial number 33 to 38.
Have you informed the others?
so my other side.
Nay, brother. Next.
Page number 8, serial number 39 to 44. Page 9, serial number 45 and 46.
45.
Hmm.
I appear for respondent in this matter. Maybe taken up next week, my lord. Date maybe.
15 days.
Have some urgency. It's on a very short compass.
15 days, 1 week anta idari.
Take on next week, my lord. 20th the date maybe.
Certificate copies are supply for now petition certificate copies. Agra Shivamogga 15 days.
45 at the request of the counsel for the petitioner, relist on 30th March.
Page number 10,
My lord, made it on 29th.
29th Agala. 31st Agala.
27th.
27.
page number 10, serial number 47 to 50.
49.
Yes.
Petition.
Yes.
The matter may kindly be taken up day after.
By day after.
We had moved the back, but date was given as 7.
We inform Mr. Bandar. For the petitioner, released on 20th March.
Page number 11, serial number 53 to 55. Number 2, page number 1, serial number 1 to 3. Page 2, serial number 4.
Till number 5, my lord.
Hmm.
My senior name H. Devendrappa is not correctly shown, as I could not bring the file. Kindly have it next week. Opposite side is also there. He informed me that the case is listed today.
We informed CICM.
The matter may be posted 2 weeks later because he has to get me an answer from the
Some
corporate.
instructions are awaited.
So 2 weeks, they normally don't move very fast.
has entered appearance for the petitioner. Delete Rupert Rosario. He is not a. Rupert Rosario is no longer appearing in the matter. For the petitioner.
I have filed for comment.
Yes. So delete Rupert M.
He is
Rosario
not appearing.
as that appearing for the petitioner. The counsel for respond number 1, 4 and 7 seeks for and is granted 2 weeks time. Released on 31st.
List to serial number 6, Your Lordship.
Yes.
Your Lordship, I
Yes.
seek short accommodation in this matter, Your Lordship.
You are for whom?
Appearing for the petitioner in this matter, Your Lordship.
List ready ಆಯ್ತಾ? ವೆಬ್ ಹೋಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕು ಇವಾಗ. ಯಾರು ಪಂಚಾಯತ್ ನಾಮಂಗ Imagine. The BN Somayaji is directed to accept notice for respond number 4, counsel for the petition. Copy of the petition of the connection.
Your Lordship, one more short submission I would like to make, Your Lordship. Your Lordship, this matter has to be connected with another writ petition, Your Lordship, because it involves
The
the same
number?
set of facts. Your Lordship, WP 14872 of 2022, Your Lordship.
Released on 3rd. Yes.
Page number 3, serial number 30 to 20.
Serial number 15.
Hmm.
1 week's time. Paper petition.
Have you informed the respondent? Next. Arting and everybody, ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ.
Serial number 19, my lord.
19.
Counsel on record, Rakshit, for the petitioner passed away, my lord. The court will issue notice to the petitioner.
19. Wherein AG accepts notice for respondent number 1. It is informed that the counsel for the petitioner has expired and issue court notice to the petitioner returnable by 29th May.
Next, serial number 12.
Inform ಮಾಡಿದೀರಾ?
Government.
ಅಲ್ಲಿ ಒಬ್ಬರು ನೋಡ್ಬೇಡಿ, ಬಾಕಿ ಜನ ಇದ್ದಾರೆ.
Assistant Commissioner and Commissioner.
ನರೇಂದ್ರ ಗೌಡ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? ಗುಂಜಾಲ್ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? ಮಾಡಿಲ್ಲ, ಅದೇ ಸುಮ್ಮನೆ ವೇಟ್ ಮಾಡಿ.
Page number 4, serial number 21 to 27.
Serial number 23.
Serial number 16, my lord, I'm sorry, serial number 16.
ಎಷ್ಟು ನೋಡಿ?
Serial number 23 in list 2, your lord.
ಹಾ,
For the respondent,
yes.
I need to file objections. You have to find 2 weeks time may be granted.
Have you informed everybody?
Yes,
R2 special Tahsildar Muda andre,
Muda. I represent
you also have to take accept notice for respondent number 2.
respondent.
B. Sharad Gowda, who has entered appearance for respondent number 1, accepts notice for respondent number 2 also. He seeks for and is granted 2 weeks time.
Next time.
Released on 3rd April.
13 and 14, my lord.
ಏನಕ್ಕೆ ನಿಮಗೆ ಟೈಮ್ ಬೇಕು?
Section file ಮಾಡಿದ್ದಾರೆ.
13 and 14, learned counsel for the petitioner seeks for and is granted 15 days time to go through the objections filed by the petitioner respondent and address argument. Released on 3rd.
Can I request in 16, my lord?
My lord, serial number 18, my lord.
Yes, Mr. Vijay Kumar.
My lord, serial number 16, weeks accommodation. I've informed the other side, my lord.
EO TP Elanka. MS Devraj accept notice for respondent number 2. Secretary Kadbugere Gram Panchayat. Korono Aurena Macholli. Accept notice for respondent number 2 to 4. Counsel for the petitioner along with connection on the said councils. Released on 3rd April.
My lord, serial number 18, my lord. Cause list 2.
Yes, Eddie.
1 week adjournment, please, my lord. File is misplaced, and I request this honorable court, please, for adjournment, please.
Have you informed everybody else? Who is
My lord,
appealing?
my lord, is a case of NOC. We have to take an incision for the government advocate, please, my lord.
Have you informed the other councils about the mentioning?
No, my lord.
Read ಮಾಡಿ ಅದನ್ನ.
Serial number 28, my lord.
28.
Request for 2 weeks time to
Who is now appearing? Ajit Kalyan.
Mr. Ajit Kalyan. I informed him.
Is here, 28. Shri Ajit Kalyan has entered appearance for the petitioner. Delete the name of the Girdhar SV and Girdhar and Company as that appearing for the petitioner. Shri Sharad Gowda seeks for and is granted
2 weeks time
for
for filing the objection statement of objection.
6. Seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 31st, relist on by 30th, relist on 3rd.
Please, grateful.
Number 1, order number 1.
Paper has filed the sketch, my lord.
But ಇವಾಗ ಎಷ್ಟು ಬರೋದು ಹೆಂಗ್ ಬರುತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್? 2 ವರ್ಷ ಆದ್ರೇನು ಬರಲ್ಲ. ರಿಪೋರ್ಟ್ ಅಂಡ್ ಸ್ಕೆಚ್ ಹಾಕಿದ್ದೀರಾ?
House.
Have you received copy?
I received copy, has just been given to me now.
No.
Great respect, no? Would you Lordship kindly take the order of 26 now?
26.
I'm reading from the middle of the paragraph. 22.
Yes.
I'm reading from our fifth line.
Hmm.
So as to resolve the dispute between the parties, it would be appropriate to direct the respondent BBMP to conduct survey of the subject property with assistance of ADLR after notifying the petitioner, after notifying the petitioner as well as the respondent, DSSB to ascertain as to whether the property of the petitioner is utilized for laying pipes.
Hmm.
That's the order direction, my lord. That, my lord, in my submission has not been complied.
Where is the report? When did you file the report? How file ಮಾಡಿದ್ರಿ?
10-3. Marked place. First one, ಈ ಬಣ್ಣ ತೋರಿಸಿದ್ರು ಅದೇ ಸೊತ್ತಾಗಿರ್ತದೆ. ಸೆಕೆಂಡ್ ಒನ್ ಈ ಬಣ್ಣ ತೋರಿಸಿರೋದು ಹಾಲಿ ಕಾಂಕ್ರೀಟ್ ರಸ್ತೆ BWF ಚರಂಡಿ ಮಾರ್ಗ ಬೆಸ್ಕಾಂ ತಂದಿ ಕಾಂಕ್ರೀಟ್ ರಸ್ತೆ ಒಳಗೆ ಹೋಗಿರುತ್ತದೆ.
ಪೈಪ್ ಎಲ್ಲಿದೆ?
ಒಳಗಡೆ
In the road only, my lord. I already filed the statement of objection. The BWSSB laid the pipe in the year of 2008 only, my lord. It is in the BBMP road only.
BBMP road, my lord. Even their schedule also, western side road schedule.
So it is when there's the 16 feet road is what they are considering. Darshan, their contention is not in your property.
That is exactly my content. That's exactly what was canvassed before this court. This court specifically directed that a survey should be conducted to find out if it is there or it is occupied my property. This does not say so.
They are saying it's not in your property by saying it's under the road. That's the necessary implication. That's the necessary implication.
So I'll respond to it.
Want to file objections to this?
First big group.
In your favor, why do you want to file?
Please. I'd like to take some instructions on the
Commission's report is finally filed. The same is taken on record. Counsel for the petitioner seeks for and is granted
2 weeks.
2 weeks time to file objection to the report, if any. To be filed on or before 30th, released on 3rd.
Relation, lad, big group.
If a director has to file, thought of file it.
ಯಾವ ಫೈಲ್ ಮಾಡ್ತಾರೆ?
ಒಂದು ವಾರ.
The BL Sanju Leonard counsel for the petitioner seeks for and is granted 10 days time to comply with the order dated 17 February 23. Released on 28th March at 2:30 p.m.
Number 3, Anna Nair.
Back to appear for.
Business line.
ಅವರು ಒಂದು ಅಫಿಡವಿಟ್ ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿದ್ರು. ಎರಡು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಿ ಅಂತ. ನಮ್ ಸೈಟಿಗೆ ಮಾತ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿದ್ದಾರೆ ಪ್ಲಾನ್.
ಅವ್ರಿಗೂ ಹೇಳಕ್ ಬಿಡಿ.
Lord, I want 2 weeks time, my lord.
2 weeks time.
The commissioner is newly appointed there and he'll initiate action, my lord. I want.
So you want to take action?
Yes, my lord.
We'll record that.
Yes. To take action, my lord. What action?
To take action meaning, what is your
Because
submission?
he has to initiate, so he's just appointed, my lord, because he has to initiate action or look into that entire matter.
Planning authority Asan yaru? And AG accepts notice for respond number 2 also. Counsel for respond number 3 submit that the commissioner has been newly appointed and seeks for 2 weeks time to file a better affidavit. Better affidavit to be filed on or before 30th, released on 3rd.
Please.
Number 4,
I represent the petitioner.
After day after tomorrow, by today I'm getting the records. I will see it and I will finish.
And counsel for respond number 1 and 2 submit that he will be securing the records today. And released on 20th.
Serial number 5. Yeah, let's.
ಪೆನ್ ನಂಬರ್ 2 ಡೈಡ್ ಆಗಿದ್ದಾರೆ ಎಲ್ಲರೂ ಫಾರಿನ್ ಎಕ್ಸ್ಟ್ರಾಡೆ ಏನು ಬಂದಿಲ್ಲ ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಮೇಲೆ 1 week ಗ್ರಾಂಟ್
Notice not ordered in respect of 1 to 4 yaro.
One state of Karnataka, Taluk Panchayat Kodam, Kadu district, Village Panchayat Kadu district, Arcot Private.
Now, DG accept notice for respondent number 1. Kadur yaro. Mangalore.
Ashok Naik. Ashok Naik.
Ashok Naik accept notice for respondent number 2 and 3. Notice to respondent number 4 is dispensed with for now. Counsel for the petitioners serve copies of the solution on the connection with the council. Relist on 3rd.
Serial number 6. Krishna Nayak.
Krishna Naik, R1. R1 yarama.
CMC Sira.
Yes, Raju. Yes, Raju accepts notice for respondent number 1. LAO NHD Tumkur. And AG accepts notice for respondent number 3. None appears for the petitioner. Copies to be furnished to the aforesaid council. If the same is not done, the petition will be liable to be dismissed for non-prosecution. Relist on 3rd.
Serial number 7.
But I represent petition. Last petition was directed to ascertain when khata property has been affected in the name of the second petitioner. The order which is impugned is 5/4/2004. The second petitioner got the property in the year 2003 by virtue of under the gift deed that is dated 16/1/2003. Khata was entered on 6/9/2004 and proceedings has been initiated against my husband. There was a strange relationship between my husband and myself subsequent to gift deed of 16/1/2003. He files an appeal before the KAT, and because of vengeance against me, he withdraws the appeal, and thereafter I files the appeal before the KAT.
You are supposed to produce some. Are you producing, not producing?
Yes, ma'am. It's ಮಾಡಿಲ್ಲ. ಇವತ್ತು I was able to secure it today.
ಅದೇ ಹೇಳಿ. Use ಮಾಡ್ತೀರೋ?
ಮಾಡ್ತೀನಿ.
Counsel for the petitioner speaks for and is granted.
6/9/2000.
ಅಲ್ಲ ಯಾವತ್ತು? When will you file?
Tomorrow I will go into
2 days time to file the documents undertaken to be filed on 14/2/2023. Relist on 21st.
Serial number 8. C. Vivekananda.
Address weeks time to take steps.
11, 12, yarama, 9, 11 and 12.
Private parties.
Private parties. Counsel for the petitioner seeks for and is granted. Weeks time to make payment to necessary processes and furnish copies in respect of the unserved account. Needful is done, registry is directed to issue notice, returnable by 29th May.
Serial number 9.
9. Third.
Private party. Code is person dead.
None appears for the petitioner. No steps have been taken in respect of respondent number 4. If no steps are taken, by 20th, the petition will be liable to dismiss for non-prosecuting, relist on 24th.
Serial number 10.
For the second respondent, I was directed to file a report indicating lots the width of the road, my lords, and whether there is a possibility of widening the road further, my lord. We have taken the photographs, my lord. In 1 week time. My apologies, my lord. In fact, what happened was, my lord, the BBMP was not a party in the public interest litigation which directed for.
Correction was on 25/1, Mr.
Photographs have been taken, my lord. There was a confusion.
Photograph ತಗೊಂಡ್ರೆ measurement
Yes,
ಮಾಡ್ತಾರೆ.
I will.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
Next week, within a week.
Counsel for none appear for the petition. Party in person.
The last occasion, he made a submission that he would be out of country sometime.
When is he coming back?
He would have come back by now, my lord. On his request, it was listed today.
None of the petitioner party in person is not present. Counsel for respond number 2 seeks for and is granted 10 days time to comply with the order dated 25/1/2023. Relist on 27.
Rajagopala Naidu on correction matter.
My lords, I'm appearing for appellant, my lord, as a proxy counsel. My lord, the amendment shall be carried out within a week, my lords. Kindly grant time, my lords, in this case.
Counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendment and file amended cost title. Relist on 28th March.
Much obliged, my lords.
My name may be deleted.
Really?
11.2, my lord. I filed Wakala.
11.1 ನಲ್ಲಿ delete since Subramani MA has entered appearance, delete TM Venkat Reddy as that appearing for R1 and R2. R3 Rahul Reddy will accept in 11.3.
No, my lord. They are different parties. They are different parties. Different parties. All four are different.
ಎರಡರಲ್ಲಿ ನೀವು ಇದೀರಾ ಇವ್ರಿಗೂ ಬಂದ್ಬಿಡಿ ಅಂತ ಇಲ್ವಾ?
Instructions.
Well, counsel for the petition seeks for and is granted 10 days time to comply with office of relist on 28th March.
Number 13.
Same 28th.
Case note that to the caveat below already served a copy on 9th itself.
Ananda.
9th itself.
Very Ananda.
Anand and Peter.
Yes, ma'am. You served it.
Please, 9th itself, 9th. I'll serve this copy.
None appears for respond number 4. Registry is direct in the name of Subramanya Egade, VG Murthy, Sridhar TR. As that of respond number 4. Counsel for the petitioner submit that he has already served a copy of the petition along with annexes on respond number 4
Please.
on 9th. The Pavan Kumar accepts notice for respond number 1 to 3. Mandamus quashing the work order and Severa.
No, his worship can say the first document produced before Salvakut is Annex A. Wherein not this is an agreement which was entered into be between me and the respondent. Wherein Lord, here, this Lordship can come to this page number 39, Lord, class 18, Lord. The term of this emotion shall commence from the date of the commencement of the work mutually agreed upon it shall continue in full 5 years and subsequent extendable up to 15 years as mutually agreed upon unless until it is terminated by the parties. Absolutely, they have not issued any notice of termination for me. There is nothing as such. One Miss Kausalya Miller, the court respondent with the rent, she came on the day and she said that the work is already allowed to be as such. He said, you know what, you have to evict. Lord, then I locked it and came back. Lord, in such an event, Lord, the second agreement which was entered successfully 5 years has completed. Second agreement, my lord, we have entered into, my lord, Annex B, where in it was extended to 20. Then, my lord, up to 20, my lord, the term was extended, my lord. Lord, Annex B is the page 42.
Yes.
It's the one wherein what was still to up to 20, my lord. Governing, my lord, again, class number 18, page 44, my lord. Governing law dispute resolution, if the parties fail to resolve the dispute as per the 17 case of dispute resolution between parties cannot be settled as mutual possession, the grieved parties shall approach the court of law, for which the courts of language shall have to do action. Then, Lord, I came to this honorable court, and my lord, for this agreement has to be enforced. Absolutely, there is no complaints against me.
You can come before this court. Mr.
Please, Lord, earlier, my lord, they have played the same step, Lord. Not a minute.
It's a specific performance you are seeking.
You last time kindly say, earlier, my lord, you last page number 60, my lord, you last kindly page number 60.
Arbitration class.
One second, sir.
You are appearing.
Yes, I am for the respondent
60.
number 4.
Page number 60, my lord, they have played the same mischief before against me. So that when I approach this honorable court, this honorable court has passed the interim order. I am not a concluded this, you last time kindly say, they have provided with the space.
What you are seeking for is specific performance of a contract.
Your lordship, I
And
can
it's been terminated.
They have not terminated. Straight away they allotted to Srimati Councilor, who is arraigned for this morning.
Not terminated.
Not,
Copy is not.
they have not terminated.
Copy could be already.
What is this? What is this?
And copy code. What's your name?
Not sir. I am for KSB, my lords. I am for the respondent number 4. I am a caveator on right.
As you know.
Judicial director in the name of so and so. None of us take that. Mr. Pawan Kumar accepts notice for respondent number 1, 2, 3. Counsel for the petition serve copies of the petition along with annexures on the said council. Released on 28th March.
Because my lord, they have already break open this particular door, not everything, my lord, they.
21st March.
21st March.
ಜಾಗ ಬಿಡ್ಬೇಕು ನೀವು.
Oh, sorry.
Left your. Application for amendment is filed. The other side, enough to say that it could be allowed. Mandamus is, the mandamus thought is to consider our application for renewal, modification of the license and issue, renewal and modification.
Application, this court has suggested to furnish a copy of the letter.
Yes, we have.
So he has furnished 2019 application. So without any acknowledgement, only
Yes, acknowledgement illa.
Huh?
Acknowledgement illa. They have sworn to the affidavit saying that acknowledgement is not available.
Well, affidavit memo ಹಾಕಿದೆ.
Like, the affidavit for amendment. we are sent. Court could consider whether mandamus could be issued.
See,
Grant the license in accordance with law.
seeking reissue of the license is to be applied through an online for an application. New act ಬಂದ್ಮೇಲೆ 2020 act ಬಂದ್ಮೇಲೆ even the plan as well as the khata applied online as a khata. Hard copy.
What is the, you have given details about the setback. What is the buffer zone?
The last document is NGT judgment.
Now, if you are going to make a new plan,
I not would remember that has been set aside, except in response 10 and 11. It is not applicable to others.
because the retrospective operation is being set aside, but it will be prospectively applicable.
Yeah, yes, number one. Number two is it has been set aside as far as we are concerned. Only 2 builders have been penalized. That judgment is also produced.
Yes, that is respondent number 10 and left.
That's right.
Is set aside.
A learned friend was suggesting that online application can be filed. We will consider that mandamus issue.
Order was not taken
The last
the buffer zone.
court has suggested the same point which I have canvas to file to review or if fresh whatever it may be, let him file in accordance with the online. So the concerned documents may be filed. So along with the online, we will consider them. See, this application, in fact, this application was filed by the 2019 without acknowledgement. So let him file a fresh application. So that's what the last application has suggested.
Three ATM Integrity Learned Counsel for respond number 2 submit that there's no application as such received by the respondent to consider
9/12
process. Like Shri S.P. Shankar, Learned Senior Counsel submit that though the application has been submitted, it does not get the acknowledgement since the respondent did not acknowledge it. In the above situation, I am the considered opinion that it would be in the interest of justice to direct the petitioner to submit a fresh application.
Through online as well as hard.
Available online process as also a hard copy of the
matter to be
requisite
record. Your Lordship, my kindly
When will you file it? When will you file it?
We filed it in 2019.
When will you file your fresh application?
1 week ಸಾಕಲ್ಲ.
New work.
ನಮ್ಮೋರ್ ನಿದ್ದೆ ಮಾಡ್ತಾರೆ 15.
The counsel for the Shri S.P. Shankar submits that such application will be submitted within a period of 15 days from today.
In accordance with the Supreme Court.
Such an I don't know according with law.
I think I have been corrected by your Lordship.
If an application is submitted, the respondent to consider the said application strictly in accordance with law within a period of
after 6 weeks.
6 weeks from the date of receipt of the said application. With the above application, the petition stands partly allowed. IA does not serve.
Number 16.
Respond number 2, not 2.
Cost ಅಲ್ಲಿ
For allotment of the same.
ಫಸ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡಿದೀರಾ?
Pay ಮಾಡಿದ್ದೀವಿ. Receipt ಹಾಕಿದ್ದೀವಿ. Respond number 2 and 3.
AG accepts notice for respond number 1. The Pawan Kumar accepts notice for respond number 2 and 3. Allot the site and deliver position. Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
I will give a copy.
Mandamus allot site and deliver position. We'll consider the application.
I will take instruction on the matter of site is what is.
We won't say possession or consider the allotment in accordance with law.
I will see the file.
Pawan Kumar
Short date maybe.
and is granted 10 days time to obtain instructions released on 28.
17. Srinivas Reddy.
None appears to be recognized, none were to appear. In black, 28.
Rajendra Kumar.
Yes, Mr. Kumar.
Produce that is challenging one certified copy order, not the. It was produced earlier, Xerox copy.
Next year, AP.
AP is the layout approved plan.
Production of original stock certified copy of annexure AP is dispensed with for now, subject to no objection being raised by the respondents as regards this documents. RD Planning Authority,
Yogesh Naik.
Yogesh Naik accept notice for respond number 1, and AGA and 5.
5.
And AGA accept notice for respond number 6 and 7. Issue notice to respond number 2 to 4, and by 22nd May.
My lord, they are trying to sell the properties, my lord, sites. The issue is that, my lord, including my property, they have taken the conversion and layout plan, my lord. More than 100 sites have been sold, my lord. When there is a stay.
This is
granted
your
by-
property they have taken. This.
Yes, my lord. Including that, this layout plan, which they have.
But
taken.
you have to show that you are the owner of the land.
I am the owner of the very same survey number. I have produced all the documents in fact number.
Where is the RTC for that land?
RTC, my lord.
Total extent is to.
All the sale deeds I have produced.
Total extent is to.
Total 3 acre of 43, 3 acre 33 guntas of land belongs to the petitioner, my lord. And it's the same survey number, my lord.
RTC.
RTC. I have produced only the sale deeds, my lord.
RTC.
RTC. I have produced all the sale deeds.
Total extent ಎಷ್ಟು ಅಂತ ಗೊತ್ತಾಗಬೇಕಲ್ಲ first. ನಿಮ್ಗೆ ಬಿಟ್ಟು ಇನ್ ಬಾಕಿ ಅವರು ಇದ್ರೆ if the total land
ಅಲ್ಲ,
is 25 acres and you want 3 acres, you can't extend.
My lord, total extent of land is 10 acres, more than 10 acres.
ಅದೇ ನೋಡಕ್ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕಲ್ಲ ಅನಿಸ್ತದೆ.
ನಾನು already ಬೇರೆ indeed which I have produced, and my lord, one document wherein, my lord, they have
ಯಾವ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ?
they have ಅದ್ರಲ್ಲಿ ಒಂದರಲ್ಲಿ they have already entered into a settlement with the petitioner in a writ petition number, my lord, in page number, kindly see, my lord, wherein they have accepted the joint memo filed by the parties.
Where is Mr. Yogesh Naik? Joint memo ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ ಪ್ಯಾರಾದಲ್ಲಿ they have clearly accepted in page number 105, my lord.
105.
Right. That is a joint memo filed before this honorable court. They have admitted that
Overlapping of the properties.
that is in para, my lord.
Exactly what we asked you. Overlapping of the properties.
Overlapping, that is what, my lord. They have access, land has been, they have taken in their sale deed. That they have accepted to, my lord, rectify the sale deeds and boundaries and conversion order, all the documents. Without complying these terms which they have agreed in the compromise memo, my lord, they have moved the conversion order and taken this layout plan also. Para number 7, my lord. Para number 7, and they have accepted that they have taken excess amount property, and even para 6 also they have agreed. May I read that para, my lord? The third respondent further submits that what was granted to Basapachari in total 4 acres in all aforesaid 4 survey numbers, and whereas third respondent has got it registered excess extent of land to the tune of 2 acres of 35 guntas. That land is, my lord, in certain land is belongs to the petitioner, my lord. In all the 3 survey numbers. Even para 7 also they have accepted for that survey number.
Where is the sketch attached to it?
Sketch is, my lord, even they have agreed to.
Where the sketch attached to it?
127, my lord. 127 page number.
ಇದಕ್ಕೆ ಅಟ್ಯಾಚ್ ಆಗಿರೋದ ಅದು? ಇದು ಬೇರೆ ಏನೋ?
ಅಲ್ಲ, ಇದು joint memo, ಅದ್ರ ಮೇಲೆ joint memo has been filed before the JDL.
ಯಾಕಂದ್ರೆ if you don't answer the questions and if you are, where is the sketch attached to this compromise, joint memo? ಅದರಲ್ಲಿ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲೆಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಓವರ್ಲ್ಯಾಪಿಂಗ್.
ಅದನ್ನೇ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಏನ್ ಮಾಡಿದ್ದಾರೆ, JDLR court ಅಲ್ಲಿ very same joint memo has been filed. The same file which was produced before this honorable court, with the same joint memo has been filed before the JDLR. wherein Shivanna shows, my lord, in all the U shape, my lord, we are having the property of our survey numbers. Because
Not indicate to be so.
because in writ petition, my lord, they have agreed that they will file the joint memo along with the sketch, my lord.
The condition of the petitioner is that the respondents are selling sites in a layout approved over the lands of the petitioner. This, any such sale shall be subject to the writ petition.
Petitioner has mandamus to consider the representations of annexure M and N. The petitioner herein is an allottee of a site bearing number 1207 found by the respondent authority Buda.
When ADA accepts notice for respondent number 1 and 2, Sharat Gowda accepts notice for respondent number 3, counsel for the petition to furnish cost for the petition connections. Registry wants refund.
Annexure
P
28, Allotment.
Number 20.
Sharif.
Taking in of mandamus, consider the representation. But there is a Gadiga in survey number 70, where the state of Gadiga, the survey number 40 is there. Right, it is being used by the villagers for a religious purposes.
ADA accepts notice for respondent number 1
and 3.
and 3. PDO Gram Panchayat Changiri Taluk, Davangere.
Anil Kumar, J. Anil Kumar.
J. Anil Kumar is directed to accept notice for respondent number 2. Counsel for the petition serve copies thereof from 28.
Petitioners, my lords. From 305, KVAT
File case.
is not put up.
Give it number in.
My lords, 3071 of 2023.
You are for Undegowda.
That is subsequent to the filing of the writ petition. On 20th February, they have filed the KVAT. Writ petition is filed on 23rd January.
Matter is coming before this court for the first time today.
Please.
It should have been put up.
We serve the copy.
3.
Specially agreed.
Especially every day. Submit
For
the
R5.
KVAT has been filed on behalf of respondent number 5 and KVAT petition number
3071 2023.
30.
3071 of 2023.
23. The same has not been put up. Registry is direct put up the same. Registrar Judicial is also directed to inquire into why the KVAT petition is not put up. List on counsel for the petitioner to serve copy of the petition along with annexes.
Please.
On the counsel for the KVAT, learned AGA accepts notice for respondent number 1. Taluk Panchayat Madhur,
Somayaji.
Madhur Mandi Allavrena.
Ah,
Shri B. N. Somayaji accepts notice for respondent number 2 to 4. Counsel for the petition to serve copy of the petition. List on 28.
I have sought for stay. Short date may be given. Yes, sir.
The short date ending that 21st.
20th.
21.
20th.
20th already 106 matters are listed. Right, Marcela?
20th.
Serial number 22. Vice Minister.
Of petitioner. This is a writ of mandamus. Challenging the annexure E on. Trade letter.
Challenging well.
Annexure E.
Cancel the trade letter. You are asking for a mandamus to cancel the trade license.
Yes, Your Lordship, because it
You ask for a certiorari.
or certiorari have
Mysore City Corporation. MP Geeta Devi is directed notice for respondent number 1 and 2. Issue notice to respondent.
another submission, Your Honor. Another connected matter is there with this.
returnable by 10th April.
Connect this
Connect
matter with
upon
another
with the
matter. Petition 24,366 for 22. Connect this. How much?
The petition issued by the respondent to the petition on 29/3/2022. On the instance of the MLA of the constituency of the Jammu have cancelled the work order as per the annexure H. The annexure F, the annexure G is this, F is the second notice. The petitioner has given the his explanation along with photographs annexure G1, G2, G3. Is performing duty without giving any scope of the complaint from the public. But the respondent one instance of the letter by the they have respondent cancel the work order the annexure H.
Or access notice to respond number 4. Counsel for the petition, sir, copy of the petition on the justice office.
Connected matter is on 31st. 31st.
31st. Number area.
2116. 2116.
On 6 of 2023. This one 31st.
I am from the petitioner, my lord. My lord, the Panchayat general license of the petitioner workshop without issuing notice, my lord. And there is an interim prayer also. My lord, what actually happened is that the petitioner took on lease a property to establish a wood carving workshop, my lord. And he has spent crores of rupees for the same. And after obtaining the license from the Panchayat, he has done all this and he obtained the electricity bill also. Now, my lord, they asked me to give certain documents belonging to the property. I produced the documents, but suddenly without issuing any notice and without asking for explanation, they have cancelled my license, my lord. Because of, and also I am producing this memo, my lord. They have also written a letter to the ESCOM to cancel the electricity connection also, my lord. My lord.
Who is respondent number 2?
The complainant, my lord, he is actually a far relative of the petitioner. He appears to have given a complaint to the Panchayat.
Property dispute.
No, yes, my lord. Personal vengeance, property dispute, because of that he has given a complaint. And based upon that, they did not question me even on that. They just asked me to give some documents. I have already given the document.
Anekal Taluk, Dommasandra Gram Panchayat. Devraju accept notice for respond number 1. Issue notice to respond number 2, returnable by 17th April. The operation of the order dated 1/2/2023 at annexure W is stayed until the next date of hearing. Made clear that the petitioner can continue with its business in the said property.
Number 25.
Let us appear for respondent within 2 weeks time. Objection. Finding of objection.
Counsel for not already in respect of respondents. Accepts notice for respond number 1 and 2. He seeks for and is granted 2 weeks time to make statement of objection is if any by 30th, released on 3rd. Interim.
26. Rajat Richley.
Therefore, the Judicial is seeking for the building plan sanction.
Demand note.
Demand note.
AG accepts notice for respond number 1 to 3. Why do you want 2 and 3?
I made a part.
Pawan Kumar accepts notice for respond number 4 and 5. in view of the part disposals on the table now. We will connect with so and so. We list on 11th. Fifth, 5-4.
Representation as per
Consideration of
next year, real representation, change the khata and iswattu in favor of the petitioner. Property of the father partition to the partition deed.
iswattu ಯಾಕೆ ಇಷ್ಟು representation?
ಅದು ನಮ್ಮ ತಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ತಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Then the partition among the family member. We make a representation before the authority.
We issue direction in the matter. And AG accept notice to respond number 1. Chikmagalur,
Ashok Naik.
Ashok Naik accept notice for respond number 2 to 4. Released on 21st March.
Further hearing, period number 28.
Today only they are giving their proposal of settlement development.
There
was some proposal, an outcome of husband and wife. Wife is not very challenging a private.
What is the proposal?
Our proposal in Kotidrala, they cannot reply. What their proposal was, their case is, my lord, sum of 79 lakhs was given, out of which I have purchased a couple of sites. Now their proposal was that entire 79 lakhs should be given to them, as well as the site should also be handed over back to them. Now what I am suggesting, my lord, at least let us sit and discuss half of the site, whatever the property is there, I'll reconvey it to you, or we can sell it and we can share the proceeds. 50% will be given to them, 50% is what.
2 sides.
Is what I am suggesting.
So it's 1 side for 2.
That can also be, that can be sat across and we can discuss it. And
Why do you want to sell capital gains and all that?
that should also be okay. That should be. That can,
Date may be. Council, both.
May suggest this. It can be referred to mediation. My lord, let them sit across the mediation. I mean, in the mediation.
Mediation, both of you sit together and sort it out.
Please.
It's already gone to mediation.
It's gone, but I feel, my lord, this time there is some progress because my client was otherwise you are not open for discussion. This time,
both of you sit and talk it out. Reach to that small thing.
please.
If then it can get over here. Otherwise, even at that stage, if both of you feel that it has to go to mediation, we'll refer it.
Please.
Because if it had not gone, we would have directly referred. It's already gone. Now both of you know where both of you stand.
Correct.
So between both, you can sort it out.
I'll have a word.
Both the council seek for and are granted
20th.
10 days time to explore a week to explore the possibility of settlement. We list on 20th. 20th, but 21st.
Much of the some difficulty on 21st. Request for 23rd.
23rd.
Please. Great.
Final hearing.
It's an interim order, my lord.
Interim order earlier granted is extended.
Narayan.
WP against petitioner is dismissed as abatement.
Only against R, petition number 1, 2, 3, 4. Petition number 1.
Yes.
Petitioners here, viewed by the, passed by the first respondent, next year, your letter. Page number 37. Vishaya Sankhya 4.
87.
Page number 37.
Yes. Okay,
Panchayati Karyakala. Vishaya 4. Assessment number 733. Astiya Khateyannu Srimati Akkayamanavara. That is the respondent number 2. ಅವರ ಹೆಸರಿಗೆ
ವಿಷಯ ಸಂಖ್ಯೆ 4
ಅದರಲ್ಲಿ ಕ್ಲಾಸ್ ಹೌದು. ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ 733 ರಾಷ್ಟ್ರೀಯ ಖಾತೆಯನ್ನು ಶ್ರೀಮತಿ ಅಕ್ಕಯ್ಯಮ್ಮ ಅಂದ್ರೆ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಹಿಯರ್ ಇನ್ ನೋ ಮೋರ್ ಎಲ್ಲ ಇದ್ದಾರೆ. ಅವರ ಹೆಸರಿಗೆ ಬದಲಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ ತೀರ್ಮಾನ ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಚರ್ಚಿಸಲಾಗಿ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ 733ರಲ್ಲಿ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣೆ 22x33 ಮೀಟರ್ ಅಳತೆಯುಳ್ಳ ಬಲ್ಲರ ಬೀದಿಗೆ ಸೇರಿದ ಹುಣಸೆಕೊಪ್ಪ ರಸ್ತೆಯಲ್ಲಿ ಬರುವ ಆಸ್ತಿಯು ಶ್ರೀ ಹಲಗಪ್ಪ ಬಿನ್
ಹೊನ್ನೇಗೌಡರ ಹೆಸರಿನಲ್ಲಿದ್ದು. ಹಲಗಪ್ಪ is my grandfather, petitioner's grandfather.
Algappa is
Petitioner's ಇಲ್ಲಿ ಇನ್ನೊಬ್ರಿಗೆ ಹಲಗಪ್ಪ is, that is the grandson of the his grandfather grandson name is one and the same, ಸ್ವಾಮಿ ಹಲಗಪ್ಪ. ಅದಕ್ಕೆ they have produced the G3 annexure A, ಸ್ವಾಮಿ, ಅದರ ಟೈಪ್ಡ್ ಕಾಪಿ. ಅದರಲ್ಲಿ ವಂಶವೃಕ್ಷ ಹಲಗಪ್ಪಗೆ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳು, ಅದರಲ್ಲಿ ಹೊನ್ನಪ್ಪ ಅನ್ನೋರ್ ಮಗನ ಹೆಸರು ಹಲಗಪ್ಪ ಅಂತ. ಪೇಜ್ ನಂಬರ್ 12. Algappa is my grandfather.
Algappa bin Honnappa.
Algappa is my grandfather. He had two sons, Honnappa ಮತ್ತೆ ಸಣ್ಣಪ್ಪ ಅಂತ. The present petitioners are Sonnappa's children, Algappa, Honnappa, Chandrasekhar, and Honnappa's son Shivanna is no more now. He had two brothers who were no more before filing of the suit petition only ಅವರು ತಿರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರು. ಸಣ್ಣಪ್ಪ ಶಿವಣ್ಣನ ತಿರ್ಕೊಂಡ್ರು. ಈಗ ಉಳ್ಕೊಂಡಿರೋದು 3 ಜನ petitioners are the son of ಸಣ್ಣಪ್ಪ.
Shivanna is alive. Very Algappa and
ಹೊನ್ನಪ್ಪ, ಚಂದ್ರಶೇಖರ್, ಶಿವಣ್ಣ 4 ಜನ ಸೇರಿ ಹಾಕಿದ್ದು.
Your Shivanna is also no more. Right?
No more. That is why petition against petition number 1 is abetted. Is no more.
Shivanna son of Honnappa is no more.
No more. The first respondent will continue. As for that one, ಹಲಗಪ್ಪ ಬಿನ್ ಹೊನಗೌಡರ ಹೆಸರಿನಲ್ಲಿದ್ದು ಸದರಿಯವರು ಮಂಚನಾಯಕ ಬಿನ್ ಸಿದ್ದನಾಯಕನವರಿಗೆ ಮುದ್ರಾಂಕ ಇಲಾಖೆಯಲ್ಲಿ ಕ್ರಯ ನೋಂದಣಿ ಮಾಡಿರುವುದರಿಂದ ಮಂಚನಾಯಕರು ವಂಶಿಕರಾದ ಶ್ರೀಮತಿ ಅಕ್ಕಯ್ಯನವರ ಹೆಸರಿಗೆ ಕಾನೂನು ಸಲಹೆಗಾರರ ಸಲಹೆಯಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಬಹುದಾಗಿರುತ್ತದೆ. Agreed by this one.
ಮಂಜು ನಾಯಕ ಬಿನ್ ಸಿದ್ದನಾಯಕ.
ಅಂದ್ರೆ ಇಲ್ಲಿ ಕಂಟೆನ್ಷನ್ ಇಷ್ಟು. Our contention is that my grandfather had owned this property and after his demise, revenue documents still continued in his name. ಅದಕ್ಕೆ annexure EA ಮತ್ತೆ annexure F produce ಮಾಡಿದ್ದೀನಿ, show that it is still continued his name. Then I came to know that public ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ annexure G, the first respondent had issued a public notice with respect to change of khata to the name of the first respondent. Then I filed my objections. Then later on I issued the notice to the first respondent. ಅದ್ರ ಬಗ್ಗೆ ನೋಟಿಸ್ ಕಳಿಸಿದೆ ಸ್ವಾಮಿ, without informing me, without hearing me. On 23/7/2012, they passed the as per annexure helps.
Annexure number, page number 2.
Annexure L, page number 37 ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ವಿಷಯ ಸಂಖ್ಯೆ 4.4.
ಅದು ಇವಾಗ ಓದಿದ್ವಿ.
ಹೌದು ಸ್ವಾಮಿ, ಅದನ್ನ without hearing me, without giving me any opportunity, I issued the notice.
Where is your objection? Objection is earlier.
First annexure page number 26, typed copy of annexure H, wherein I have filed my objection to that ಸಾರ್ವಜನಿಕ public notice. ಅದಕ್ಕೆ objection ಹಾಕಿದೆ. Later on I issued a legal notice. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮ ತಾತನವರು ಲೇಟ್ ಹಲಗಪ್ಪ ಎಂಬುವರ ಹೆಸರಿನಲ್ಲಿ ಎಲ್ಲರ ಬೀದಿಯಲ್ಲಿ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ ಮೀಟರ್ ಅಳತೆ ಖಾಲಿ ಜಾಗವಿದ್ದು ಸದರಿ ಜಾಗವು ನಮ್ಮ ಪ್ರತಿಷ್ಠಿತ ಸ್ವತ್ತಾಗಿದ್ದು ಯಾರಿಗೂ ಪರಭಾರೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಸ್ವತ್ತನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಸಿಕೊಳ್ಳಬೇಕೆಂಬ ಪ್ರಯತ್ನದಿರುವಾಗಲೇ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ಇದೆ. ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆಗೆ as per annexure G, their public notice I had filed my objection. Later on at annexure A, I issued the legal notice.
ತಿರಸ್ಕರಿಸಿ ಖಾತೆಯನ್ನು ತಡೆಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ.
Thereafter annexure case, page number 28, I issued legal notice to them.
Yes.
97, 98 also, it was standing, ನಾನು ಆತನ ಹೆಸರಿಂದ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. 97, 98 annexure, page number 17 annexure is to show that it was standing in my grandfather's name. On page number 18 annexure F also, further annexure F also, to that I have paid and it was standing in my name. A notice go no reply ಕೊಡ್ಲಿಲ್ಲ and also did not hear me. Proceedings ಹಾಗೆ ನಡೆಸಿ without
Even for the sake of argument, please not, there is a registered sale deed executed by Alagappa in favor of my father. On the basis of the, just because, please, my lord, the petitioner,
Where is the sale deed?
lord, the copy of the sale deed is not being produced by the petitioner here.
Have you produced?
Lord, last occasion I entered my appearance, but since it's a 2012 matter, going through the records, please, my lord, I'm submitting. Now, there is a sale deed.
We also have to go through the records. Not only you going through the
My
records.
lord, to secure instructions also, even otherwise, please, my lord, the claim of the petitioner is that there is a sale deed.
So you want to argue without that sale deed, you are free.
I'll secure the sale deed and all that.
You should, beginning only you should make that submission.
Allah, my lord, even otherwise, please, my lord, this remedy would be before the civil court.
Now, first, let us see if you have the sale deed.
Please.
Then that question will come about. Counsel for respond number 1 seeks, respond number 2A seeks bond is granted a week's time. To
Not 2
produce
weeks.
Sale, 2 weeks time to produce the sale deed such to have been executed by one Alagappa, the grandfather of the petitioners herein in favor of.
Manchanayaka.
Who is he to you?
My lord, he is my father.
Father of, which is respond number 2.
2A.
2A. Released on 3rd April.
Figure number 30. Jeta Nayak.
Appeal counsel is on her legs, ma'am. Kindly pass.
Pass. Ready?
31.
Thirty-one.
I represent to respond number 5, ma'am.
5 ನೀವು ಇದ್ದೀರಾ?
My lord,
So ಇದೇನು ಕನ್ಫ್ಯೂಸ್ ಶರತ್ ಚಂದ್ರ for R2 and R5 ಅಂತಿದೆ. GR Ramchandrappa for R3 to R5. Now M Shiv Prakash for R5.
R5. Or returnable. Well, authorities, Allah.
ಅದು note
Jilla Panchayat, Bangalore Rural. Taluk Panchayat, Nelmangla, Begur Gram Panchayat. This is Jilla Panchayat, Bangalore Rural. The MS Devraj. Taluk Panchayat, Nelmangla. The MS Devraj was appeared for respond number 4, except notice for respond number 2 and 3 also. Registered directly with the name of Sri R. Sharat Chandra as that appearing for R2 and 5. GR Ramchandrappa as appearing for R3 to R5. Since Sri M. Shiv Prakash has entered appearance for respond number 5. Then we correct list on the
Real application and the
objection on Wakalat. In view of the same, the objection as regards Wakalat of R4. R4 and seal Sariyaga Akila.
statement of
Who has signed, who has
objection.
ಆಗಿದೆ.
ಹಾಕಿದ್ಯಾ? Return ಆಗಿರ್ಬೇಕು ನೋಡಮ್ಮ.
is written with office objection.
ಒಂದೇ ಒಂದಿದೆ ಜಸ್ಟ್ ಪ್ಯಾರಾ ನಂಬರ್ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್
Paragraph number IA4. What is IA4 for disposal of WP?
ನಾನು ಹಾಕಿದ್ದೆ ಮೆಮೋ ಇರ್ಬೇಕು. Petitioner disposal ಗೆ ಹಾಕಿದ್ದೆ.
IA1 of 17 for direction ಏನಿದು?
At present ಆಗಿದೆ.
IA17 which is filed by advocate for petitioner. Counsel for the petition submit that it does not press IA 1 of 2017, hence IA 1 of 17 is dismissed, as not pressed. IA 4 of 2018, 1 of 2019 and 2 of 2019 are filed for early disposal of the above petition. They are allowed. Counsel for respond number 4 to comply with the office objections within a period of one day, about 2 weeks.
1 week.
Within a period of 10 days from today. Relist on 28th March. It is made clear that no further adjournment would be granted. Finally.
Number 32, adjourn 33.
Here to the respondent. These matters pertain to, my lord, sale certificate issued by president without a resolution, my lord, without taking permission from the government or from the Zilla Panchayat. The lordship had asked other writ petitions also which are connected. My lord, I'll provide the writ petition, my lord, numbers 8702/14. I'll provide it to the court officer, ma'am. With
Only
three
one?
matters.
Only, how many matters are?
There were 3 matters, ma'am.
When are they listed now?
My lord, those are not listed at all, my lord.
That day you did not provide the list.
Yes, my lord, I took collect.
Counsel for the respond number 2 submit that the above matter is connected to so and so, so and so, so and so. Relist on, can I register that connect the above matter and relist on 3rd.
Yes, ma'am. I'll provide.
Give that sheet of paper.
Yes.
35. 34. Serial number 34, Nagarajan Naidu.
Is the then Mike administration has entered Abdagalu Dejanti.
Just 1 minute. Mr. Shriyari. 10 to 19. Ashwathappa yarge. 4 to
R9. 10 to 19. R4 to R9. R4 to
Yaar was Shriyari na Ashwathappa na for R4 to
R4 to R9 IIP.
R4 to 9 you are there. 10 to 19.
Srihari appears. Srihari.
Ashwathappa or S. You are ready, madam? Just call Mr. Shriyari. We'll pass it over. We'll take it.
Let me look at it.
35.
Kulkarni.
Petitioner. You have copy, sir. Paragraph 2 and paragraph 6. State as a party.
Yes, motion we have to see. Comment. Lords, the last question, my lordship may be pleased to see the order pass, my lords, whether it works for
lease of 5 years is what he's looking at, or a lease come sale? What was the question posed to them? Now they have come back. Now they have come back to say that they would want a lease come sale as on 1997. A week's accommodation. I'll file my objections to this.
Affidavit does not advert to that, Mr. Chair.
That's what is happening here. The first ground that's without even looking at affidavit. That's my contention is that I request to.
You had made some submission last.
Yes, sir. I made a submission.
Undertook to file an affidavit.
Yes, sir.
And the affidavit that you have filed today is nothing to do with your submissions made.
That's my submission was that the annexure A is not applicable to me because it passed after a particular period of time and cannot be applied retrospective. At that point of my words, I'd asked him to file an affidavit whether do I want a lease deed for not for a period of 5 years. I'd even mentioned that also stating that whether I would want a lease deed or a lease come sale agreement. So far as that, I have mentioned that in paragraph number 2.
What have you mentioned?
Second part, where I speak about therefore. Therefore, petitioner when submits response therein ought to allot land in terms of their assurance and on par with other allottees, that is either execute a long-term lease deed or execute a lease cum sale deed at a rate prevailing on the date of acquisition or equivalent as in obtaining the first order from this honorable court in 1997.
What is it that you want? Lease or a lease sale?
I would want to be placed in parity with the other allottees. Whatever they've done with the other allottees.
What has happened to the other allottees?
They have executed a lease cum sale deed.
Where is that?
One of the agreements which I was able to procure, that's will find at page 50.
Okay.
Page 50, 50. To one Mr. S.K. Khalil,
This is a sale deed which came to be executed.
Yes, sir. They executed a sale deed itself. That's what is happening.
In your question, in your matter, the question is that your land is acquired, you thereof. This doesn't read like in you. This is an application filed by him, he was allotted aside and the sale deed was executed.
That may make the submission. May take my lots to one later, which I had. That's annexure E, page 55 minutes. The chronological events that may have to be considered. I may take my lots to the second page of the letter at page 56. Unnumbered paragraph 2 minutes of that page.
There are allegations that you are making in your letters and in your oral arguments before us. What we asked you to do is to place some document on record to establish your allegations. They are only oral allegations.
I will show that. I'll show that to this particular letter.
We can't see. We have already shown us these documents. Mark, see so many flaps are there. But that is not leading anywhere. You can go on making allegations.
That's my only submission is that at the first instance, whether a lease is for 5 years, 10 years, or any amount of years, this circular cannot be applicable to me because it is made under or issued under section 176 of the KMC Act, which empowers lease only for about 3 years. Now, we cannot even fall back on the section or the circular owing to two aspects. One, 176 itself. Second, the affidavit filed by the erstwhile commissioner. I understand,
If we quash this, You won't get any benefit from this.
Because I wanted
Don't
to
want-
read down.
Fine.
Because I want to have it read down, my lords, to say that it's not applicable to me.
Okay, it is not applicable. Then what?
That's then, my lords, let them allot.
Then nothing.
Let them allot land to me as it was prevailing in the year 1997. Because
That's not a thing that we can, unless you put that on record. The first prayer will allow. The rest of the prayers will have to reject.
that's at the time, that's my,
They're presuming that because first prayer will be allowed, rest is consequential. They're not consequential. You have to place records.
it's not consequent. That's consciously, my lords, I've not used the word consequently also.
But actually, that's what you're saying.
That's, I would not be able to.
Even if you succeed in prayer one,
let's have read into it. That's my,
and get the rest.
my only request. May make apart from the affidavit filed by me, may take my lords to page 75 annexure L,
Yes.
which is an affidavit which has been filed by the then commissioner of BBMP.
You show that. Don't show your allegations.
Yeah, none. I will go by BBMP stand. May I read, my lords, at paragraph number 2. I submit that I have highest regard and respect for the orders passed by this honorable court. I submit that this honorable court on 29/6/2009 was pleased to issue an order to show cause for non-compliance of the orders issued on 2/12/1997 in WP number 15771 of 1994. An order dated 15/12/2001 in WP number 33668 of 2000 by filing an affidavit within 2 weeks. As soon as I received the intimation, I secured the papers and noticed the direction issued to BBMP with regard to allotment of alternate site in favor of the petitioner on lease basis. I submit that Honorable High Court in writ appeal 334 of 2004, dated 4/1/2005, has observed as under where they.
At the most, you can refer to para 5.
Yes, ma'am. I'm coming to that. It is reported. I submit minutes. I just read for sake of content. Paragraph 4. I submit that records disclose that subsequent to filing of the above writ petition, concerned Assistant Revenue Jeevan Diwan Nagar was instructed to send paravised remark. Paragraph 5. It is reported from the concern that no vacant site available in the industrial area. I submit that estate officer has identified an alternative site in commercial zone suitable for petitioner's business. The site now identified is situated as Bomanari zone, which comes under BBMP limits measuring 15 meters into 20 meters. A detailed sketch has been enclosed. I have passed an order of allotment of said site situated measuring 15 to 20 meters in favor of the petitioner as per the direction issued by the Honorable High Court. Details with regard to the lease amount and execution of the lease deed and possession certificate and other related documents will be communicated to the petitioner in due course. And thereafter, my lords, he says that I.
You were a leaseholder.
Yes, ma'am.
The lease rights were acquired. Last time you argued all these things, and then you have to file notice whether you want a lease for a period of 5 years or a lease come sale. Now converting your leasehold rights to a freehold right. What is it that you want? If you want a lease for that period of 5 years, you will have to place your affidavit on record, then we can direct them to consider it as on the prices that were available then. But if you want a lease come sale, which is higher than what rights you had, you will have to pay for it.
That's on both these counts. Last time also I had
Cannot
mentioned.
they take a freehold right?
That's I respectfully bow down with. That's not my contention. And I agree, my lords, this was the exact thing which was canvassed from my side. I'm just repeating. So far as the 5 years period is concerned, there's absolutely no reasoning as to why it is 5 years. Having acquired it back in the year 1979. And so far as the lease cum sale deed is concerned,
First you decide whether you want, what is your argument? Is it for lease or lease cum sale?
Maybe passed over. I'll file a better affidavit right now. It may be passed.
If you are.
I have my client also here. I'll ensure that it's.
Three and R.
My lord, I'm filing the report of the commissioner, engineer. The question is about unauthorized construction. We are filing the report today to say that unauthorized construction continues.
S.N. Prashant Chandra, who has entered appearance for respond number 4, accepts notice for respond number 3 also. Registered name as such.
Or should we kindly see the order dated 31/1 and 9/2/23? Petitioner says that there is no unauthorized construction.
Memo dated 13/3/2023 and close the report. The same is taken on record. A copy thereof is furnished to petitioner. You are furnished.
WhatsApp copy ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು ಇವಾಗ hard copy.
Instructions ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ I will go through and file the
Instructions ಬೇಕಾ?
ಬೇಕಾಗಿದೆ. ನಾನು
photo ನೋಡಿದ್ಮೇಲೆ ಬೇಕಾ?
Photo my lord in my favor my lord. Those are photos my lord. I have left my lord. I have not constructed what is my lord as per the.
ಇವಾಗ ನಿಮ್ಮ ಮನೆ white color
White color. ಹಿಂದ್ಗಡೆ ಬಿಟ್ಟಿದ್ದೀನಿ ನಾನು portion. BWSSB has used the most portion of my property my lord. ಅಲ್ಲಿ ಮ್ಯಾನುವಲ್ ಇದೆ, ಲೈನ್ಸ್ ಹೋಗಿದೆ BWSSB.
We understand. At least we'll try to understand on human basis ಏನೋ ಸ್ವಲ್ಪ ಇಲ್ಲೋ ಅಲ್ಲ violation ಅಲ್ಲ. ಹಿಂಗೆ violation ಮಾಡ್ತಾರೆ. 4 floors, no setback at all.
I kindly see the
Zero
next
setback.
and this my lord I have I could not build my lord on this year my lord because of this
That
manual.
doesn't mean you violated. That doesn't mean you violated. You have to take a plan sanction for that and do it. And if BWSSB has outed BWSSB, build a manual in your properties.
Yes,
It's not your property.
That's my property.
Manual ಹೆಂಗ್ ಬರುತ್ತೆ ನಿಮ್ property?
ನಾವು ಕಟ್ಟೋಕ್ಕಿಂತ ಮುಂಚೆನೆ ಅಲ್ಲಿ ಮ್ಯಾನುವಲ್ ಇತ್ತು, ಲೈನ್ಸ್ ಹ್ಯಾವ್ ಪಾಸ್ಡ್ my lord.
Revenue layout.
It seems my lord manual.
ನಿಮ್ಗೆ ಯಾರೋ ಮೋಸ ಮಾಡಿದ್ರು ಅಷ್ಟೇ. It is not
Further instruction my lord, if need be I will file objection my lord to the.
You take a plan sanction like this and build like that and the
1.65 ಫ್ರಂಟ್ ಇರಬೇಕಾಗಿತ್ತು, 1.20 ಇದೆ. ಹಿಂಭಾಗ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರು ಹಿಂಭಾಗ ಬಂದಿದ್ದಾರೆ, ನಂದು ಸ್ವಲ್ಪ ಮುಂದೆ ಹೋಗಿದೆ. ರೈಟ್ ಸೈಡ್ 0.35 ಇದೆ, 1.25 ಇರಬೇಕಾಗಿತ್ತು.
first and second. First and third ಮಾಡಿದ್ರ, just terrace ಮೇಲೆ ಮಾಡಿದ್ರ. One full floor is violation.
Instruction thought I will file my lord. Statement 3.
Instruction ನೀವು ತಗೊಂಡ್ಬೇಕಾದ್ರೆ ನೀವು ಡೆಮಾಲಿಷ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಅವರು ಡೆಮಾಲಿಷ್ ಮಾಡ್ತೀರಾ?
ನಾನು ಆಲ್ರೆಡಿ respond number 6 has filed a suit my lord, entered into a compromise and I.
That is your private this one. When it comes to our notice that there is a violation of a public law, there is a problem.
I will go through my lord what.
Go through ಮಾಡಿ.
One week.
Compared to seeing your plan sanction and comparing it with the photographs. Counsel for the petitioner seeks for and is granted 10 days time. File his objection, relist on 28.
Published.
Yeah. 38.
Which time?
ಏನಕ್ಕೆ? 38. At the request of the counsel for the petitioner, released on 3rd April.
39.
These are number 39 and 40. They are asking for the renewal of permissions under the old act and the old advertisement BBMP bylaws to.
Is it now posted all those advertisement matters?
20.
The H. Jevendrappa has entered appearance for respondent number 128, delete IG Gachinmat as that appearance for 128. 39 and 40. Connect to each other and WP number. And relist on 28.3.
41. Narendra Devi, go down.
41.
Appear for the petition. There was an advertisement by the respondent for disposal of the sites. The petitioner also one of the applicants. And the second respondent was also one of the applicants. The site was annexure 11, my lord, page 11, serial number 42.
Annexure 11, serial number 42.
Sorry, annexure here, sorry, madam. Page 11.
Page 11.
Serial
number. Yes. Page 11.
Serial number 42, my lord.
42.
Was reserved for Samudaya Bhavana or Saikshanika or Kendra.
Belewadi survey number 333, 336, 337. Tyagi. Yes. Yes.
Measurements, my lord, 1500 square meters. Next call. 1500 square meters.
Meter. Column 7 is chadra meter. What to Guttige? 2100 is the Dara per square meter.
1500 square meter.
This one is column 6 is the measurement.
Yes, my lord.
Not 1500. Column 6 is
square meter.
84.5 into 35.5 by 2.
Measurement.
Measurement.
Measurement. Total, my lord, it comes to 1500 square meters.
Per square meter, 1500.
No, total, the measurement of this measurement comes to 1500 square meters.
The next column is lease rent.
Lease rent.
And then 2100.
Yes, yes.
Yes.
Then, my lord, I made an application as per annexure B, claiming for Samudaya Bhavana as per annexure B, my lord. Page 13.
Page 13.
Page 13. Samudaya Bhavana. 5th serial number. Then the annexure C, my lord, the second respondent mentioned at page 17 as against Uttesha purpose, Samudaya Bhavana or Saikshanika or Arogya Kendra. He mentioned all. But the committee which was constituted to scrutiny the paper at page 22 recommended second respondent. Infant Jesus Catholic Center. While recommending whether the comparative merits and the purpose has not been considered at all. Simply, they have recommended. Recommendation is at the last portion. ಪರಿಶೀಲಿಸಿ infant Jesus Catholic Center ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಕೊನೆಯಲ್ಲಿ the comparative merits of these applicants has not been considered at all. Then, my lord, as per annexure,
what is your name?
Okkaligara Ksema Abhiruddhi Sangha.
ನೀವೆಲ್ಲಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಎಲ್ಲ ಯಾರ್ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಅದು ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲಿ.
ನಿಮ್ಮ ಹೆಸರು ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಇಟ್ ಈಸ್ ಅಟ್ ಮೈಲಾಡ್ ಕೆಳಗಡೆಯಿಂದ 1, 2, 3ನೇ ಪೇಜ್ 22 ನಲ್ಲಿ ಕೆಳಗಡೆಯಿಂದ 3ನೇ. While considering my lord, Rashmi, kindly see come to column number. The Varshika Varadi, under the Varshika Varadi, my lord, as against the second respondent, Varshika Varadi, 2012-13 ಸಲ್ಲಿಸಿಲ್ಲ, 13-14 ಸಲ್ಲಿಸಿಲ್ಲ, 14-15 ಸಲ್ಲಿಸಿಲ್ಲ, 15-16 ಸಲ್ಲಿಸಿಲ್ಲ, 16-17 ಸಲ್ಲಿಸಿಲ್ಲ. But insofar as my application is concerned, my lord, I have produced all the documents and also produced all the books of accounts, the financial status also.
ಆರ್ಥಿಕ ಸಮರ್ಥ್ಯ ಎಲ್ಲಿಂದ ಬಂತಾಗಾದ್ರೆ? ಬ್ಯಾಂಕ್ ಖಾತೆ ಬಂತು.
ಬ್ಯಾಂಕ್ ಖಾತೆಯ ಇದರಿಂದ ತಹಲ್ವರೆಗೆ ಕನಿಷ್ಠ ಗರಿಷ್ಠ ಮೊತ್ತ ದಾಖಲಿಸುವುದು. ನೆಕ್ಸ್ಟ್ ಕಲಮ್ ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ವರದಿಯಂತೆ ನೆಟ್ವರ್ತ್ ಇದೆಲ್ಲ ಇವರು ಈ ಕಲಮ್ ವಾರ್ಷಿಕ ವರದಿನಲ್ಲಿ ದಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಆನ್ಯುವಲ್ ರಿಪೋರ್ಟ್ ಆಫ್ ದಟ್ ಸಂಘ.
The bank statement has been produced.
ಅದೂ ಸಲ್ಲಿಸಿಲ್ಲ ಅವರು. Sorry, it has been produced.
ಬ್ಯಾಂಕ್ ಖಾತೆಯಿಂದ ಅಂತ ಬಂದ್ರೆ they have produced those statements.
Yes, madam. The account, but the annual report ಸಲ್ಲಿಸಿಲ್ಲ. It is one of the requirements.
Annual report ಅಂದ್ರೆ ಇದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಅಂತ ಇಲ್ಲ.
ಅಲ್ಲ, ಸಂಘಕ್ಕೆ ವರ್ಷ ವಾರ್ಷಿಕ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಆದಾಗ ಅಪ್ರೂವಲ್ ತಗೊಳ್ಬೇಕಲ್ಲ.
ಫೈನಲೈಸ್ಡ್ ಆಡಿಟ್.
So here, my lord, straight away recommended the name of the second respondent. My lord, as per Annex G, my lord, the second respondent, as it is, has accepted the recommendation made by the committee at page 34.
34.
Serial number 31.
Yes.
My lord, it has been considered for the purpose of education purposes, my lord. As per the Annexure E, my lord, in order to start an education institution, at page, my lord, I had produced Annexure E, my lord, a particular portion was listed. First, we kindly take the state of objection filed by the Muda at page 12, my lord.
Now, what do you want to say by referring to item 31?
31, my lord, the respondent, my lord, was supposed to again look into the merits of each applicant. That has not been taken into consideration. The recommendation made by the committee has been taken as it is.
Yes.
Why I am not eligible? Why they should be allowed? My lord, as per Annexure D, my lord, but they have produced, my lord, the corporation, the Muda has produced that Annexure E. ಅಲ್ಲಿ ಅವ್ರ ಸ್ಟೇಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ Annexure R3, page 12.
Yes.
Page 12. As per this rules, my lord, Karnataka Education Institutions Classification, Regulation and Prescription of Curricular Etc. Amendment 2018. Page 12, my lord, location, serial number 1. Extent of land, my lord, if any education institutions to be started, my lord, in BBMP and other municipal corporation areas, 2000 square meters is required. Page 12, my lord, of the statement of objection. Annexure R3.
Amendment to Rule 5.
Yes, my lord.
Table you are reading.
Table, sorry.
Yes, BBMP and others.
Education institution imparting primary to higher secondary education or primary to higher secondary education or pre-primary to secondary education. BBMP and other municipal corporation areas, 2000 square meters. The advertised area is 1,500 square meters. So they, if this education institution, it should not have been granted in favor of the second respondent.
Without even knowing what is the extent of the education. Because it's Samudaya Bhavana, Saikshnika and Arogya. So what is the classification? What is the division of that land for 3 years also not there. And even if it is not there, it can't be for education because it's lesser than the.
Yes. So therefore, the merits of each applicant has not been considered. It requires reconsideration in respect of this particular site.
Yes.
Services of senior counsel is on its way.
Argument ಆದ್ಮೇಲೆ ಅಲ್ರಿ submission ಮಾಡು first ಹೇಳ್ಬೇಕು.
From the case.
Passover. You have to explain us to Vivekananda. How to allot for all 3.
Relative merits of both the applicant has not been assessed, I should be fair to the court. But the application filed with second respondent has been considered for education purposes. Though they have indicated.
Who are you to consider after they indicate 3 things?
That's what Natsa.
You decide what they will do.
We should have indicated to them, you specify the purpose for which you are asking for allotment. That we have not done, Nats. Therefore, this matter may have to be reconsidered by the subcommittee, not is my submission.
Your reconsideration Kalsakunu, their application which says 3 things. Now after everything, they cannot now say I'll restrict it to A or B or C. C is anyway not possible.
Specific purpose should have been indicated in the application. And the scrutiny committee, either they should have asked them to indicate the specific purpose, or else they should have rejected the application itself in toto. But
Their
it has
application not have been, whoever has given all 3
yes,
should have been rejected. If they are given all 3 and then said 50% of the land I am going to use for Samudaya, 10% for Arogya and
that is
20% for this, and then you can consider.
Yes. But the looking into the dimension of the site, even all 3 cannot be accommodated. Even one purpose cannot be achieved.
Yes, the argument is this. One, you have indicated all 3.
Yes, sir.
Samudaya Bhavana,
Any one of
and Arogya. Insofar as Saikshnika is concerned, the minimum requirement is 2,000 square meters. The land measures only 1,500. So therefore, there is complete non-application of mind.
No, I'm sorry, that is not correct. Because I showed you a lot.
2, you will have to indicate. When the application is filed, you have to indicate one of the 3. Or if you have indicated 3, you should have said how much of the land will use for what.
The application was invited. Please see. Last may kindly come to page 10, madam.
Yes.
Page 10, item number 42. Please see this. Anyone, all the 3, this was reserved for 3 purpose. I have filed application for any one of the 3.
All 3.
All 3, anyone I can use it, not if it is granted.
So how do we evaluate you?
But evaluating is based on my capacity to establish any one of these things.
So what is the document that you have produced for Samudaya Bhavana, Shaikshamika and Arogya?
No, the question is this. Whether I have a capacity to do it or not is the only assessment. No, there are 3 aspects has to be considered while allotting under Rule 7. Whether I have a capacity. Secondly, whether I am having any disability to get this property. No, earlier also I have applied for Samudaya Bhavan. In 2013, that has been rejected.
Kind of applications, how can it be considered, Mr. Krishna? Give me the land. I want the land. I'll use it for whatever.
Not whatever. 3, they have specified 3 categories.
So what will you use this land for now? Will you use it for Samudaya Bhavan?
No, there are, please see, even for this, anyway, now they have decided to use it for Samudaya Bhavan only. But please see the restrictions import. Please come to
Page 13. Earlier, my lord, they are not applicant for earlier allotments. Now my application is page 17.
Yes.
And in this, of course, there is some confusion in this, but I have also produced my application that along with my statement of objection. I have filed any application along with the statement of objection. Lordship may kindly come to statement of objection filed by respondent number 2.
Yes.
At page 8. This is my application. My application Uddesha. Lordship got it? No?
Yes.
Uddesha ಮೂರಕ್ಕೂ ಇದೆ ಸಮುದಾಯ ಭವನ ಶೈಕ್ಷಣಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಅಂತ ಮೂರಕ್ಕೂ ಅಪ್ಲೈ ಮಾಡಿ. Anyone, my lord, I have. Then please come to page 8. Page 8 ನಲ್ಲಿ ಸಂಸ್ಥೆ ಈ ಹಿಂದೆ CA ನಿವೇಶನ ಕೋರಿ ಸಲ್ಲಿಸಲಾಗಿದ್ದ ಅರ್ಜಿಗಳ ವಿವರ ಹಾಗೂ ಪಾವತಿ. Then I have stated they have applied earlier, not granted. They have not applied. This is my second attempt. The earlier all they have not granted because that's non-available. Then please come to.
In that ಮಾಡ್ಬಿಟ್ಟು ನಂಗೆ ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಹೇಳಕ್ಕೆ.
ಅಲ್ಲ ಕೊಡ್ಲೇಬೇಕು ಅಂತಿಲ್ಲ, but the question is the earlier if it is not granted is one of the criteria to grant the CSH.
We want to know from your application.
Then please come to me. I will take your lordship only factual aspect. I will clarify. Then I will take your lordship the position of. Please come to page 9. That this is the allotment made. Please, the page 9, 13, item number 31. It was reserved, please see. ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡೋ ಆಯ್ಕೆ ಸಂಸ್ಥೆಗಳ ಪಟ್ಟಿ ಅಂತ ಬರೆದ್ರು. ಇದರಲ್ಲಿ ಮೂರಕ್ಕೂ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮಗೆ. ಸಮುದಾಯ ಭವನ anyone I can do it.
But exactly is the problem.
No, my question is I can use it. This is all ಸಮುದಾಯ ಭವನ ಶೈಕ್ಷಣಿಕ ಆರೋಗ್ಯ all as for charitable purpose only. I can use it for anyone. This is the order passed by them. Then my lord, I have also produced materials to show that I am running institutions and everything. I have produced all these materials. Taking into consideration of this, your lordship may kindly see the criteria. What they have done is at page ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಕಾಲಮ್ ನಲ್ಲಿ ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದ ಪರಿಶೀಲಿಸಿ ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಆಯ್ತು ಅಲ್ಲ, ದಿಸ್ ಇಸ್ ಆಲ್ ದೇ ಆರ್ ಹ್ಯಾವಿಂಗ್ ದಿ ಡೀಟೇಲ್ಸ್ ಆಫ್ ದಿಸ್ ಥಿಂಗ್ with them. Then even for them also same thing. They have not produced any other material. But this is what they have done. Please come to then the statement filed by the respondent number 2. Respondent number 1.
We have passed the detailed direction another matter. The CA site has to be considered for purpose of allocation. What are the criteria to be seen and how each one has.
7 says, rule 7 says, now please see how they have done it in this the annexure R1, they produced by the Mudam. They have filed the statement of objection also.
Yes.
At page 1, para 3. They say the CA site measuring 1,500 square meters. Admittedly 80,500 square meters.
Yes.
Then please come to page 2. ಇದರಲ್ಲಿ ಹೇಗೆ ಡಿಸಿಷನ್ ತಗೊಂಡಿದೆ ಅಂತ ಬರ್ತದೆ. This respondent, second line ಅಲ್ಲಿ, third line. This respondent has resolved to allot the CA sites in question in favor of respondent 2, taking note of the relative merit between the second respondent. Therefore, such the decision cannot be called in question. They have come.
The contention called out. These are the contentions of the petitioner. 1, 2, 3 are the contentions of the petitioner. Sorry.
No, sorry, not correct. Para 3 nalli, last may kindly see para 3. Starting. Contention ಅವರು ಹೇಳಿದ್ದಾರೆ.
But
further.
ನಿಮ್ಮ submission.
ಅಲ್ಲ.
Respondent is resolved to.
ಅವ್ರು ಹೇಳಿದ್ರು ಯಾಕೆ ಮಾಡಿದ್ರೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ನಾವು ಹೇಳಿದ್ದಲ್ಲ, ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
That can never be the contention of the petitioner. It will go against.
ಅವರಿಗೆ against ಆಗತ್ತೆ.
Writ petition dismiss.
It appears Muda is hiding that side. Anyway, it doesn't matter. But para 2, the page 2, last portion, this respondent has resolved to allot the CA site in question in favor of respondent number 2, taking note of the relative merit between the petitioner and the second respondent. Therefore, the said decision cannot be called in question in as much as there is no arbitrary exercise of power. Last may kindly see exercise of power on the part of the respondent. Then please come to para 4. Reason for allotting. It respectively submitted in respect of CA site in question, this respondent has received as many as 15 applications. Second respondent institution has been preferred application for allotment CA site in question on the ground that the said institution has a good financial position, having bank balance of rupees 9,44,000 and has sufficient net worth. In addition, it was also taken into consideration the fact of the second respondent having filed an application in the year 2013 and CA site having not been allotted was not allotted, the second negative. And one more factor which weighed in favor of the second respondent was that second respondent is the only applicant which is minority institution. Since no site has been allotted in favor of any minority institution, pursuant to the notification issued by this respondent, has thought it fit to allot CA site in question in favor of the second respondent, copy of sworn. Then please come to para 5 last sentence. This is they are contending this. The contention of this is that the establishment education institution, and this is what they are saying. Minimum area required is 2,000 square meters. However, in the present case, the dimension of the property is only 1,500 square meters. Therefore, CA site in question could not have been allotted. That is the contention. Their content. This is the answer. The notification relied upon by the petitioner at Annexure A does not disclose any such description of 2,000 square meters being the requirement of to establish an education system. Not Annexure A, what they have produced, petitioner has produced. This is only in respect of the payment of registration fees and other things. But anyway, Muda has produced a certain document. I will take your lordship through that document also. Please come to para 7, last sentence. Para 7, after Annexure 3, this is the amendment rules they have produced. I will take your lordship through the amendment rules later. Please see this, the factual aspect. According to the said rules, the minimum extent of land required for establishment of education institution of different class of standards is 2,000 square meters to 4,000 square meters. The CA site in question was earlier with the jurisdiction of the Belwadi Gram Panchayat and presently is with CMC Huttugalli. The aforesaid notification was not noticed at the time of consent. This is the justification. We have not noticed at the time of allotment. At the time of inviting application, there were no restrictions at all. There was no restriction. This notification is prospective in nature. I will take your lordship through that notification also. Please come to the notification issued, a rule is that Annexure R3, page 11. This has come into effect. Please see this. R3, page 11. But this is the Education Secretary notification, Bangalore 8/3/2018. Lordship got it? Yes. Please see the rules. They shall come into force from the date of their final publication, the official gazette. It was published on 8th March 2018. Then please come to this the rule, page 12. In page 12.
Yes.
Amendment amendment to 5 rule 5. This is what it says. 4. Every private body of persons every private body of person desiring to establish and maintain an educational institution imparting pre-primary, primary, secondary and higher secondary education or any part thereof shall own or have on lease for a minimum period of 30 years following minimum contiguous extent of land for the building and playground of education institution with permission from relevant authorities to use for educational purpose. Now please see the first one, category 1. It says, education institution imparting.
I understand all that. What is it that you want to use this land for?
No, we are using it for Samudaya Bhavan.
Which we don't gather from your application.
Pardon?
We don't gather that from your application.
My application is there. Please see this.
Samudaya Bhavan, stroke, Shaikshanika, stroke, Arogya.
Lordship may kindly see the application was invited for 3 categories. I have said anyone, I'm ready to, because if there is a restriction in another, I will stop this.
You have to be, you can't take that kind of a stand.
But the application itself is for that.
You can't take
Yes,
that.
please see this, Malad, please. Even otherwise also, even for education, please see in the next category, may please be seen.
We've seen that.
That is permissible.
ಅದಕ್ಕೆ ಇವಾಗ next question ಅಲ್ಲಿ ಬರೋದು, ನೀವು education ಅಂತ ಮಾಡಿದ್ರೆ, is it for higher secondary, is it secondary, is it for primary, is it for pre-primary? How do we gather from your application?
Now please see this. Education institution imparting, this is ultimately the education department. Suppose if I am incapable of carrying on that, definitely they will reject my application. And here,
and the whole
question
process,
is,
and the whole process goes based with the allotment of a civil community.
No, not. Please see this.
Education side, this is not a matter of right that you can get.
That is not the question. Is this? Please see this second one. Please see this.
Yes.
Education institution imparting only either primary and secondary education, or imparting secondary and higher education, BBMP and other municipal 1,500 square meters. I am
application primary education.
Education, not this. It is of course.
You are 1,500 ಹೋಗ್ಬಿಟ್ರೆ ಸಮುದಾಯ ಭವನ ಎಲ್ಲ ಹಾಕ್ತೀರಾ? ಆರೋಗ್ಯ ಎಲ್ಲ ಹಾಕ್ತೀರಾ?
ಸಮುದಾಯ ಭವನದಲ್ಲಿ ಅಲ್ಲ, anyone
when application is filed, comparative evaluation is to be made. It is to be known what you want to do for you to be compared.
Comparison.
ಸಮುದಾಯ ಭವನ clarity ಇದೆ ಅವ್ರದ್ದು. So they will be compared only for samudaya bhavana.
No, please see this. I'll
so ಅವ್ರಿಗೂ ನಿಮ್ಗೂ, if you had said education.
The case for exercising the power, judicial review is the permissible in these cases. I'll take your lordship from this.
Complete non-application of mind by the.
No, I'll take your lordship. Ultimately,
complete non-application. The entire process will have to be quashed.
Please see this. Education institution. Other municipal corporation, please see this. BBMP and other municipal, 1,500 square meters.
Give you 1 hour to go through this. But first you will have to answer us. From where can we get a reference in your application?
Application, please see this application.
Whichever point you are drawing.
Application will ಹೇಳಿದ್ದಾರೆ ಇವರು. ಸಮುದಾಯ ಭವನ ಶೈಕ್ಷಣಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ. ಮೂರರಲ್ಲಿ ಯಾವ್ದಕ್ಕಾದ್ರೂ ನಾವು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಿ. ನಮ್ ಕಂಪ್ಯಾರಿಟಿವ್ ಸಮುದಾಯ ಭವನ ಅಂತ ಕೇಳಿದ್ದಾರೆ. Namdralli, we are in a better position, therefore, anyone it can be permitted. Ultimately, it is for me to take a decision. If when they invited.
You go buy your land and then do it. Then it's your decision.
This is not a free allotment, it is also for cost.
But this is a civic community, not as a matter of right.
No, that it is not a matter of
land, you decide what you want to do.
Not a matter of right, but the question is, ultimately, whether the decision taken by the authority, now it has to be interfered with or not is the point for your lordship's consideration. That has to be looked into by your lordship. But please see this. I have stated these three things as and I have also given all the details, how I am, what are the nature of the institution I am running, and I have also given the buyer of my institution. I have given all the details, everything I have given. If your lordship wants me to specify which institution I am, that I don't have at present, I will make submission and
we can only look at your application. We can look at your application as in what date on which it was filed, not today what you are going to make a choice. Either they could make a choice for you, nor you can change.
They have taken a decision. I am entitled for this. I am entitled for. Please see.
Anything else?
But even in the rules also, there is no restrictions as such for 1,500 square meters.
You're not on that.
Then please see what is the decision taken by the committee. Committee has said this. We are giving it for education institution. Committee decision is for it.
Where does it say education?
It is there, sir. It is. Please see this.
Page 13.
Yes,
number 31.
Not that. Not that.
7 of the objection. Next R1, page number 7 of the.
So please come to page 20.
Page 7 is the application.
Please come to page
R1.
Annexure R, Annexure D, my lord, Annexure D, page 19. This was produced by the petitioner. Annexure CD. Annexure D page starts from 21. Yes, last time kindly take page 21. Annexure D. Annexure D page 21.
The repetition.
Page 20. How do you
Page
then
22.
22 ನಲ್ಲಿ last time kindly come to page 22. ಅದರಲ್ಲಿ ನಮಗೆ ಇವರು they have taken decision for granting ಶೈಕ್ಷಣಿಕ.
Page 22 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ page 22 ನಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ ಅರಿ ಕಷ್ಟ ಇದೆ ಓದೋದು ಕಷ್ಟ.
The name of the institution third column ಅದಾದ್ಮೇಲೆ
ಅಲ್ಲಿ ಮೇಲಿಂದ 1 2 3 4ನೇದು ಸಿಕ್ತಾ?
ಎಸ್.
ಅದರಲ್ಲಿ ಶೈಕ್ಷಣಿಕ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ನಾವು they have series. My application was for 3. They have taken a decision for Shaikshanika. While intimating you start anyone, all the 3 they have accepted. But ultimately, whether I am capable, whether it requires to be interfered with in this under these circumstances is my respectful submission. Please see the this is the position of as far as
capable of doing this and more, Mr. Krishnamurthy.
Please.
Not on your capability. You can probably establish a 1,000-bed hospital, or you may be able to establish a postgraduate university. We are not doubting your potential. May be able to establish an international convention center, Samudaya Bhavanalli. We are not on that. You have to choose when you made an application that this is what I want, so that there can be a comparative evaluation. You can't leave it blank to
the comparative evaluation. What I have stated is ಸಮುದಾಯ ಭವನ ಶೈಕ್ಷಣಿಕ ಇದು ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಸಮುದಾಯ ಭವನಕ್ಕೆ they are nothing has been produced. Lakshmi kindly see their application. ಅವ್ರು ಇದ್ರ ಪ್ರಕಾರ ಏನೂ ಇಲ್ಲ, ಬಾಡಿಗೆ ಮನೆ ಇದ್ರಲ್ಲಿ ಇದ್ದೇವೆ, ಅವ್ರ ಕೆಪಾಸಿಟಿ ಎಷ್ಟು ಅಂತ they are themselves have stated. So this authority, after looking into it, this is an institution, they are capable of establishing education institution, we are granting it for education. That is the decision.
So you are incapable of Samudaya Bhavana and Arogya.
Incapable alla, better. All the 3 when we will give to
can't do that. So
may request to Lordship, there are 2 judgments I would like to bring it to Lordship's kind notice. Maybe pardon me because
Kodi.
certified copy shall I give the citation? Sorry because the
copy kodi. Ravi ಅವರು copy kodi ನಮ್ಗೆ
advocate ಅವರು ಏನು ಅವಕಾಶ ಇದೆ television.
ವಿವೇಕಾನಂದ ಅವರು ಕೊಡಿ, ರವಿ ಅವರು copy ಕೊಡಿ, ಇಲ್ಲೂ ಕೊಡಿ.
2019-10 SEC.
If you don't give copies to both and us, we won't look into it. We can't keep a judgment with you and read it.
Yeah.
It will be totally unfair.
Correct.
ಅವ್ರಿಗೂ ಕೊಡಬೇಕು, ಎಲ್ಲರಿಗೂ ಕಾಪಿ ಕೊಡದೆ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗ?
ಏನ್ ತರಲಿಲ್ಲ ಮಾಡ್ತೀನಿ.
Come back at 2:30 with copies. Aso.
Sorry, apology.
Copies kodi, ಅವ್ರಿಗೂ ಕೊಡಿ ಎಲ್ಲರೂ. Aso.
Krishna Samiti is representing the population of minority community in Havanje Grammar. This matter, my lord, here for Panchayat, my lord. Some documents are there, need to place it in record. But now they sought for amendment of one prayer, my lord. It's already amended. Already amended, and amended petition also filed, my lord. But the only thing is, the application now they sought, my lord. What happened is earlier round the application for construction of, my lord, Madarasa was rejected. Now they wanted to construct a mosque. Subsequent application, after lapse of 3 years, they filed. Now there was an endorsement at page 5.
The amendment carried out.
It was amendment was carried out. Amendment petition is also filed out. But now the chief is my lord, whether they want.
My humble submission is lordship, even otherwise, my subsequent prayer will not be considered because that clearly has stated that with the pendency of this application or this writ petition, the application was rejected. So the first prayer, which is in respect of the application, what he had given respect of Badarsa, that has to be considered. Kindly,
What is your submission, Mr. Thayer? Now, after carrying out the amendment, you don't want to insist on that prayer?
I am not, even my learned friend, the argument may be taken on record. At the most, if my first application will be considered, so then I will be entitled for the second application as well. But you kindly peruse the.
Thing is, my lord, the first application is for madrasa. Now they want to construct a mosque. The second.
What is the document that you want to place on record?
The applications, my lord.
Applications are there.
Difference between the madrasa and mosque, my lord, to show that. But if you want to, my lord, just stick on to the subsequent application, my lord. But that has to be considered independently because, my lord, it is separate cause of action.
Has an application been filed for a mosque?
Yes, my lord. Now,
for the same land.
Same land, my lord.
Same land,
same trust.
You make your submission. I will make submission after now. You make your submission.
Only thing is, my lord, same land, same area, everything is same. Earlier, my lord, the 2 rounds of litigation, my lord, their application was rejected. That is for madrasa.
What is that you want to place on record now?
The present application and earlier application and endorsement, my lord, which is not placed on record.
Are they not already on record?
It is not on record. I have seen, my lord, that is why, my lord, I am making submission.
Both the applications.
Shame, my lord.
All applications are there in the record, lord.
Show us where it.
First application is there on page number 33, lord. The application, page number 33, which was rejected on page rejection by the already page number 34. Lord. This is first step. Second application
is for madrasa.
Madrasa, lord. Kindly see the second application, which is there. I presented along with my amendment application.
In our application, only endorsement is there. You make submission, there is no difficulty. What is
Lordship, kindly see this. This is the implementing was given by the authority.
The application.
Lordship, application is already we had submitted based on that application.
Where is it on record, Mr. Thayer?
It is application is not. There is an endorsement given by the department. And I am considering there is no difficulty that what my learned friend saying. I am also accepting that there is no need to produce the document of the record.
So you don't want to insist on a mosque now?
But,
Is that your submission?
Yeah, we will for the sake of argument because my learned.
Not for the sake of argument, we are going to.
They have amended the prayer.
But yeah, we have amended the prayer. My learned friend contested. In spite of that, the amendment prayer was the amended application was allowed. That my learned friend not contested. They have.
Why he is asking for time is to place some document on record. You said they are already on record. We saw
Endorsement is there in the record. Endorsement is there in the record. There is no dispute of my submission or is in my learned friend submission. If there is any dispute in my learned friend, dispute between our submission, then these things will be recorded. Because my learned, now this first time they are coming before and they are making this submission. Last 4 occasions, every time they come and take an adjournment for one another reason. Let them give us this opportunity also. Date may fix, lordship. But kindly see the provision of law, lordship. For the time, lordship, from 2009, when community is suffering. 2009, the community is suffering because of the objection by a majority community, lordship. I am not worried about. I am worried about the trend, lordship. Kindly see the section 64 of Panchayat Raj Act, which clearly speaks about on what reason the application can be rejected.
When will you produce it, Mr. Shah?
In a week time.
Counsel for respond number 3 and 4. Seeks bond is granted 1 week's time.
Please.
To produce the second application submitted by the.
And some other documents. We'll place it everything on record.
The mock and certain other documents.
Entire file may be summoned, lordship.
The learned AGA is directed to secure the AGLR.
Counsel for the
Ashok Naik will have to.
I'm for the appellate authority.
Respond number 2.
So who is this one? Who is the file?
Respond number 3, lordship.
Respond number 3.
Respond number 3.
3.
He is so permitted. Respond number 3 is also direct secure the entire file pertaining to both the applications submitted by the petitioner.
Yes.
The Copies of any documents proposed to be relied on by respondent number 3 and 4 shall be furnished to the petitioner on or before 21st March 2023. Relist on 28th March.
Please. This may be, Lordship, some observation with that because it's a long pending matter.
No, we will place it on a field to the court, my lord.
In that days, no further adjournment may be required.
It is made clear that no further adjournment.
Earlier also it was mentioned, but every time they're coming with some new excuse to adjourn the matter.
Serial number 43, Sharat S. Gowda.
So Srinivas. The KN Srinivasa. They have to file an affidavit. They have filed an affidavit.
They have served a copy upon me, lords. That's the Town Municipal Council of Dodbalapuram was in need of land for expansion of bus stand. And that land originally belonged to one KV Venkatesh, but they entered into a registered exchange deed so that he
We'll pass on, let him come.
ABS Mullion and connected matter.
Oh, these are.
This is for final year. This application may not be received.
it may be.
So Manian, you are appearing for the petitioner in few matters.
3 of the matters.
You are appearing for petitioner in Sarvana. Number 10.
Yeah, society on the layout.
Where is he?
They are sailing with the petitioners.
The
Sarita.
she's
will be appearing.
she's appearing and she's the
Lord,
main,
Madam, ನಿಮ್ಮ ಹೆಸರು ಬರೀಬೇಕು ಐಪ್ಯಾಡ್ ಅಂದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
Please, my lord, I will.
ಗೊತ್ತಾಗಲ್ಲ ನಿಮ್ಮಲ್ಲಿ ಇದಿರೋ ಇಲ್ವಾ ಅಂತ.
I'm sorry, my lord, I will arrange it.
Sharat Gowda is there. Prashant Chandra is also appearing. You are appearing in 44.3 now, madam. No, Mr. Prashant Chandra will not be appearing.
No, my lord.
44.3. Sarita 44.3. Ms. Sarita Kulkarni has entered appearance for R1 to 3. Delete Prashant Chandra has that appearing for R1 to R3. R1, 4, 5, 6, 7. What is this notice not ordered in 8 to 10 in 44.2? 44.2.
Private party.
Who are 8 to 10? In 44.2.
8 to 10.
Other parties in the other.
It's in 44.3, 1810.
44.2, Nodi, 18102. You will be appearing for the next Sharat.
They are placed similar to 6 and 7, my lords.
Will you accept notice for that? 44.
Pushpalata, my lords, so far as Pushpalata is concerned. Similar to 6 to 7, my lords, I can.
44.2. Sharat is Gowda who has entered up for 6 and 7. Except notice for respond number 8 to 10 also, registry is that print his name as such. Right. 44.1, service is complete?
Complete.
Very nalake janali.
Complete.
Only BBMP is a party. Then Ms. Sarvana. Only person now missing is Sarvana. You can start. Please join us.
I refer to the facts in 44. 13945 of 2021.
13945
2021.
Yes.
It's an allotment of a residential site in a residential layout owned by a housing society. The housing society plot is known as the Remco BHEL House Building Cooperative Society Limited. This society, my lord, was formed for the purposes of acquiring lands and for the formation of sites. The benefit of the employees of the public sector undertaking BHEL in Bangalore. The petitioner before my lord is a former employee of BHEL and a member of that society. Society is arraigned as respondent number 9. They, as my learned friend says, supports the petitioner. The residential layout was conceptualized sometime in 1984, and lands were acquired in a village called Pattanagare, not too far from the BHEL unit on Mysore Road, from various landowners. My lord will note that the legal structuring of those acquisition documents were in the form of powers of attorney, agreement to sell, and affidavit. My lord will note that subsequently in 2012 in Suraj Lab's case was found not to be legal. In any case, Justice Ravindran there said it has to apply prospectively. Nevertheless, under these arrangements of 84-85, the 9th respondent proceeded to form the residential layout, having taken possession over 60 acres of land. The layout was formed. In 1987, the government of Karnataka came out with a policy of acquiring lands for the benefit of these housing societies or public sector companies. And for the benefit of these societies, including the 9th respondent, issued notifications under the Land Acquisition Act for the purposes of acquiring the very same lands over which the formation of the residential layout are already commenced. My lord, the understanding between the society and the landowners was this, that in the compensation awarded, if there is any difference between the amount paid already, the difference would be made good by the society. So it was eclipsed. The acquisition by private arrangement was eclipsed by the acquisition of the government of Karnataka in 1987.
Yes.
Now that was challenged in 1989.
Went up to the Supreme Court in HMT.
My lord, no, is aware of that. And by that time, in 1995, the Supreme Court upheld the judgment of the High Court, quashing all of these acquisitions as falling foul of the provisions of the Land Acquisition Act. Middlemen were involved in lobbying the government in acquiring land, and therefore it said public. But my lord, the private arrangements were not an issue before the court. The acquisition was an issue before the court, and the court rightly found that this is not the way the government should act. The private transactions of 84-85, it is our respectful submission, was intact. And in 1995, when the Supreme Court passed this judgment, I believe there were some interim orders in the interim. And in 95, when the appeals were dismissed, the society had already formed the layout as early as 1991. Houses were constructed by allottees, roads were formed, all infrastructure was in place. The lands had lost their character as agricultural land. It came within the jurisdiction of the municipal.
Was the land converted?
The land was not converted.
Was a plan sanction obtained?
There was a plan sanction obtained from the BDA.
Without conversion.
Without conversion, because, my lord, it happened in this sequence. As I rightly say, my lord, it was an acquisition by the government for the purposes of formation of the residential layout in 1987.
If the acquisition had gone through, there's no problem.
There was no problem.
But
In
since
the
the
context
acquisition
of
is,
not obtaining a plan, I mean, I stand, obviously, the law had to be followed. You had to apply for a
conversion at least.
absolutely. There's no doubt about it. But my lord, these are things which happened in the year 1984, 85, 87, resulting in the quashing of the acquisition in 1995. The reality of the situation, yes, the legalities, obviously, my lord, it will be tested. In 1995, when the Supreme Court dismissed the appeals, the layout was formed.
Yes.
I mean, this is the ground reality. Relying upon those agreements and also relying upon no layout sanction plan as is contemplated by law under the Karnataka Town and Country Planning Act. But there was a PDA approval of a layout plan in principle in the light of the acquisition. When the application was made by the society, the PDA had in principle sanctioned a layout plan. But that was not followed in view of the subsequent developments of quashing the acquisition. But nevertheless, the society went ahead and formed the layout in terms of that in principle plan. I don't want to revisit a situation of 87, but it did happen. It did happen. And my lord, may I make the submission, because this becomes relevant in the connected matter, including the common areas, the roads and the CA sites, etc., were transferred to the corporation. But these are facts which have happened over time. And my lord will see that the sites were assessed to tax by the municipality. And then it later came within the jurisdiction of the municipal corporation. Khatas were entered in the names of the allottees. Some of them had khatas standing in the municipal, they call it the city municipal council, the predecessor to the Bangalore City Corporation. And later on, the corporation took over, and some of the allottees have their khatas registered with the corporation. Others are still pursuing that transfer of kata in the records of the Bangalore City Corporation. Now, this is the situation as it existed. In the year 2000, my lord, since the appeal was dismissed by the Supreme Court in 95, and there was some kind of a cloud over the legality of the society itself. To clear the air, the society entered into agreements with all the landowners. They called it, on legal advice, they got a document executed called Declaration cum Ratification Deed. Now, what happens in this deed is, that is not the subject matter of interpretation here, that is obviously will be tested elsewhere in a civil court. In terms of the ratification deed, my lord, the landowners acknowledge the formation of the residential layout, acknowledge the judgment of the Supreme Court quashing the acquisition, but they reiterate the 84-85 agreements under which possession was parted with to the society and also the power of attorney. And they say that since the society has acted on those documents, dehorse the acquisition process, the landowners ratify all the sale deeds executed by the society in favor of its allottees on the basis of those documents.
Was the sale deed ever executed?
Yes, sale deed was executed in favor of the allottees.
But in favor of the society, was it executed?
Not in favor of society. We had a set of agreements, my lord, which it was in the form of those days, my lord is aware, that it was a device used by lawyers in respect of agricultural lands to have an avoid stamp duty and registration fee, which was faulted in Suraj Lamb's case in 2012.
Problem is that there is no conversion.
Conveyance happened relying on
No conveyance in favor of the society.
no conveyance in favor of the society. There was a power of attorney in favor of the society, and which was acted upon and conveyed in favor of its allottees.
So the conveyance is of unconverted land or agricultural land only.
There was no conversion at all. There was no conversion at all. It was, my lord, as I said, it happened in the light of those developments. And the 87 acquisition was challenged and pending resolution in the court until 1995. And it so happened that the layout was formed. This is the stark reality of the situation. I really can't say that this is not a case, my lord, then there is no issue at all in this matter if there was a conversion order. There are two issues here. There is no conversion order. And secondly, the kind of transactions which were deployed by the society and which were in vogue those days were found not correct by Honorable Justice Ravindran and Suraj Lam, but he said the judgment will apply prospectively. Now, my lord, this ratification in a way for the society and the allottees gave some semblance of legal title over the layout. Now, in the year 2004, certain vested interests, I would use the word vested interests, taking advantage of the Supreme Court setting aside or upholding the judgment of this court, quashing the acquisition, entered into transactions with the very same landowners, 2004 onwards, buying by way of purchase deeds, the survey numbers as though the lands are still agricultural lands. This is happening on one side. And one of them is prominent, who also has been a respondent in the connected writs, which I will be referring to. And the modus operandi was on the basis of the sale deeds obtained from the landowners in the year 2004, 6, 8, and even as recent as last year, they would then apply for conversion of lands which have come within the jurisdiction of the BBMP, as though they are still agricultural lands. And my lord, on the basis of the conversion order, they would create self-styled layout plans, not again approved by any statutory.
Also not approved.
What they would do is the existing layout and the existing sites, wherever the allottees have not constructed their homes,
Becomes a new layout.
a cluster, yes, a cluster of sites which are vacant. A layout plan is formed only for that cluster, and fancy number.
So you have to be thankful that who had constructed or not disturbed.
Yes. So now this happened, and then the corporation issued khatas for those imaginary numbers. And also, what happens is, to be frank, to be very clear on facts over here, let us say that the petitioner's site number is 491. Is this vacant? Is 490 is constructed? The person, also an employee of BH here, an allottee of 490, he has constructed his house, living there. He's got a khata from the corporation as 490. And then you have 491, petitioner's site. And then you have next to his site, 492, 493, and so on. Those who have constructed are living there. They have khatas in those numbers. So also
That's 492 and 93.
Yes. Now, what 492, 493, which is vacant, including 491, which is that of the petitioner, becomes fancy number 1, 2, 3 in the new khatas.
490 remains 490.
490 remains 490. So if my lord sees, the khatas will run 490, and suddenly it becomes 1, 2, 3, and then again it'll go on to 494, 495, 496. Now, I'm just bringing it to the notice in the light of the facts which has to be understood in this case. The vested interests who entered into this modus operandi.
When did this happen?
Well, this has been happening from 2010 onwards.
Are there criminal proceedings filed?
Sorry, my lord?
Are there criminal proceedings filed?
One of the one of the major private party involved in this is a known land grabber, and he's got a host of cases for land grabbing against him. He's a respondent.
Have any of you filed?
No, none of us have filed. None of us have filed.
Is there any investigation ordered?
Nothing at all. Nothing.
Yes.
Well, this is the factual background in which these things have happened, but this issue has been tested before this honorable court on 2 different occasions. Well, apart from following this modus operandi, the person involved appears to be a little politically influential. I'm saying this with authority because this court has so observed in one of its judgments. What he did was he influenced the officials of the corporation sometime in 10 and 2012, and he got an order issued by the commissioner of the BBMP revoking all the khatas standing in the name of the allottees, relying upon the judgment of the Supreme Court of 1995.
So 490 got revoked.
490 got 491. 491.
91 got revoked or 490 got revoked?
All of them got revoked.
90, 91, 93,
Yes,
everything got.
Yes, everything got revoked.
So now there's no 490, 1, 2, 3.
No. I'll just come to that. At that point in time, it was effaced from the records of the corporation. This was challenged by petitioners, certain allottees and the society on behalf of its allottees by way of a writ petition before this court. And this court struck down the order of revocation by the corporation. It rendered a finding that the act was mala fide. It also pointed out certain political former MLA, and I don't want to name anybody.
Are they parties then?
They were parties. They were parties.
Parties to this petition?
No, this is gone. I mean, that list has been resolved. So the khatas were restored back by an order dated, the date becomes very relevant. By an order dated 13th of February 2013, the khatas were restored.
Yes.
And my lord, in that writ petition, the statutory respondents, the corporation of the city of Bangalore, and the vested interests were all parties. Consequent to the judgment, my lord, applications have been made by allottees to have the khatas issued in their names from the corporation. Corporation has not responded. Contempt proceedings are pending against the corporation. In the meantime, my lord, the private respondents who were arraigned as party respondents in that writ petition, seeking quashment of the order revoking the khatas, they file an appeal before a division bench of this honorable court. That division bench judgment has come out and they have dismissed the appeal by the private respondents and has reiterated and confirmed the judgment of the learned single.
13/2013.
Yes. And now the private respondents, kindly mark, my lord, the statutory respondents will not prefer an appeal. And the statutory respondents, I might add, have not filed any objections in these petitions. My grievance, my lord sees the prayers, is against the statutory respondent on 3 counts. 1, you have not restored the khata consequent to the judgment of the
But if a contempt is
contempt is for penal action. Contempt is for penal action. I need to get a mandamus for my one. Number 2, the manner in which, despite an order of this court, they have gone ahead and issued khatas in respect of the survey numbers which were part of the layout, pursuant to that modus operandi of that layout plan self-servingly made by the private respondent, was again against in the teeth of the order of this honorable court. So we seek a cancellation of those khatas. Based on those khatas, my lord, building plans have been sanctioned in respect of those self-serving sites, numbered sites. In this court, in the writ proceeding, we have challenged the legalities of these actions. Parallelly, in a civil suit, my lord, armed with this khata and armed with muzzle power, pitted against a retired employee of BHEL, they have forcibly encroached into the site. Civil suits have been filed for an injunction against interference with peaceful possession. In the interim, my lord, there are many suits filed by many of the allottees. Some have secured interim orders, some have failed to secure interim orders. Appeals have been filed. Miscellaneous first appeals were filed before this court. Some appeals were allowed in favor of the allottees. Some appeals went against the allottees in favor of the private respondents. Both in their respective matters have appealed to the Honorable Supreme Court. The Supreme Court is seized of all of these matters, and the matter notice is issued. Supreme Court has ordered status quo in most of the matters. My lord, the petitioner before my lord is also before the Supreme Court in that matter. He failed to secure an interim order in the trial court. He failed to secure interim protection here. He approached the court right on time, even before the construction started. But unfortunately, he couldn't get an interim order on the lower pending disposal of the suit. And he was unfortunately not given protection here as well. Now he is in the Supreme.
They all bear injunction suits, not for declaration.
Fair injunctions. Based on possessory title, they relied heavily on the judgment of this court restoring the khatas, and they also relied heavily on the ratification deed. My lord, some of the suits have seen the end of the day, like they have resulted in decrease in favor of the allottees. And regular first appeals are pending before this court by the private respondents against those judgments. So this is the actual background as to how these matters have come.
Let's come to this matter. Who are the respondents here?
Now we'll see the first respondent, first, second, and third, fourth, fifth, are all statutory respondents.
Yes. 6 to 8.
6 to 8, my lord. 8 is the king, if I may use the word with due respect to the other side, kingpin behind entering to deals with the landowners. 5, 6, 7 are his purchasers of those imaginary sites. And they are the
6 and 7.
yes, 6 and 7. Sorry,
So
6 and 7.
8 form the layout. What?
8 formed the imaginary layout, which was formed by the society. He formed the layout on paper and superimposed the existing sites in his layout, gave imaginary numbers and sold it to 8, 6 and 7. My lord will kindly note, 8 was a respondent in the writ petition filed against the corporation for setting aside that order revoking the khatas. He supported the order of revocation and he suffered. And he has obtained a khata in his name, again, in the teeth of that order of the court. Subsequent to that order of the court of 13th February 2013, he's obtained a khata in his name. In respect.
And what happened to respondent number 9? Is now made.
It's a society, my lord.
Respondent number 9 is transposed as the second petitioner, my lords.
Yes. Yes.
So in the light of these facts, my lord, we have sought for the following reliefs. First,
And the BBMP has not filed objection.
no, they have not. I mean, my lord, with due respect, I have to make this statement, otherwise I will fail in my duty. The statutory respondent seems to be sailing with the private respondents.
Like the society is saying.
Like the society is sailing. Society, I have to admit, they are sailing with me. So this is the factual background in which these requests come up. Now, one of the arguments raised was, my lord, the connected matter is similar. That is, on behalf of another set of allottees.
18102.
Yes. My lord, in this matter, in the parallel civil proceedings, the trial court.
18102.
No, not this, sorry. Not this. In 261, my lord, is at 44.3.
261.
44.3 is these are 4 petitioners who advance a similar case as the petitioner in the first writ petition.
So firstly, you are asking for a khata to be issued in your name.
Yes.
Second, cancel the khatas which have been issued in
absolutely
name.
Yeah.
3, cancel the plan sanction which have been issued in
on the basis of the bogus khata.
And 4, to protect the civic amenities and open spaces.
That is the separate writ, my lord, where the society, we have relied upon the transfer deed in favor of the municipality.
In terms of the earlier plan sanction and relinquishment is what you're
So
saying.
I just want to bring out one aspect of it. I mean, that is
Your petition, Mr. Goda?
That's
7-1. Just to understand the.
Lords, I will just narrate the facts.
You are, no, we'll come back to you on the facts. What is your, to allot 100% all?
That is slightly different matter. Because there I say, since acquisition is quashed, BBMP has utilized to put up a BBMP office without resorting to acquisition proceedings. And that land belongs to the petitioner, therefore I am entitled for alternative equivalent land.
This, according to you, would be in the civic community site. Isn't it?
And while that writ petition is pending, they would go and acquire by force the common amenities, and therefore the writ petition from the society has been filed. Well, even while this is pending consideration.
These two are 4271 and
No, my lords.
Okay, that is
4271 is filed by the filed by me, my lords. Other three petitions, my lords, are all similar.
No.
Where they challenge.
No, they are not similar.
Except in 261.
Yes.
It is filed by Remco Society itself, contending that the.
Writ petition 18102.
I'm sorry, 18102.
1 minute. I'll explain my petition. Writ WP 18102.
Now we know your petition and we know generally where everybody is. Yes. So you can continue.
18102 is by the society against encroachment into the common amenities. Now, this was filed when their writ petition was already filed, and they had forcibly taken over the common amenities, including the water sump area and other places. So that has been challenged by the society.
So in none of these petitions, the BBMP has filed objections.
No.
Pawan?
Yes, I'm sorry. Let me stand corrected. They have filed objections.
In 18102, I have filed objections.
18102.
And also in there.
Also. In my written also they have filed objections.
And 18102. When did you file your objections, madam? Yes. We got
312.
we filed it on 3/12.
Please do.
They are in a catch-22 situation because
Not.
Yes, I want to make a note. In the connected writ by my learned friend, they also have filed, the state has filed, the corporation has filed its objection, and both objections are conflicting.
Conflict.
They are supporting them in my writ, and in the writ by him, the subject matter is the same. So the corporation has a lot to answer.
Yes.
My lords.
Yes, the sheriff.
About 6.
Should we come to you or should we hear Mr. Ravi Shankar before we come to you?
I'll just take another 5 minutes, Milords.
Because he is a petitioner. Let's finish the petitioners first. Yes, Mr. Ravi Shankar.
Lords, the acquisition having been quashed by the Honorable Supreme Court, the society entered into various agreements with the landowners, which is in the nature of ratification cum declaration deed. And into the ratification cum declaration deed itself, there was a reference to power of attorney being executed in favor of the society itself. If in case that is one of the secretary of the society. So if in case there is any dispute, we can proceed against the power of attorney holder and get it resolved. There are civil court decrees which were passed on the basis of the suits filed by the society or the allottees, and subsequently the landowners were made as the parties as represented by the power of attorney holder, and there was a compromise or a joint memo filed on the basis of which the decrees were passed. Now, one of the landowners alleging
you executed a compromise with yourself.
We executed a compromise with ourselves, with reference to the power of attorney, because this was a power which was specifically referred to as having been conferred in the ratification deed itself. Let's say, if we were just to indicate what is this ratification all about, it only says that we have entered into a transaction in the nature of sale way back in the year 84-85, where we have received the full consideration, and we received additional consideration again in the year 1990. And again, after 1992, there was one more final settlement agreement, because the first time the acquisition proceedings came to be quashed by this honorable court in 1991. 1992, there were fresh set of agreements executed between the society and all other landowners, where they said we will not disturb, because by 1992 we had formed the layout, distributed the sites to the members. Some of the beneficiaries were the landowners themselves, to whom the allotments had been made. So then 1992, then 95, the Supreme Court judgment came. 2000, milords, we entered into this declaration cum ratification. It only said that 84-85, we have received the full consideration. We have received additional consideration in 1990. We have received additional consideration in 1992 after the judgment. Now, what we intend to do is that since we have already taken the full consideration at different points of time from the society, society has formed the layout, which we have acknowledged in 1990, 1992, we have acknowledged. Therefore, we wanted to ensure that the benefit of the Supreme Court orders goes in favor of the society and its allottees, for the simple reason that the society has actually paid the entire consideration payable to this to the lands. Now, this declaration cum ratification deed and the decree was subject matter of contempt proceedings before the Honorable Supreme Court. One of the landowners went to the Supreme Court and said that the entering into an understanding of the nature of declaration cum ratification and the decree will be conflicting with the orders passed by the Honorable Supreme Court, where there was a direction to restore back the lands. We filed our objections, bringing it to the notice of the Supreme Court that in respect of each one of the lands, this is the manner in which we have sought to safeguard the interest of the allottees who have already either constructed or who are purchased the sites, khatas are standing in their names, etc. Supreme Court dismissed the contempt proceedings, saying that there is no case of contempt made out. That is a very specific orders which was passed by the Supreme Court. After these proceedings were concluded, we had absolutely no difficulty until one letter was generated from a then MLA, milords. He addressed this letter to the then Revenue Minister. Revenue Minister writes it on the letter that you take action. The Revenue Secretary, without there being any hearing, on 7/2/2006, I think, milords, he passes an order directing the corporation to cancel all the khatas, cancel all the plan sanctions, and then seek to demolish the buildings. He also writes a letter to the sub-registrar saying that cancel all the registration of the sites which are executed in favor of the allottees by the society. This was independently challenged before this honorable court. This honorable court had interfered with that matter and said this is an ex parte order, you could not have done this, and therefore remanded the matter to the secretary for fresh consideration after giving us a notice. Eventually, the secretary says that this is a lot of things is transpired between the date of quashing of acquisition and the date on which the nature of orders are passed. Therefore, I don't want to interfere. This is purely civil in nature. It is, as a matter of fact, pursuant to this order of the secretary which directed the corporation commissioner to cancel the khatas and to demolish the constructions or do whatever, that the proceedings were actually initiated by the corporation. Till then, the corporation, there was no difficulty. This was the triggering point for us. Till then, we had absolutely no difficulty. This is the Revenue Minister's letter, the Revenue Secretary's letter, and then entire thing bursts out. Then corporation starts issuing notices saying that, look, there is a direction by the secretary saying that you cancel all the khatas. I am cancelling all the khatas. Then there was an ex parte cancellation of khata which was challenged before this honorable court, which was pertaining to about 6 or 7 allottees only. They came before this honorable court. This Justice Ramon Reddy directed that you cannot just give some paper publication and say that you have cancelled khatas. You have to follow the procedure as contemplated 114A and then undertake this exercise. So then they issued individual notices to all the site owners. The earlier writ petition of before Justice Ramon Reddy was pertaining to only few allottees, 7 or 10 allottees. But when the matter went back, they issued notices to all the allottees and said that you please produce the documents because we intend to cancel the khata. We went before the authorities and said that our khatas were made way back in the year 96 by the then, that is the sanitary board. Thereafterwards, it was transferred in the name of Patnikere CMC, which later on was rechristened as Rajarajeshwari Nagar CMC. Subsequently, BBMP, because of the notion created under the provisions of the Municipal Corporations Act, my khata dates back to 1996. It cannot be recalled at this stage at under 114A. That was one of the contentions raised. Besides, we said that there are transactions between 1995 up to the date on which the khata cancellation took place, which I had indicated. It may be in the nature of contempt. It may be in the nature of a writ petition where the matter came to be remanded back. There were a couple of other matters where the landowners themselves came and sought for a mandamus, which writ petitions came to be dismissed. And there were civil suits which were filed in which decrees were passed. These were all several nature of transactions which had taken place. And it is in this interim, I'll have to point this out, that each one of the landowners have received additional consideration right from 1995 to 2002-2003, including allotment of sites.
Even they are not parties to any of these writ petitions.
They are all the parties in the earlier round of writ petition.
They are not parties in the present set of papers.
In the present set of writ petition, the persons who claim under these landowners after 2006, when they came into picture was when the revenue secretary writes a letter. That is when everybody gets triggered, saying that now the lands are virtually with the landowners. And from 2006 and onwards, virtually all the transactions have come into existence after 2002-2003, before which time ratification deed and the decrees had already been in place. So in the teeth of this ratification deed and the decrees, additional consideration having been paid up to 2002, they go to the landowners, get a sale deed executed in their favor, showing as though it is an agricultural land. I should also point out which the corporation is holding it back. Says in 2006 when these proceedings commenced, the then Joint Commissioner had conducted an inspection. He has clearly indicated that this entire extent of 57 acres is fully formed into a layout. How many roads are there, and what are the nature of constructions which is existing on this property? Water lines, sewerage lines, and then the electricity lines. Which are the places where there is this water tank? All these things were reflected by indicating that there were about 340 constructions which had come up as of 2006 itself. This was the state of affairs which the BBMP's records itself reflected, which was pursuant to a joint inspection conducted by the then Joint Commissioner. Despite all these things, once these private negotiators came in between, that is the persons who entered into transactions with the landowners, post 2002-2003, the problem started for the allottees. Till then, from 95 to 2006, I can say 2006 also, from 95 to 2006, we were in camaraderie. The landowners were also happy, we were also happy because we gave them additional consideration and sites. They took the sites, and it is between this period of 1995 and 2006, many constructions had come up, which is with the concurrence of the landowners themselves. Because we had paid consideration for them in addition to what was the full consideration paid in 85, in 1990 and in 1992. This is how we paid them the consideration. Notice when all these things transpired, then the corporation notwithstanding cancelled the khata. Then this first two batches of writ petitions were filed, one in 2010, another one is in 2012, because two sets of orders were passed cancelling the khatas. Notice a coordinate bench took the view that the Supreme Court order has spent itself, because Supreme Court's order has been resulted in an endorsement being issued to the landowners that the physical possession of the property has already been handed over. That is not a fact which is in question. So therefore that Supreme Court's order, and moreover the coordinate bench also took note of the fact that the contempt proceedings filed before the Supreme Court, after all these changes had taken place, endorsements were issued to the landowners saying that you are put back in possession of the property pursuant to the orders of the Supreme Court. And then there was ratification and the civil court decrees, both of which were taken into consideration by the coordinate bench and felt that it would not be proper for the revenue authorities to go into this question, and at any rate under 114A, they could not have interfered with the khata because 3 years had already lapsed, 114A was not available. And the proper course open is for the persons who have suffered the decree or the persons claiming under them to challenge the decree and then go back to the revenue authorities and seek for change of the khatas. That is substance of the orders passed by Justice Bopanna. That was challenged before the division bench. The division bench made only one observation, which is again subject matter of a clarification application, The division bench observed that this order is restricted only to the appellants. We said that appellants, in the sense, whatever observations was made by the division should be restricted to the lands which are owned by the appellants. But the appellants, that is the landowners before the division bench, are to contend that it should be applicable only to the petitioners before the learned single judge. That's a controversy which is at large before the division bench, which is yet to be resolved. Now, as things stands, with all these proceedings having taken place, there being a mandamus already issued by Justice Bopanna.
Division bench has passed its order.
Division bench, there is one clarification which application has been filed, which is still pending consideration. If your lords were to take internal page number 77, my lords, of the orders of the division bench.
Yes.
Lords, about 6 lines, 6 lines, my lords, from the top. Therefore, we hold that the aforesaid orders are quashed to the extent of the interest held by the appellants before us. So this is the matter where the appellants themselves have sought for clarification. We have opposed, saying that appellants cannot seek for restricting the orders of the learned single judge in respect of the lands not belonging to them. So that is the reason why we were permitted to file objections. The matter is still at large before the Honorable Division Bench, only so far as this sentence is concerned. All other things, the Division Bench confirms.
Are there any other lands apart from the declaration?
Yes, there is only one piece of property which is excluded from declaration and ratification deed. Only one piece of property. It's about 1 acre, 14 guntas or so, out of this total extent of 57 acres. Rest of the lands are subject matter of declaration cum ratification, as also the civil court decrees. But in respect of that remaining portion which I am speaking about, 1 acre, 14 guntas, there is an agreement which is executed in 1992, pursuant to which we have allotted them 4 sites to all the family members, which is the family of Mahalingappa, who are not the parties in the present petition. But so far as they are concerned, we have allotted them the sites after 1992.
Yes.
Now, the division bench, now what they did, they were bound under an order. If your lordships were to see that the quashing of the orders impugned, which is the cancellation of the khatas, should have naturally resulted in the restoration of the khatas in our favor. But they did not do it because, rightly or wrongly, there is no positive direction to that effect. But this should have been understood by the authorities and they should have carried it forward as though these orders never existed. That is the effect of certiorari issued by this honorable court. But they never restored the khatas. Khata number stands. Khata is not put into anybody's name. But what they did was they started duplicating. For a one property, if my extent is 57 acres, there are khatas in respect of this entire 57 acres as on today. Now, because of these intervening persons who are the subsequent purchasers, now there is another khata for another 30 acres of property. They have given PID numbers for our properties. Now they have created khata for another 30 acres. This is the dubious method which was adopted by the corporation in order to circumvent what is possibly the orders of this honorable court and the division bench. They created duplicate khatas, in the sense duplication of the khata numbers for the very same property, which cannot take place. So this is the exercise, which is under subject matter of challenge before this honorable court. Of course, Mr. Manian is on the legal front. Mr. Manian has already indicated, but what I wanted to submit in addition to what Mr. Manian has said is that 95 Supreme Court's order has already spent itself. Pursuant to this order, there is a reference in the ratification deed itself saying that the landowners have taken the money from the society, went back to the land acquisition officer, deposited the compensation, took the endorsement on the paper saying that we have been put in possession of the property. This is an acquiescence to the completion of the orders or the specific directions issued by the Honorable Supreme Court. What happens after 1995 in the nature of the ratification deed is an issue which should not have been gone into minutes by the corporation. But the difficulty for us is, as Mr. Manian said, this Mirle Vardraj, he is the kingpin. He is the biggest troublemonger. He starts in 2006 and this entire layout is rendered a turmoil. Now, I do not know how many sites he has encroached and then putting up constructions. Virtually, we are already fighting in the second generation of the allottees are gone. They're all retired employees. Some of them are dead. Their LRs have come on record. Some of them committed even suicide. Because whatever their savings were there, these are all working class people from the BHEL who had put in their hard-earned money in buying this site. Society made its efforts to the level best to ensure that the sites are safeguarded, notwithstanding. And one clarification I wanted to give was, in this case, there was no tripartite agreement as distinguished from HMT. But here only problem for us was that the approval of the government was given prior to the date on which the amendment was made to the Land Acquisition Act, which incorporated cooperative society within the definition of company. That is the only ground on which the acquisition has been quashed, not on any other ground.
No, that is quashed by the Supreme Court. It remains quashed.
Yes, it is quashed. I just wanted to say that it's not a case of fraud or something. Here is a case where society has entered into agreements with the landowners only. There is no tripartite agreement or a middleman. We have directly paid the compensation or the consideration in favor of the landowners. Every single rupee which has been paid is through the account payments. Now, even now after 1995 to 2006, whatever payments has been made is through account payments. They have accepted all the payments. Now, the effect of ratification, which I wanted to say, was there was a power of attorney executed by all the landowners in the year 84 or 85. This is between these periods that all the landowners had executed. Now, the power of attorney conferred certain powers, but I can say, my lords, that the power to execute the sale deed was not specifically there in that power of attorney. The ratification deed says that since we have already taken the full consideration, delivered possession to you in 1980, authorized you to form the layout and distribute the sites to the members, the power of attorney which we had given or the agency created, since you have acted to this extent, your execution of the sale deed in favor of the allottee stands ratified. This is the effect. Ratification does not require registration, my lords. This is the substance of the ratification which we have executed. But all the problems started only because of this Mirle Vardraj. He's got his own coterie, his wife, his brother-in-law. Then he brings in a couple of other people. So they are the only persons who have purchased all the properties, which are the vacant pieces of properties in and around this 57 acres of layout which has been formed by us. All the retired employees, I'm submitting notes that most of them have died. They have entered into second generation, and still we are litigating at the stage of khata as to whether khata should be in our names or not, despite the orders of this honorable court, the coordinate bench of this honorable court confirmed by the division bench, because BBMP feels it very comfortable to duplicate for the very same land another khata and give it in favor of the private respondents. So therefore, my lords, my respectful submission is that the manner in which the property register is required to be maintained under 114 is blatantly breached, and they have circumvented the orders passed by this honorable court. Upon quashing of the orders, the effect of certiorari is that the order which has been the subject matter of certiorari stands obliterated and things has to be put back in the same condition. That is the effect. But they don't want to do it. That is the substance, my lords, of the present writ petition.
Yes, we'll get back at 2:30.
Grateful, my lords.
Varun Kumar and Ms. Kulkarni, you have a lot of things to answer for.
Second list.
Second list?
Second number. Next week, 2 weeks time.
Inform ಮಾಡಿದಿರಾ?
Happy for the respondent number 3.
Serial number 2, Sri Chandrasekhar M has entered appearance. Respondent number 3. You accept notice for respondent number 2 also?
3 ಮಾತ್ರ.
ಇದರ ಮುಂಚೆ MS ಪ್ರಕಾಶ್ ಇದ್ರು.
3 ಮಾತ್ರ ಅರ್ಥೈಸ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರಿಗೆ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ? Please wait, we'll come back. 26 ಯಾವ ಲಿಸ್ಟ್? 26 Sri Prasanna VR, learned counsel for the petitioner, submit that during pendency of the above matter, the petitioner responds to this. The same is not opposed by the counsel for the respondent. The submission is accepted. Petition is dismissed. 7. Yes. 7 at the request of the counsel for the petition released on 3rd. Yes.
Serial number 15. I informed the others.
15.
Serial number 15.
ಯಾವ?
Serial number 15.
15.
ಅಲ್ಲ, ಇದಕ್ಕೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ.
15. ನೀವೆಲ್ಲಿದ್ದೀರಾ? 15 and 15. List 2, serial number 15. At the request of the counsel for the petitioner, relist on 3rd April. List 1, serial number 50 and 51. ಯಾವಾಗ ಬರುತ್ತೆ?
My lords, 51 I object, my lords. ಅದ್ರಲ್ಲಿ ಬರೀ ಟಾರ್ ಹಾಕಿ ಅಂತ ಕೇಳಿರೋದು. Consider my representation, my lords. It's a simple matter.
Objection on the way.
Number 46.
46 in it.
I appear for respond number 5, my lord, in that matter. Writ petition is not maintainable. 46. Writ petition is not maintainable because they can file an appeal before district court.
46 learned counsel, it's submitted to learned counsel for the petitioner is unwell. Relist on 28th March.
Serial number 29 in second list, my lord. I'm for respond number 1 and 2. I inform the petitioner. I request my kindly take.
29.
Please, my lord. I'm for respond 1 and 2. I inform the petitioner.
At the request of the counsel for respond number 1 and 2. Relist on 3rd April.
Serial number 30, respond number. Serial number 30, list 1.
30.
30.
List 1. List 1 or list 2 ಹಿಂದೆ ಮುಂದೆನೆ ಹೋಗ್ತಾ ಇದೆ. ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Serial number 47, my lord.
My lords, serial number 54, my lords. I believe, my lords, this property tax matter is started before the coordinate bench, in which the interim orders I mentioned, my lords, on Friday that I'll submit before your lordships. In fact, my lords, all these matters are pending before the coordinate bench as part-heard matters, the connected matters, my lords.
Yeah, number in it.
Connect, my lords, it is petition number 1.
ಅದು ಹೇಳ್ಬೇಕಲ್ಲ ಅಲ್ಲೇ before connect with
Writ petition number 14351 of 2021.
list on
Any day, my lords, tomorrow.
Is there a date?
There's no date, my lords, no date given for final hearing. In my matter, interim order. ಅಲ್ಲ interim order ಆಗಿಲ್ಲ, my matter, my lords.
Argument ಮಾಡಿದ್ರೆ ಆಗತ್ತೆ. ಇವಾಗ connect ಅಂದ್ರೆ connect.
It may have to be connected before that bench.
That is why we are connected.
I'll wait.
47, my lord. Pray for you.
47?
Inform government advocate, week's time.
Respond number 7 inform ಮಾಡಿದೀರಾ? Please don't do this.
See number 45.
ಇಲ್ಲಿಂದಾನೆ ಶುರು.
Sorry, see number 35, man.
35 of list.
Passed over matter. First matter, first list. And both of us.
Monday.
35. At the request of the councils, relist on 21st.
20th, man.
20th को reach आगा doubt.
Serial number 4.
List number 2, serial number?
ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರಿ ಸರ್, ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಒಂದು 2 weeks ಟೈಮ್ ಆಗುತ್ತೆ. ಓಲ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಲಾಗ ಇನ್ನೂ ಬಂದಿಲ್ಲ.
Please wait. Yes.
Serial number 48, my lords, in first list, my lords.
Yes.
My lords, needs weeks accommodation, my lords.
Municipal Council, Mysore, ಯಾರು?
R1 and R2.
Lords, it is third notes are not presented, my lords.
Election completed and Mr. Naveed.
Lords, I take instruction, my lords. Election, my lords, I have challenged the election itself, my lords.
Election petition, il barala.
Lords, with the liberty, my lords, it can be. My lords, I'll take an instruction, my lords, kindly push it next week, my lords.
No need, you get the instruction by afternoon. We'll reserve liberty and dispose it.
My lords, today, my lords, I got an appointment, my lords. That is the reason, my lords, I am not physically present before you.
Ask one of your colleagues to make the submission.
Lords.
Why should it get listed only for that? If
Lords.
there's something we have given you time.
Lords.
Serial number 2, sir. Second list. ಏನಾರು ಹುಷಾರಿಲ್ಲ.
Serial number?
2, second.
Inform ಮಾಡಿದೀರಾ ಎಲ್ಲರಿಗೂ?
ಮಾರ್ನಿಂಗ್ ಇನ್ಫಾರ್ಮ್ ಆಯ್ತು. ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡ್.
ಇವಾಗ ತಾನೇ ಚಂದ್ರಶೇಖರ್ ಅಪಿಯರ್ ಆಗ್ತೀನಿ, ಅಪಿಯರ್ ಆಗಲ್ಲ ಅಂತ. Please don't mention again the same matter when it is refused.
50 ಏನಿದೆ? 50 ಇದೆಯಾ? ಅರ್ಜನ್ ಆಗಿದೆ.
ಮೇಡಮ್ 34 34
ಸರ್ ಎಷ್ಟು 29 ಯಾವ ಡೇಟ್ ಕೊಟ್ರು ಕೇಳಿ? 29 ಮೇಡಮ್ ಬರ್ಕೊಂಡ್ರು.
ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಆಕ್ಚುಲಿ ಅದು ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ. ಫೈಲ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಫೈಲ್ ನನ್ನ ಫೈಲ್ ಅಲ್ಲಿ ಆಫೀಸ್ ಕಾಪಿಯಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಎಲ್ಲ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಒಂಚೂರು ಅಡ್ರೆಸ್ ಬರ್ಕೊಂಡು ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಫ್ರಂಟ್ ಬರೀ ನೋಟಿಸ್
ಯಾವಾಗ್ಲೇ ಕೇಳ್ಬೇಕು.
ಬಿಸಿ ಇರ್ತಾರಲ್ಲ ಬೆಳಿಗ್ಗೆನೆ 22.
ಇವಾಗ ಕರೆಕ್ಟ್ ಆಗಿದ್ ಮಾಡ್ಲು ಅದೇನಾಗಿಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಯಾಕಂದ್ರೆ ತಿರ್ಗಾ ಮೈಸೂರಿಂದ ಬರ್ಬೇಕು ಸ್ಟೆಪ್ಸ್ ತಗೊಳಕ್ಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಏನಾಯ್ತು ಕೋರ್ಟ್ ಆಫೀಸರ್?
50 ಇದೆ ಮೇಡಮ್, ಅದು
ಇದೆಯಾ? ಓಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಏನಾದ್ರು ಅರ್ಜನ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸರ್, ಇದೆ ಅದು.
ಇದೆ ಅಲ್ಲ?
ಇದೆ.
ಮೇಡಮ್ ಇದು ಹಿಂಗೆ ಇಲ್ಲ,
ಆ ಲಿಸ್ಟ್ ಕಾಣೋ ತರ ಇಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಆಮೇಲೆ ಕೊಡ್ತೀನಿ, ಕಮ್ಮಿನೇ ಇದಾವೆ.
ಈಗ ಮಾಡಿದ ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ, ಬೆಳಿಗ್ಗೆ ತಾನೆ ಅಲ್ಲೇ ಒಳಗಡೆ ಟೋಟಲ್ 25 ಗೋಧಿ ಗೋಧಿ 28 ಟೋಟಲ್ ಲಾಸ್ಟ್ 20 ಟೋಟಲ್ Okay. Serial number one. What? Serial number 50. Serial number 50.
Lords, with kind permission, Lords.
Business Naveed.
Lords, serial number 48, Lords. Lords, with the liberty, Lords, to file election petition, it can be disposed of, Lords.
Only 7 days will be there, madam. Within 7 days, they have to file the election. The rule says.
Pardon with law. 48. Petitioner is before this court seeking for the following reviews. The Nityananda AGA submit that the elections have already been held. In view of the said submission, Shri Naveed Ahmed, the counsel for the petitioner, seeks liberty to file a election petition. Reserving such liberty, the petition stands disposed.
Public notes.
And permission. This is ready.
Taika.
Statement we have.
Hot copy then.
I will.
Okay, we'll get it posted in the Telegram group.
We also web post the same in our
Supposed to
KMA
ಮಾಡ್ತೀರಾ? ನಾವು ವೆಬ್ ಹೋಸ್ಟ್ ಮಾಡೋದು ಕಷ್ಟ. ನೀವು ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ. ಗುಡ್ ಎಫರ್ಟ್. ಇವಾಗ ಎಷ್ಟೋ ಟೈಮ್ ಸೇವ್ ಆಗುತ್ತೆ.
44.
I'll make my submissions in WP 13945 of 2020. That is the first
13945
of 2020. So it's about it's about 60 acres of land, my lords, in Pattangere village came to be notified for acquisition for the benefit of Demco BHL society under the provisions of land acquisition. But this was challenged on the ground that there was a report of GVK Rao committee report. That there are various fictitious persons created as membership, and the society had entered into agreements with the middleman as well as the landowners, so as to influence the state government to issue this 41 and 61 notification. This court noticed that these kind of agreements are opposed to public policy. Therefore, the notification based on these agreements which are opposed to public policy is having no public, and ultimately quashed the acquisition process. The judgment of our Honorable High Court is 1991, is of the year 1991. This is relevant because till 1991, my lords, not even a single sale deed was executed by the society in favor of the allotments. In spite of passing of the acquisition proceedings by this Honorable Court in the year 1991, the society goes on executing sale deed in favor of its allottees as if it had acquired the land under the acquisition. Lords, I have to make this statement. It is not executed on the basis of agreements or GPS or whatsoever. It is executed on the basis of the acquisition. Lords, 1995, your Lordship may kindly take the list of documents along with memo.
List of documents, when was it filed?
My lords, it was filed on 16/8/2021.
16/8/2021. Yes.
There are two set of documents filed on the very same date, my lords. May I request my lords to take the documents in which the first is the judgment of the Apex Court, ILR 1995 KR 1962 Supreme Court.
16/8 ಒಂದೇ ಇದೆ.
ಎರಡು list of documents.
On 26/6, the amended written state rate petition. The judgment in ILR 1990.
Yes. But this is the judgment of the Apex Court. Your Lordship, at the bottom of this judgment, will notice the date of the judgment, my lord. This is very relevant. This is 21st February 1995 is the judgment.
Yes.
Lord, so far as Remco Society is concerned, page 12, my lords.
Yes.
And paragraph 2, my lords. In the appeal number so and so, after the dismissal of the appeals, a direction has been given that as a result of the quashing of the land acquisition proceedings, including the notification in question, the possession of the land shall be restored to the respective landowners, irrespective of the fact whether they have challenged the acquisition of their lands or not. A further direction has been given that on restoration of the possession to the landowners, they shall refund the amounts received by them as compensation or otherwise in respect of their land. We issue a similar direction even in this case. The petitioner, respondents and the state government, including all authorities, persons shall implement the aforesaid direction at an.
Yes.
So irrespective of the fact whether the landowners have approached the court or not, this direction was given.
The entire acquisition is.
Entire acquisition is quashed, and direction was specifically to the state, authorities of the state, to the society also to restore the land in favor of the landowner.
Yes.
The only thing is the landowners had to redeposit the compensation. Now, my lords, this judgment is in 1995. But so far as this petition is concerned, your lordship will kindly take the petition. The sale deed of the petitioner, who is an allottee of the society, is dated 33/1996. Your lordship will get that in para 4 of their facts of the case in the petition of our minutes.
Yes.
And they refer to a resolution for formation of layout in 31/10/1988. That is even before the setting aside of the acquisition proceedings by this honorable court, by the division bench of this honorable court. 88 resolution. So what they have now is only a proposed layout plan which was prepared by the society, and there was some resolution before quashing of the acquisition proceedings. After that, there is nothing. And this CLD in favor of this petitioner is 33/1996. The judgment of the apex court is 21/1995. After the judgment of the apex court, there was nothing. The title as well as the possession got restored in favor of the landowners. The society could not have executed this CLD, but still it goes on and executes this CLD as if it has got title under the acquisition. Now, my lords, 2000, they said that in spite of this, there was some renegotiation and there was a ratification deed. My lords, this ratification deed is an unregistered.
Appearing for whom, Mr.
Lords, I am appearing on restoration of the land in favor of the landowner. The
You're
land,
appearing for the landowner.
yes, my lords, the landowners have sold the land.
This submission you cannot, you can make, but they won't be of any benefit or any value.
My lords, because my lords, I claim through the landowner. I am the purchaser from the landowners.
When?
Lords, in the year 2006, 2004, 2002.
After the declaration.
My lords, this ratification cum declaration deed, my lord, is an unregistered document, not due. Yes. And my lords, it's a fraudulent created concocted document. I say this because at the instance of landowner, there is a private complaint filed. They have sent this document to forensics. They have obtained, they have compared and said that these signatures are forged. Charge sheet is filed. That's not it. This entire document is a created document. Now, my lords, this document they have not brought to the notice of your lordship. They have themselves have produced that along with the production of additional documents. They have filed something called as production of additional documents.
When was that?
The date is missing in the copy which was supplied to me, my lords. In this, my lords, page number 148 of the document.
One?
48.
Yes.
The lordship will finally see the signatures of the landowner, valid signatures of the landowner is next to the name.
The 148 is document for 14. There are no signature. It is application registered.
Madam, it's put Ido. Lords, this document.
That is what it looks like. Petition memo, first document.
Compilation filed on 19/2/2022.
6631 suit. First document is the plain.
First document is the 6629 suit, my lord. In that, my lord.
631 is enough.
29 is an a different set problem.
6629 non document. Okay. Totally 148.
My lords, in this document number 51 anta madidare, page 148.
Document number 51, yes.
51, page 148. Lords, this is styled as declaration from ratification deed, and it is on a 100 rupees stamp paper. And the valid signatures of the landowners and thumb impression is next to their names. And if your lordship is kind enough to turn over the pages, your lordship will find this is an unregistered document. And if your lordship comes
to each page.
Huh?
Nothing on the bottom of each page.
Yes, this is exactly what I wanted. From page 6 onward, there is nothing on bottom of each page. This is as if they can insert anything and now one can produce before your lordship. And they said this is the document by which they got the title restored, in spite of the judgment of the apex court.
What is the criminal matter about?
About these signatures, my lords, the landowners said these are forged signatures. Therefore, they filed a private complaint under 468, alleging offense under section 468 of IPC. This document was sent for forensic. Forensic report is there. It said that these signatures are forged. Charge sheet is filed.
Yes.
Which is, then my lords, therefore, my lords, prima facie, this document cannot be a basis to say that the title, in spite of the judgment of the apex court, got restored in favor of the landowners in 2000. On top of that, my lords, your lordship may kindly take the list of documents which I was referring to earlier.
There seem to be a lot of issues here. Let us direct the state to conduct an inquiry into the matter and submit a report.
Lords.
Let us direct the state, not the BBMP. We won't go by what BBMP has filed as their objection. We won't go by.
The state has already, there is a state had already conducted an inquiry, and the law secretary of the state has already given a report. All these sale deeds executed by the society subsequent to quashing of the acquisition proceedings are declared as null and void.
What is the point of reference to the
point of reference, my lords, similarly, because this become a question of litigation under various writ proceedings. My lords, proceedings were initiated to demolish the unauthorized structures built by the allottees of the society because they claimed on the basis of the sale deeds. Then, my lord, the matter was referred by this honorable court for the law department, for the state, for us to give our documents, and also directed the society to submit their documents and directed the state to pass appropriate orders. We had sought for cancellation of all these sale deeds executed by the society because they are null and void in the eye of law. The law department of the state said they are null and void. There is no provision as such to cancel this.
We don't want law. We want an investigation by them into all the records, including the BBMP, sub-registrar, BBA, land acquisition, to give a complete chronological report on what has happened as regards these lands. Whether it is you as the private respondent, whether them as the petitioners or the BBMP.
Lords, strictly speaking, what has happened, Lords, there is no title with the allottees. But some of the allottees had put up construction without title. There, my lord, certain landowners or purchasers from the landowner, they have filed suit for possession. Some suits are decreed, possession is restored on the basis of the decree obtained in the possession suit. And in some cases, there is negotiations where we have negotiated with them and we have executed confirmation deed.
Well, Mr. Manian is telling us what is good for him. You are telling us what is good for you.
Lords,
we'll find out what exactly.
Lords, this is. Lords, I'm not.
It won't help.
Lords, I am admitting for a moment, my lords, few cases there are constructions and we have filed a suit for possession, and those possession suits are decreed, and few cases where there are negotiation, and few cases they are left as it is. No litigation is as of such, and the allottees have constructed. And wherever it was vacant, the landlords have converted the land from agriculture to non-agriculture purposes. They have sold it. On purchase, a private layout is formed. We have sold it to many prospective purchasers. They have taken their sites for valuable consideration. Khata is taken. The plan is taken. Sanction, building plan is taken. Sanction is obtained. They have put up construction.
Let us find out how to safeguard everybody's interest. So this is not the way that the society or you can also, you are the purchaser. But who is the one who formed the layout from whom you purchased?
Well, Lord, so respondent number 6 in the first petition.
Respondent number 6 is formed the layout.
In 13945.
Respondent number 6 is Leasing.
My lord, 13945.
Lata B. Singh.
Respondent number 8, my lord. I'm sorry.
Yes. He formed the layout.
In this particular survey number, there are various other persons placed similar to.
There are various other people.
Other persons who have purchased from the land lots, land owners.
Layouts.
Different layouts. Small layouts. Survey number 21, they're probably measuring 3 acres. They'll purchase entire 3 acres on the land getting converted.
We find out from them how the 3-acre layout was sanctioned by the BBMP, and by whom was it sanctioned?
Layout is not sanctioned, but land is converted from agriculture to.
So your layout is also not sanctioned. And what is the state doing? People are suffering. Everybody has a khata, everybody has a document. You are collecting your registration fee, stamp duty, everything you are collecting. How is the interest of a purchaser to be protected when you have multiple set of documents? ಐದು ಸೆಟ್ ಇದ್ದಾರೆ on the society to purchase it from the society, their legal representatives. Then this person with the landowners, we forgot that, landowners who have taken money all over the place. Then we have this layout for people who have formed the layout, from whom is a purchase. The same land.
Of the respondent himself, criminal proceedings are being initiated. Charge sheet is filed. He has produced an.
I want a complete report on this.
But so far as this first petition is concerned, my lords, yet this very petitioner, my lords, was a plaintiff in OS 6629. He files a suit for bare injunction, my lords. There he files an application under Order 13 and Rule 1 and 2 to restrain me from putting up construction. That came to be rejected, my lords, by the trial court. Aggrieved by that, he files a first appeal before this honorable court in MFA. MFA, my lords, all these things are noticed, and this honorable court confirms the order of the trial court, rejects granting temporary injunction.
In a few of them, and in few of them, it is granted.
No, my lords, this is only this survey and this petition is concerned. This very petitioner, that is the first petitioner, 13945 of 2021.
This is what Ms. Manian said, that he was not able to secure it. Get an order of injunction.
Please, my lords, he suppresses that, and this petition is filed after suffering before both the courts.
No, we are indicating that we would want an inquiry to be done.
Yes, I'm not on that. This petition, that is 13945 of 21, is filed subsequent to dismissal of his MFA.
Let all those facts come.
And my lords, as on today, my lords, we have put up our construction, because my lords, these things were brought to the notice of this honorable court. This honorable court directed us to put up construction. I mean, on our undertaking that we will not.
The whole issue has to be resolved one way or the other.
Please, my lords, it has to be resolved, my lords.
This is going on for the last 20 years. If we do piecemeal work like what you are suggesting now, this will go on for another 50 years.
They may find sufficient. None of the petitions landowners have been
Complete. That's why we want that investigation to be done. Each of them is saying what is convenient to them.
There are two.
Unfortunately, you have not done anything and filed something, nor has the BBMP looked into all the aspects and filed. Because they also don't want to file since there are serious allegations made against them.
Revenue secretary, I'm not having that paper which.
So who should we direct in this matter? Where? Revenue Secretary and Urban Development Department.
They have taken some action, but that is not the petitioner in the WP number 13945 of 21 review.
Action.
On that basis only the khata was restored, that is the argument.
That was the High Court order. So both the Revenue Secretary and the Urban Development Department, they'll have to nominate or constitute a task force for doing this.
There are many orders in it has went up to apex.
Lord,
Judicial was passed and the khata was restored on the basis of.
Ella ಬೇಕಾಗುತ್ತೆ. Otherwise, there are so many 57 acres, so many people. Civilly, the Sadhikya. It should not result in something else.
One document may request your lordship to kindly take note of, my lord. In the list of documents, the fourth document is this was done by the state. On this basis, the state, it will be helpful for the state to give a further report.
Not that document, they look into everything independently.
Because this exercise was done pursuant to the directions of this honorable court to give a report on these fields.
Heard Shri KVS Manipur Council for the petitioner and so and so. Shri D.R. Ravi Shankar, Lawrence Senior Counsel for petition number 2 in WP 13945 of 2021. Shri Sharad Gowda, Lawrence Counsel for respondent sponsor and petitioner and so on. Shri Pawan Kumar, Lawrence Counsel for BBMP, Ms. Sarita Kulkarni, Lawrence Counsel for BBMP. The litigations, the subject matter of this litigation is a property situated where is the property situated?
Pattangere village.
Pattangere village.
About 58 acres of land in various survey numbers of Pattangere village.
about 8 acres about land situated in various survey numbers in Patanjali village. The claim of the petitioners is that the Remco bracket DHL House Building Cooperative Society Limited has formed a layout, and the petitioner and several others have purchased sites in the said layout. Even though the acquisition was quashed by the Honorable Apex Court, by this court and the Honorable Apex Court, subsequently the landowners have confirmed the purchase made by the society, as also a sale made by a society in favor of various persons. The further contention of the petitioner is that thereafter, many of the purchasers have built their houses after obtaining necessary plan sanctions and have been making payment of taxes in respect to the said lot. Subsequently, in the year 2006, certain other persons wanting to take over the usurp the said land have created documents in conjunction and in conspiracy in conjunction with the landowners and obliterate the layout which has been formed, as also form new layout over small portion of the land, leaving out the construction which have happened, which has resulted in and that there is a conspiracy between the said person and the officers of BBMP, resulting in the cancellation of the khatas issued in favor of the purchasers. And thereafter, several litigations have accrued, including civil suits, writ petitions, etc. The contention of Sri Sharad Gowda, the contention of Sri D.R. Ravishankar, Council for the Society, is that the society has followed all the norms, created, formed a layout and sold it to its members. And that even post the decision of the Apex Court in HMT House Building Cooperative Society was Syed Qadir, reported in 1995 to SCC 677. The landowners having confirmed the actions taken by the society, the sales made in favor of the petitioner and other similar situated individuals is proper and correct. And therefore, he submit the case of the support the submission made by KBS Manu and submit that the writ petition could be allowed. The submission of Shri Sharad Gowda, who appears for a person who had formed the layout subsequently, as also purchasers of various sites in the year 2008 and onwards, is that the acquisition having been quashed, the declaration come confirmation which has been signed by landowner has not been signed by them. And that it's a forged and fabricated document as regards to criminal proceedings are already pending.
And it's an unregistered document.
Further submit the said document being unregistered one, it cannot, it was required to be registered in terms of Section 17 of the Indian Registration Act, and therefore does not confirm any title or interest on the petitioner, on the society or the petitioners or the purchasers. The submission of Sri Pawan Kumar is that the authorities have relied upon the document presented to it for the purpose of issuance of khata.
And the acquisition was cancelled.
More so taking into account that the acquisition had been quashed. Having heard the submissions, at this stage, I am of the opinion that there is a detailed inquiry which is required to be made by the concerned officers, a task force being appointed in relation thereto. The Chief Secretary, Government of Karnataka, Principal Secretary, Revenue Department, and Principal Secretary, Urban Development Department are directed to constitute a task force of such officers as may be necessary to inquire into this matter and submit a consolidated report. Some of the points which could be referred to said committee are: one, whether there were any agreements between the landowners and society. If so, what are the rights which have been confirmed thereon? Whether the layout has been sanctioned. If so, by whom and on what basis? If the property is assessed to tax and a khata number allotted or a PID number allotted, on what basis was a said allocation made and what documents were considered in that regard? Are there civic amenities and roads which have been formed? If so, with reference to which plan? And are they relinquished to the concerned authority? And if so, relinquished to which authority? What is the status of the civic amenities, roads, and open spaces which have been formed in the layout? And who is in possession of the same? The status of who is in possession. The documents which have been executed in respect of the said lands with copies there and the rights that they confer. The plan sanctions, if any, issued by whom and on what basis? What are the other things?
Or a claim has been made of.
Lordships, they contend that the layout is approved, my lord. Let BDA answer whether it is an approved layout.
BDA has issued an endorsement. In fact,
that is
It is not. That is the reason.
There is no contention regarding that. We have admitted the fact that it is, I mean, you don't have to raise an issue which we admit it is not there.
Anything else?
No, may I make the submission? This may not pose the question to us. A submission was made that they formed the layout on parts of land, which is absolutely false. They have created.
We don't know. That's why we are appointing.
That can be an issue. Who physically has formed the layout?
That's what. If there are any layouts formed by respondent number 8 and others in WT 13945 of 2021, on what basis and who has sanctioned the said layout? The location of the said layout with a superimposition of the layout said to have been formed by the cooperative society with that said to have been formed by private individuals. They're all individuals, right? Private developers, stroke individuals.
And with the direction of this court to issue khatas in our names, how do they issue khatas in respondent 68?
That will come about later. All of you have done shortcuts in this matter. No, nobody is clean. What to do with this is what we'll have to look at later. Either your vendor is clean, nor you are clean, nor they. There is a question.
The remedy of the allottees was with the society plots because
In case of need, all the parties will be directed.
The petitioner as also the other respondents are direct respondents, be it private individuals or statutory authorities, are directed to fully cooperate with the task force and provide such documents as the task force calls upon them to produce. If the sort documents are not available, to inform the task force about the non-availability.
May I make one submission? I'm not permissible. Two things. A judgment of a coordinate bench on the kata has already reached finality. So that has to be kept in mind when this exercise is done.
We'll see that.
One. Secondly,
we don't want legal opinion from them.
Absolutely. Absolutely.
That will decide.
Absolutely.
We just need the document.
I completely agree with the court. There is an interim order. My lord, I pray that it be extended.
That will be extended.
And one other thing is, let nothing be sanctioned until this is resolved by the court.
Property will be maintained in status.
Absolutely.
If there are any other points of reference, please give request to add it. If not today, tomorrow also is fine.
regarding the sale deeds executed by the society in spite of acquisition being quashed, as if they had title under the acquisition.
That we'll decide. That's a legal.
My lord, this is the society upon its allottees.
Legal issues.
Allottees remedy.
Those contentions will have to be left open and.
Legal issues we'll decide. We can't, they can't decide the legal issues. Is there any other
The interim order be extended.
actual aspects? Please let us know, all of you. When could this report be submitted? ma'am?
Coming election, I'm not able to
8 weeks will be.
election.
8 weeks ago.
But your start this you should not seek further adjournment in.
ನೀವು ಮತ್ತೆ ಬಂದು ಕೇಳ್ತೀರಾ ನಾವು ಕೊಡ್ತೀವಿ ಹಾಗೆ ಆಗುತ್ತೆ
ನಾನು ಇಟ್ಕೊಂಡ್ರೆ
ಅದು ಆದ್ರೇನು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. The report of the task force to be formed within a period of 1 week from the date of receipt of a copy of this order, and the report of the task force to be submitted within a period of 8 weeks thereafter. ಇನ್ನೊಂದು ವಾರ ಸಿಗ್ತದೆ.
Interim order may kindly be extended.
Interim order is extended. All the parties are directly keeping the property in status quo.
Lords, we have
Without any further
Ban sanction.
so as regards both the title of the property as also the character of the property.
Grateful. Very grateful.
We'll give you a
Obliged.
As far as the construction is concerned, my lords, because by way of a previous order of the honorable court, we are permitted to put up construction. In 13945, the construction is complete. In some other cases, we are in the midst of construction. Oh, my lords.
You place those documents on record.
Let it are already placed, my lords, and this honorable court had directed that this will
It
be.
is not there in any of the things.
No, it is there, my lord. It is there.
Which one?
It is there.
Which one? Show it to us.
In the order sheet, my lords, if you are lordship.
Those documents of order sheet of Torsik, ಯಾವುದ್ರಲ್ಲಿ order?
The order sheet, there is an order of this honorable court.
Which one? ಯಾವ matter ಅಲ್ಲಿ?
In all these three matters, my lord, it was argued and this was permitted.
Common order sheet.
May I clarify?
Let us see the order sheet.
In the meantime, I'm sorry.
Dated? Twenty-one two. 21 you won't claim equity. That is only as regards response 6 and 7.
Yes.
That is continued to other petitions also in the subsequent order.
So whoever, which is that order? Apart from you, nobody else can do.
Apart from me, sorry.
Apart from 6 and 7, extension ಯಾರಿಗಾಗಿದೆ ಅದು order?
That is extended to the writ petition in WP 18102 of 2021.
Date of the order?
Huh?
Supreme Court has subsequently ordered a status quo in that matter.
No, that is.
When it's Supreme Court, why should we pass a statement? Already.
Hello, this 18102 is the common amenity matter.
There is one more appeal pending before Supreme Court.
As regards to that khata, my lord's division bench order is challenged, taken in appeal.
As the contempt is pending, my lordship, visual bench of dishonorable performance. There is a XLP also pending before Supreme Court, filed by respondent number 8.
Okay, this is the order dated 5/9/22. These are the two orders.
In 10102, you're referring to. My lord, what actually happened was the first matter 3945 when we one minute.
I will just come to and continue.
One minute.
Lord, there is an order anyways, Lord, restraining us from alienating the properties. That is the latest order which was passed.
That's all right.
So far as construction, it was on our undertaking that affidavit that will not claim equity. We are permitted to put up construction. Anyways, my lord, there is an order that restraining us from creating third party. May continue, my lord.
Well, I'll just clarify. He's right. May I just clarify this? What house happened? A lot will see in 13945 of 2021. By the time we.
That is not required. What is this order? Only respond number 6 and 7. And who are the parties here? That's all.
In 13945, we are fine, my lord. What happened was when we came to court, that they had put up 2 floors in great hurry. And therefore, the court was of the opinion, since it had already come up by 2 floors, on an undertaking that they will not claim any equities, they will be permitted to construct. But then subsequently, they were restrained against creating third-party rights. We have no difficulty there. In 18102, when we came to court, they hadn't even put a brick. They got that order extended to this writ petition by misrepresenting to the court.
But we can't look into now.
We have filed an application. We have filed an application that this order was extended to this writ petition by misrepresentation, and that should not have happened.
In 139.
My lord will see the photo.
That is the case, my lord.
Kindly see.
Kindly see. Civil suit, they lost MLA.
On the slide, they got that order extended to a connected writ petition where not even a brick was laid. And on the cover of the order.
On the other end,
and these are civic amenity sites. A lot of public interest is involved. And the last thing we want is
what is it being constructed by respond number 5 to 10?
Hello?
5 to 10, what are they constructing?
They are constructing apartments, flats.
Now we will have one more set of apartment agreement holders and purchasers coming.
Because they have entered into GDA and constructing apartments. They will not alienate, my lord, they will keep it. But in the midst of construction.
They will not alienate, they will not mortgage. They will not encumber in the property in any manner. This court-wide order dated 21/2/2022 has permitted respond number 6 and 7 in WP 13945 of 2021 to continue the construction. But has also observed that they shall not claim any equity in the event of they are not succeeding in the writ petition. On 5/9/2022, this court had also permitted respond number 5 to 10 in WP 18102 of 21 to put up construction. By order dated 2/12/2022, the private parties have been prevented. Respond number 6 to 8 in WP 13945 of 2021 has been restrained from creating any third party interest. In my sensible opinion, the said order would also be applicable to the respondents, to the parties in other matters also. Thus, all the parties are restrained from, all the parties apart from the above mentioned respond number 6 to 8 in WP 13945 of 2021 and respond number 5 to 10. Thus, any construction put up by respond number 6 to 8 and 13945 of 2021 and respond number 5 to 10 in WP 18102 of 2021 shall be subject to the result of the present writ petition without the said respondents claiming any equity. All the respondents, all the parties are restrained from creating any third party interest, be it by way of sale, mortgage, or otherwise. Suffice it to say that no encumbrance can be created by any of the parties in respect of these properties. The official respondents are also directed to see to it that no third party interests are registered before any authority.
Look, last submission I want to make. So far as the common amenities matters is concerned, I quite understand that where constructions have begun, my lord has permitted them to go ahead. Let there be no fresh, because common amenities are in different areas. This should not be a shield. Start construction elsewhere. No fresh construction, my lord.
These are already orders which have been.
So far as the existing constructions are concerned, this order would permit them to encroach other CA sites where construction is not yet begun to start afresh.
You'll have to give us.
Let that be clarified, my lord.
An affidavit to be filed by respondent number 6 to 8 in WP so and so, respondent number 5 to 10 in WP so and so, detailing out the area where the construction is carried out by them within a period of
week.
1 week from today. Released on 21st March.
Very great.
They are actually constructing in respect of the plan and service. Sanction, plan and license which already sanction.
ಎಷ್ಟು plan without
Therefore, to say that we can put up construction everywhere, my lords, it is.
Serial number 56, daily presentation.
With regard to
Pass.
power of the authority in passing order under section 30 of the Cooperative Societies Act. The lordship directed me to get instructions with regard to whether the society is an assisted society or not. ERPS himself is present. He said that, well, at one point of time there was a loan that was shown in the audit report. That is why this order is for suitable orders. As on today, there is no assistance.
No assistance.
No assistance.
You're Barbeka. Pass.
Please.
Passport license. Number 30. Jeta Nair.
20.
Lord, I appear for petitioner. Unfortunately, arguing counsel has suffered from chill and fever, my lord. She has restored, doctor. So, kindly matter.
Morning you said arguing in another court.
Please. Suddenly she has suffered chill and fever. Matter may be taken up tomorrow, my lord.
Submitted that the counsel for the petitioner is unwell, released on 28th.
Great.
Serial number 34.
34.
Number respond number 10.
ಊಟ ಮಾಡಿದ್ದೀರಾ? ಜೋರಾಗಿ ಹೇಳಿ.
And for respond number 10 to 19, clear AV. 2 days accommodation. Senior is out of session, inconvenient to come. 2 days, only 2 days.
ಬೆಳಗ್ಗೆ ಬರಲೇ ಇಲ್ಲ ನೀವು.
So data is brought in.
Though the counsel for the petitioner and respond number 4 to 9 are ready to address arguments. Counsel for respond number 10 to 19 seeks for a short accommodation. Released on 28th March, it is made clear that no further adjournment will be granted. ಯಾರು ಕೇಳಬೇಡಿ. What happened?
That's business.
Please. ಎಷ್ಟು ವರ್ಷ ಕೊಡ್ತೀರಾ lease?
What section? 2 days time.
Lease ಎಷ್ಟು ವರ್ಷ ಕೊಡ್ತೀರಾ? What is the amount? Because they have lost the usage of the property for last 20 years.
40 years. 1979 is acquisition.
They have lost in usage more than Mr. Mahesh Chaudhary's age. So you'll have to, that old litigation.
Age also is sufficient. I can give it as much as my age also.
Counsel for the petitioner has filed a memo, stating that the petitioner in continuation until actually
That's because we filed an affidavit in the morning. So in continuation to make it a better.
That your stand is not clear. Again, you are creating problem for yourself.
That's me. My submission may be recorded now.
We are just taking, let him sub. It's filed an affidavit. Date illa ಏನilla. No
That's
signature.
inside. Inside.
ಬೆಳಗ್ಗೆ ಒಂದು affidavit ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. No signature.
That's we have raised it inside the presentation formula. Sorry. Justification.
File two of in the morning section and in the afternoon section. The same are taken on this. The DS Karthikeyan seeks for and is granted
A week's account.
10 days time to obtain instruction, make a submission, release for 28. How many years and what rate?
Please.
That's interim order.
Interim order earlier granted.
Serial number 41.
The paper notification.
We have to. Two minutes, you'll have to make one day. The paper publication issued by the Buddha. At page 10.
Yes.
It is in conformity with civic communities allotment rules. That is them under section 71 and 39. And under the rules, I will take your lordship rules little later. Please see page 10. But this is, there are several columns. In column number 4, Uddeshita antide. There actually they have to say Nigadita Uddesha anta, but in Uddeshita antide parvali. But please see each of the columns. And it is not only one. In some cases, they have given Saikshanika Arogya, Grantalaya, Anganwadi Shishuhara, Ige, Arogya Kendra Saikshanika, totally different. Several categories have been provided in this the notification. And in our notification, please see the next page, page 11. Page 11 item number serial number 40 may kindly.
40.
Samudaya Bhavana Matra. That means all the civic community sites, either formed by the BDA or by the private layout, they are making categories. These sites are provided for, some are reserved for different categories, some are reserved for specific purpose. In this particular case, in the example, in 40, that is, they have reserved only for Samudaya Bhavana. In 41, you will actually make kindly see different categories. 42 is 3 categories. 42 is 3 categories. Not in the, similarly, different types, not in the single category, 2 categories, 3 categories, bifurcated. Category wise, they have made it. Then please come to the last page of this.
What's your submission?
Huh?
What is the submission with regard?
Not this is just I want
so many categories are there.
The categories are there. Then this is, they have to follow the Karnataka Urban Development Allotment Site rules. This is the notification they have published. Then we filed an application. They filed application for Samudaya Bhavana. Though there are the 3 categories, they opted only 1 category. That is Samudaya Bhavana. As far as we are concerned, we have this is the slash means R. Either this or that or anyone, any one of the 3. That is our understanding.
To give me this, I'll do what?
I will like this is my submission plastic. Pardon. I have to make some submission in this.
He's already
just I will make it. I will complete it. The column number 5, Uddeshadalli, 3 categories is therefore the presupposes I can apply for, I can use this if it is allotted, I can use any one of these. I am supported by this. For this reason, you will actually may kindly come to the last notification, which was allotment notification at page 40, 29 was. Sorry, 30. This is 30 in this. In page 30.
Yes.
In this, my lord, the final allotment. Please see in this. First in the Saikshanika. In there also, my lord, allotment, the application was invited for Saikshanika. ಒಂದಕ್ಕೆ ಎರಡನೇದು ಆರೋಗ್ಯ ಕೇಂದ್ರ ಮೂರನೇ ನಡೀತಾವೆ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಶೈಕ್ಷಣಿಕ ವ್ಯಾಯಾಮ ಇಲ್ಲೆಲ್ಲೂ ಎಲ್ಲ ಕ್ಯಾಟಗರಿಗೂ ಅಲಾಟ್ ಮಾಡಿದೆ ಎಲ್ಲರಿಗೂ ಈಚ್ ಒನ್ ಆಫ್ ಅಲಾಟೆಡ್ ಇನ್ ದ ಸೇಮ್ ಟೈಪ್ anyone they can use it. That is the reason why my lord this category was made. And ours you will ask me kindly come to page 34. ಮೇಲೆ ನಿಗದಿತ ಉದ್ದೇಶ ಅಂತ ಇದೆ.
ಯಾವುದರಲ್ಲಿ if you see whatever is there.
Yes. ಇದು ಅಲಾಟ್.
First one is ಶಿಕ್ಷಣಕ್ಕೆ. Serial number 1.
Serial number 1. Serial number 1 ಇದಕ್ಕೆ ಶಿಕ್ಷಣ. Serial number 2 ಆಯ್ತು. Serial number 3 ನೋಡಿ ತಾವು ಅಲ್ಲ serial number 4 ಇಲ್ಲಿ ಈ ಆಗ್ಬೇಕದು 4 ಮಾಡ್ಬಿಟ್ಟಿದೆ 3 ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದೆ ಇರ್ಲಿ ಸಾಲ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಖಂಡಿತ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಶೈಕ್ಷಣಿಕ ಕೆಳಗಡೆ ನೋಡಿ 6 ವ್ಯಾಯಾಮ ಯೋಗ ಶಾಲೆ ಎಲ್ಲ ಬರೆದ್ರು then we just come to next hours category
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ 6 ರಿಜೆಕ್ಟ್ serial number 4 ಲಾಸ್ಟ್ ಆಯ್ತು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು
serial number 4 ಎಸ್ ಅಲ್ಲ ಹಂಚಿಕೆ ಮಾಡಲು ಅಲ್ಲ ಮೂರನೇ ಅಂದ್ರೆ ಕ್ರಮ ಸಂಖ್ಯೆ 3 ಅದು ಇದ್ರದ್ದು ಪ್ರಕಟಣೆ
ಅರ್ಹತೆ ಇರುವ ರಾಷ್ಟ್ರೀಯ ಇವ್ರಿಗೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಇನ್ನೊಬ್ರಿಗೆ ನೋಡ್ಬಿಟ್ಟು ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ
ಅದಕ್ಕೆ ಅಲ್ಲ ತೋರಿಸ್ತಾ ಇದೇ ರೀತಿ ಮಾಡಿದ್ದೆ ಪ್ಲೀಸ್ ಕಮ್ ಟು ಫಸ್ಟ್ ಪೇಜ್ 34 ಬಿಸಿ 34 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಮೇ ಖಂಡಿಸಿ ಆ ಸೀರಿಯಲ್ ನಂಬರ್ ಕ್ರಮ ಸಂಖ್ಯೆ 29 ಅನ್ನು 40ನೇದು ಪ್ರಕಟಣೆ ಸಂಖ್ಯೆ ಅದು ಸಮುದಾಯ ಭವನ ಒಂದೇ ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ದಿ category is also for ಸಮುದಾಯ ಭವನ allotment is also for ಸಮುದಾಯ ಭವನ similarly this allotment has been made then next one ನೋಡಿ ತಾವು ಇದಕ್ಕೆ 3-4 ಇದೆ ಇದೆಲ್ಲದಕ್ಕೂ ಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ ಸಾಮಾನ್ಯ ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು ನಮ್ದಕ್ಕೂ ಅಷ್ಟೇ 3 ಹೀಗೆ ಸಿಮಿಲರ್ಲಿ they have allotted whatever the category they have called. If I apply for that particular category, I can use it for anyone. Otherwise, there was no need of mentioning this.
If we accept whatever they do to be right, then we are not required to be here for this.
Not that, but otherwise, there is no reason for.
They have not done that.
Otherwise, the entire thing has to go.
It will go.
Not only mine. Please see this. They have called for application for allotment of civic community sites for hundreds of sites.
What is
and each
what is before us is what.
No, I'm sorry. That will be a that's why whether it is under these circumstances whether judicial review is permissible is my respectful information. So therefore, please see this. In each of the categories, alternative was provided, and they have opted for alternative sites, alternative purpose, and it was given. If
decision was taken,
suppose I am.
Did you opt saying that I'll do education? Now you are saying you want to do samudaya bhavana.
If it is granted to me, if it is permissible under law, I will go for an education. If it is prohibited, I will go for the samudaya bhavana or arogya kendra. Anyone I think I can opt. That is the reason why they made 3 categories. If the reason when one is impermissible under any of the provisional law, then I can go for another one. Otherwise, there was no need for making a category R. The word used, please see this, the flash, the slash is there. That means R, either this or that. This is my first submission. Therefore, I have opted for any one of these things. Now, even for Saikshanika also, it is permissible under the rules, but the education rules, for primary education, it is permissible. 1,500 square meter is permissible. And that rule has come into force much after the notification is issued, this notification. Therefore, if that is prohibited, I can go for samudaya. This is my first submission. Then Ulashi may kindly come to the rule. Urban Development Authority rules. Please come to Rule 7. The Karnataka Urban Development Allotment of civic community rules.
Yes.
The civic community is defined in section 2B, or sorry, rule 2B.
Yes.
2B, civic community site means a site earmarked for civic community in layout by the authority or site earmarked for civic community in a private layout approved by the authority and relinquished to it. Then please come to rule 3. This is how it has to be done. Offer of civic community site for allotment. The authority may, out of civic community sites available in any area, reserve such number of sites for purposes of providing civic community referred to in clause B of section 2 by central government, state government, corporation, or by a body established by the central government or the state government may require. 2. After making reservation under sub-rule 1, the authority may, subject to section 39 and general or special orders of the government, and having regard to the particular type of civic community required to be provided in any locality, offer such of remaining civic community sites for the purpose of allotment on lease basis to any institution, provided that the authority shall, while so offering remaining civic community sites, reserved 18% of this. This is for category, allotment of category and other things. The rule proviso, scheduled caste, scheduled tribe institutions, and sufficient number, etc. Reservation has to be made. 3. Due publicity shall be given in respect of civic community sites offered for leasing of institutions, specifying their location, number, etc. This is what then the disposal of sites. 4. Notwithstanding anything contained in these rules, the sites reserved under subsection 1 of rule 3 may be allotted to the categories. Last may see the words used. Allotted to the categories specified therein on lease basis by the authority for the purpose of providing civic community, subject to such terms and conditions as may be specified by it. So, the categories is mentioned in this particular the say they have made it is available for 3 categories. So I can opt for any one is my respective permission. Therefore, the rule is also clear to that effect. Then, Lashi may kindly come to rule 7. 6, other eligibility and other things that is not in dispute. The authority shall consider the case of each institution on its merits and shall have special regard to the following principles in making the selection. Then here, the first one is object and activities of the public institution, financial position. Please see this: financial position of the institution, present location of the institution, benefit likely to accrue to the general public for the locality of allotment of civic community site, the bona fide and genuineness of the institutions as made out in the annual report, editorial report, etc. The need of the civic community site by the institution for providing civic communities in question. For the purpose of sub-rule 1, authority may constitute a separate committee called a civic community allotment committee consisting of 3 officials and non-official members. The chairman of the authority shall be the chairman of the council. Then, subject to the approval of the authority, the decision of the civic community site allotment committee shall be final. Now, in this authority has, after looking into the there are about 10-12 applications were there, even according to them. Out of that, they have taken 2 considerations. One is according to the statement filed by them. The 2 things have been taken into consideration. Yes. Next one is allotment of whom are all then also please come to rule 10 also. Rule 10 also. Application, how it has to be filed, etc. Rule 10, conditions of allotment of civic community sites. Rule sub-rule 11 may kindly be seen. 10 sub-rule 11. Let's say shall exclusively use the site for providing the civic community for the purpose which it is allotted. Yes. Now, the reservation is 3, allotment is for 3, and I can use it for any one of the 3. Is my respective service. This rule is also very clear. Is my respective permission. Then, please see. Now the several. I have already shown the chart, and several institutions have been given an alternative option for them, either education or health, and the different purpose they have provided.
And as far as I am concerned, I was also treated like other institutions. I have placed in the same category. That is, I have been permitted to use for any one of the three categories. That is permissible as per the notification. Therefore, my lord, my respectful submission is, and the authority have also filed statement of objection saying that we have compared these two applications and several applications, and this institution is standing on better position, both on financial aspect and the other aspect also. Apart from that, it is a minority institution. Earlier they have applied, it was not given. Therefore, we are selecting this is the view taken by them. Such being the case, my respectful submission, it is not a case.
You argued all these things in the morning. Again,
No, such being the case, it is not a case for interference.
Some two citations ಅಷ್ಟೇ ಅಲ್ಲ ಹೇಳಿದ್ದು.
ಅಲ್ಲ, ಹೇಳ್ಬಿಡಿ.
ಮತ್ತೆ ಫುಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
ನಾನು ಹೇಳಿಲ್ಲ ಅಂತ ನಂಗೆ ಅನ್ಸಿತ್ತು.
ನಿಮ್ಗೆ ಗೊತ್ತು ಏನೋ ಹೇಳಿದಿಲ್ಲ ಅಂತ. Yes.
See, my first decision. This is the first decision is 2019, volume 10.
Yes.
CC. But this is a case where my municipal council has granted lease to the highest bidder. Several bidders were there, but highest bidder was accepted, and the highest bidder it was accepted by the committee. Then and two members of the committee has opposed for granting this. Then it was referred to the deputy commissioner and to the government. And when the matter was come back from the government, the collector has taken a decision. It is not in the interest of the institution for two reasons. One is the amount quoted comparing to the market price is less. Secondly, it has not been auctioned in accordance with the rules prescribed, because they should have taken local newspaper publications and provided opportunity to others, and nothing has been done. Therefore, though the committee has taken a decision to allot, I feel that it is not in the interest of the institution and also in the interest of the state, because revenue will go, because valuable property. Therefore, he has set aside the. That was challenged before the honorable division bench. That the honorable division bench said, I will not interfere in the. No, the division bench said you have no right, because he is the highest bidder. Whether value is less or not, that has been set aside. Again, that they approached the Honorable Supreme Court. The Honorable Supreme Court has held there are two things, how the judicial review has to be exercised. We see the two judgments that Tata Cellular case and the two judgments have been taken note of. That is West Bengal Central Special Institute and Tata Cellular. Two cases. I have given all the three judgments. Such may kindly say para 13 in this page 744.
1-3. Yes.
744. In the present case, the judges of the division bench have arrived at a finding that such a sanction was in fact granted. We will examine the correctness of the said finding of the fact at a subsequent stage. However, before doing that, we propose to examine the scope of the powers of the High Court of Judicial Review in administrative action. Though there are catena of judgments of this court on the said issue, the law laid down by this court in Tata Cellular versus Union of India laid down. These are the Tata Cellular case. These are the para 77 up to 81. This is only para 77 is extracted. Up to para 81 also I will take. The judgment also I have given. The duty of the court is to confine itself to the question of legality. Its concern should be whether the decision-making authority exceeded its powers, committed an error of law, committed a breach of rules of natural justice, reached a decision which no reasonable tribunal would have reached for, abused its powers. Therefore, it is not for the court to determine whether a particular policy or a particular decision taken in a fulfillment of that policy is fair. It is only the concern with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control by the judicial review can be classified as under illegality. This means the decision maker must understand
correctly the law that regulates his decision-making power and must give effect to it, irrationality, namely witnessary unreasonableness, procedural impropriety. The above are only the broad ground, but it does not rule out addition of further grounds in course of time. A matter of fact, in R versus so, the state of Karnataka, law deploy refers specifically to one development, namely the possible recognition of the principles of proportionality. In all these cases, the test to be adopted is that the court should consider whether something has gone wrong of the nature and this degree which requires its intervention. It could thus be seen that the scope of judicial review of an administrative action is very limited unless the court comes to the conclusion that the decision maker has not understood the law correctly, that regulates the decision making power, or when it is found that decision of the decision maker is vitiated by irrationality and that too on the principles of witnessary unreasonableness, or unless it is found that there has been procedural impropriety in a decision-making process. It would not be permissible for the High Court to interfere in the decision-making process. It is also equally well settled that it is not permissible for the court to examine the validity of the decision, but this court can examine only the correctness of decision-making process. Then, my lord, the next para 15, this judgment also I have given. This is the West Bengal Central School Service Commission versus Abdul Alim. In this case also, under what circumstances 226 can be exercised is the taken. That this is the judgment. That judgment also I have given. And para 16 may kindly be seen. Same thing, but this is the earlier judgment, Tata Cellular, all these things. Then 16. It could thus be said that an interference by the High Court would be warranted only when the decision impugned is vitiated by an apparent error of law. That is, when the error is apparent on the face of the record and is self-evident. The High Court would be empowered to exercise the powers when it finds that the decision impugned is so arbitrary and capricious that no reasonable person would have ever arrived at. It has been reiterated that the test is not what the court considers reasonable or unreasonable, but the decision which the court thinks that no reasonable person would have taken. Not only this, but such a decision must have led to manifest injustice. So therefore, my respectful submission, my lord, in this, there is no manifest injustice. There are three, even in para 21 also, but I will not trouble your lordship. The same thing is reproduced, relying upon the other judgment. Now, ultimately, the Honorable Supreme Court no doubt set aside on two grounds in this case. Order of the learned, the division bench has been set aside by the Honorable Supreme Court on two grounds. One is the state exchequer is affected by because the property is sold it for totally undervalued. One. Secondly, procedure prescribed under the Act and also rules. Rules was framed in that case also. Rule was framed under the Act statute. That rule is having the effect. Therefore, you are not follow the procedures prescribed under the rules. Therefore, we are setting it and demanded back the matter, reconsidered. Therefore, my respectful submission is the principle laid down in this case is very much applicable to this case because we have opted this and we are at it. One. And other two judgments, Tata Cellular case, just I will refer only paragraph, last may kindly
27. Already I'll refer my.
Para 81 77 ನೋಡಿ ಆಯ್ತು ತೋರಿಸಿ ಆಯ್ತು para please, para 81. Two other facets of irrationality may be mentioned.
it is open to the court to review the decision makers' evaluation of the facts. Court will intervene where the facts taken as a whole could not logically warrant the conclusion of decision maker if the weight of facts pointing to one course of action is overwhelming, then a decision the other way cannot be upheld. Thus, Emma Hotels Limited versus Secretary of State for Environment. The Secretary of the State referred to a number of factors which had led him to the conclusion that non-residents bar in a hotel was operated in such a way that the bar was not an incident of hotel. So this is on the fact. And now, this the Honorable Supreme Court in next para, the decision would be regarded as unreasonable if it is impartial and unequivocal in its operation as between different classes. On this basis, R versus Bernard London Borough. So the conditions imposed by the local authority prohibiting the participation of those affiliated with political parties to events to be held in the authorities' parks was struck down. But ultimately, in this matter, the Honorable Supreme Court in this case has considered many aspects, but the two things are required. One is whether any injustice has been caused. One. Secondly, the appreciation is contrary to the provisions of law and violation of principles of naturalization. And then, my lord, the other judgment referred is year 2019. After judgment, that is year 2019 Supreme Court, page 4504, West Bengal Central School Service. This para 28 and 29 and 30. And I will not trouble you also by reading 28 and 20. 30 may kindly be para 30. In the exercise of its power of judicial review, court is to see whether the decision impugned is vitiated by an apparent error of law. The test to determine whether the decision is vitiated by error apparent on the face of the record is whether the error is self-evident on the face of the word, or whether error requires examination or argument to establish it. If an error has to be established by a process of reasoning on points where there may be reasonably by two opinions, it cannot be said to be an error on the face of the record as held by this court in so-and-so case. If the provisions of the statutory rule is reasonably capable of two or more construction and one construction has been adopted, decision would not be open to interference by the writ court. It is only an obvious misinterpretation of relevant statutory provisions or ignorance of disregard thereof, or decision founded on reason which are clearly wrong in law, which can be corrected by the writ court by issuance of the writ of certiorari. Then please see 31 also. The sweep of power under Article 22 may be wide enough to quash unreasonable orders if the decision is so arbitrary and capricious that no reasonable person could have ever arrived at it. The same is liable to be struck down by the writ court. If the decision cannot reasonably be supported by the material on record, the same may be regarded as. Therefore, my respectful submission, this is not a case.
Insofar as my learned, page 34, which my learned friend referred to, that there is a reference to dictionary, page 34. There is reference to Samudaya Bhavana Saikshanika Artha Kendra. That is Melada. This is Nigadita Uddesha. This is as per the advertisement. So therefore, Melada, for what purpose it has been notified, it has been mentioned here. Well,
according to the statement of objection filed by the first respondent, their application has been considered for Saikshanika. Well, as per the notification, in an area which measures 1,500 square meters, the education institution cannot be opened. Even Malad, he should be clear for what classes he is opening. Suppose if he has made an application for the education purposes, from what classes to what classes. First, my kind is the notification. There is Malad, if he intended to start Annex D Malad, education institution imparting pre-primary to higher secondary education, or primary to higher secondary education, or pre-primary to secondary education, then the area required Malad 2,000 square meters. Then Malad, the education institution imparting only either primary and secondary education, or imparting secondary and higher secondary education, then Malad 1,500 square meters. Therefore, Malad, the application should have been specific as to in what classes he is going to commence. The application is very broad. Right? The application, as per the notification, Malad, he says Malad, Saikshanika or Samudaya or so and so. It is not very clear. Then, kindly see Rule 7. The relative merits of the application should have been considered. Here, Malad, the records produced by the state objection, Malad, it doesn't disclose, but the relative merits of each application has been considered. Here, Malad, suppose my learned friend is making submission, Malad, he may start Samudaya Bhavana. Then, if it is Samudaya Bhavana, then my application should have been considered along with his application regarding relative merits. Therefore, Malad, considering the application without going into the relative merits of each application is in violation of Rule 7 of the allotment rules. Then, insofar as Malad, kindly say, Malad, I have produced the education institutions which are there in the locality at page Annex F, Malad. There are page 28 of my writ petition, Annex F.
Yes.
There are 31 education institutions are there in and around this area, 28. And Samudaya Bhavana, Malad, only 3. So the judgment with my learner friend has there is no quarrel at all. Here, Malad, I am questioning the allotment in the second respondent on the ground of arbitrariness and violation of Rule 7 of the allotment of rules. The relative merits, Malad, of all the applicants has not been considered at all. Therefore, Malad, the allotment made in favor of the second respondent is liable to request, and let it reconsider, Malad, my application, this application, and other applications also in respect of this site concern.
Flagship project.
Replied.
Not this. If this court comes to the conclusion, but the rule, as far as the rule is concerned, education is permissible. I have already pointed out, page 2. Education 1,500 square meters is permissible. And our intention was to establish. If this ultimately, if it is impermissible, we establish Samudaya Bhavan. We are giving an undertaking before the honorable court. But ultimately, our application has been selected on merits.
Give me the land, I'll establish any of the 3.
Any one of the 3, we can do it.
Tell him submission. ಬೇಕಾದ್ರೆ ಆರೋಗ್ಯ ಕೇಂದ್ರನೂ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅದು ಇಲ್ಲ ಅಂತ.
Ultimately, they are.
The petitioner is before this court seeking for the foreign relief. The first respondent and Mysore Urban Development Authority had invited applications from registered societies bodies for disposal of civic community sites in various parts of Mysore city in pursuance of the in accordance with the Karnataka Urban Development Authorities allotment of civic community sites rules 1991. A public notification in the daily newspaper was published in this regard on 9/1/2018. One of the sites, there have been several sites which have been brought up for allotment. One of the sites was in survey number 333, 336 and 337, measuring 1,000 square meters at Belvedere. In the notification, It is stated that the said land could be allotted for the purpose of Samudaya Bhavana, education, stroke, arogya. That is to say, Samudaya Bhavana, Shaikshanika, stroke, arogya. That is, community hall, stroke, education, stroke, health center. The petitioner applied for the allotment of the opposite property for the purpose of Samudaya Bhavana stroke community hall. As respondent number 2 applied for the allotment of the said site for the purpose of putting up Samudaya Bhavana stroke Shaikshanika stroke Arogya. Okay, English. The respondent number 1, after receiving various applications which have been filed, which have been submitted in regard to this particular property, which number application 15 in number, allotted the said property to the second respondent. It is agreed by the same, the petitioner is before this court. The RS Ravi, that is senior counsel appearing to the petitioner, would submit that the allotment which has been made to the petitioner to second respondent is contrary to the applicable law, inasmuch as the application was made for all 3 categories without indicating any particular category for which the respondent number 2 wanted the property. An application for allotment of a civic community site on a lease basis ought to be specific in nature. The petitioner having submitted his application for Samudaya Bhavana and respondent number 2 having submitted for Samudaya Bhavana Shaikshanika Center. There are no comparative merits which have been taken into consideration by respondent number 1. In fact, a perusal of the main answer, what do you call the sheet? Annexure D, na?
Report of the subcommittee. Page 21.
The recommendation made by a subcommittee indicates that respondent number 2 has not even submitted his audit reports and annual reports for the purpose of such consideration. The application of respondent number 2 has been considered without any basis, and allotment is made for education purposes, even though the application is made for Samudaya Bhavana, Shaikshanika and Arogya. Thus, it is respondent number 1 who has decided the activities which are to be carried out, even though the application is submitted for 3 different aspects. He submits that there being no comparative evaluation of both the applications by the subcommittee, the decision of the subcommittee is required to be quashed, the petition be allowed, and the civic community allotted to the petitioner. The G. Krishnamurthy, learned senior counsel appearing for respondent number 2, would submit that the notification indicated the opposite 3 categories, and as such the petitioner made his application for all the 3 categories. The petitioner is willing, the respondent number 2 is willing to set up any of the three. That is to say, if the land is allotted to respondent number 2, respondent number 2 is willing to either establish a Samudaya Bhavana or a education facility or a health center. Respondent number 2 is capability and ability, has also competence to establish any of the three. And that is the reason why an application has been made in all three categories.
Like we have produced all the materials, they're all available. The committee says you are not produced, not correct. Records are available there, in their record. So balance sheet, all bank
statement is produced.
Bank statement is there. And audit report is there. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ನಿಮ್ಮ objection.
Objection ಎಲ್ಲ ಹಾಕಿಲ್ಲ, but ಇದರಲ್ಲಿ ನಮ್ಮ application ಅಲ್ಲಿ ಹಾಕಿದೆ ಹೌದು ಅಂತಿದೆ.
And you have put on notice about annexure D, you should file it along with your objection.
ರೆಕಾರ್ಡ್ನಲ್ಲಿ ನಮ್ಮ ಇದರಲ್ಲಿ ನಾವು ಎಲ್ಲ ಹಾಕಿದ್ದೇವೆ ಅಂತ ಬರ್ತಿದ್ದೇವೆ ಪೇಜ್ 18 ಹೌದು ಅಂತೆಲ್ಲ ಇದೆ ಅಮೌಂಟ್ ಎಲ್ಲ ಇದೆ.
The respondent number 2 being a minority institution and earlier applied for and failed in obtaining the lease of a civic community site, and this being the second time that an application was made, respondent number 1 has considered the said application and allotted the civic community to respondent number 2, and no fault could be found in regard there. He submits that the power of judicial review vested with this court is also circumscribed, inasmuch as it's not in all administrative decisions that this court ought to exercise its powers under Article 226 of the Constitution of India, but it is only when certain tests which have been laid down by the Honorable Apex Court are satisfied that such judicial review could be exercised. In this regard, he relies upon the decision of the Honorable Apex Court in 2019, 10 SCC 738, more particularly para 2, 13, 14, and 16 thereof, which are reproduced here under easy reference. 1994, 6 SCC 651, more particularly para 81 thereof. Year 2019, Supreme Court 4505, more particularly para 30 and 31 thereof. By relying upon the decision in Mahadev Real Estate case Supra, he submits that this court can only intercede when the decision impugned is initiated by an apparent error of law. That is, when the error is apparent on the face of the record and is self-evident. And the test is not as to what the court could think of it. That is, even if the court were to consider reasonable or unreasonable, the court cannot substitute its wisdom for the administrative action and decision. But the decision can only be questioned if it led to manifest injustice. By relying on Tata Cellular, it is contended that it is only when the test laid down therein, when legality is questioned, then the court could intercede. If not, it should not. And the point that could be taken into consideration in this regard is whether the decision-making authority exceeded its power, committed an error of law, breach of principles of natural justice, the decision which has been arrived at cannot be so arrived by any reasonable person. The abuse of the process of law. Even if a decision is impartial as regards unequals, it could be challenged. He therefore submits that the test laid down by the apex court in Tata Cellular have not been satisfied in the present case for this court to exercise the power of judicial review. By relying on Abdul Alim's case supra, he submits that what this court would essentially have to see is whether the decision impugned is vitiated by an apparent error of law. That test can be ascertained on the face of the decision and not on the basis of reasons or arguments advanced thereon. If the error is required to be reasoned, then it cannot be said to be an error apparent on the face of the decision. Thus, there being a possibility of two decisions being taken, an error being capable of determined only on the basis of reasons, the sweep of Article 226 does not envisage the exercise of powers of judicial review in such a situation. In the present case, there is nothing which is apparent on the face of record to indicate violation of the CUDA Allotment of Civic Community Site Rules 1991. All the provisions and requirements have been followed. The application filed by respondent number 2 being as per the notification which has been issued, the authority having considered the same, merely because this court could come to another decision, this court ought not to intercede in the matter. Insofar as the establishment of Samudaya Bhavana, community hall, education institution or health center, respondent number 2 is willing to establish any of the three as per the permission which may be granted by the concerned authority. And that respondent number 2 will establish that particular civic community only if permission is granted. Three, T.P. Vivekananda, learned counsel for respondent number 1 would submit that though the approval now has been granted for educational purposes, subsequently there has been a notification issued and subsequently there is amendment to the Karnataka Educational Institutions classification, regulation and prescription of curricula, etc. in the year 2018, in terms whereof for an education institution imparting pre-primary to higher secondary education or primary to higher secondary or pre-primary to secondary education, a minimum area of 2,000 square meters is required. And if an institution imparts only primary and secondary education or secondary and higher secondary education, 1,500 square meters is required.
So far as BBMP and other municipal corporation areas, 1,500. Other areas, not it is 3,000.
In the municipal corporation area,
it is not within the municipal corporation. It is outside the municipal corporation.
At the 2,000, it is outside the municipal.
It is beyond. Uttagaldi is city municipality. It is not municipal corporation. It is municipality.
Okay, then we will confine to. If that is the case, but I will give an undertaking. Will confine only to this.
Areas is 4,000 square meters. Primary and secondary education or imparting secondary and higher secondary education, minimum of 3,000 square meters is required. For educational institution imparting only primary education or secondary education or higher secondary education, a minimum area of 2,000 square meters is required. Unfortunately, this aspect was not considered.
Allah, consider madam, it has come into effect only on 8/3.
Whose submission?
Allah, sorry,
It's coupled with the zoning regulation which I have used, page number 9.
We are not saying yes or no to any of the
No,
subject.
I'm not, I'm just assisting.
Page number?
Page number 10 of the statement of objection. Just got it.
10 is,
Statement of objections filed by.
yes, yes.
Page 10, space standards for various buildings users, serial number 6 and 7.
When did this come in?
Page number 9, this has come into effect from 1 to 2016. It was gazetted on.
It is also subsequent. You are 2013.
No, the notification was called for in 2018. By that time, this zoning regulation was approved by the state. And
What was the date of this notification?
January
8th March 2018.
8th March 2018, date of the notification.
Allah, it has come into effect on the gazette date there.
And the allotment was made on?
The resolution of the board resolving to allot is 13th 2018.
So this came into force in 2016.
And the rules amendment, the rules connection are
8th March
2018.
It was there in force at the time it did this. Unfortunately, same was not taken into account while approving the decision of the, while approving the recommendation of the subcommittee and allotment of the civic community site for education purposes to respond number 2, by resolution dated 13/3/2018. We submit that this was to inadvertence. Even as per the development control regulations, for the purpose of establishing any educational institution, the area would have to be as that prescribed by the competent authority, which in this case would be in terms of the aforesaid rules. Without compliance thereof, the allotment could not have been made for education purposes. Third, R.S. Ravi, Shri J. Krishnamurthy, Learned Counsel for Respond number 2, Shri T. P. Vivekananda, Learned Counsel for Respond number 1. The short point that would arise for consideration in is whether this court size.
Notification all areas 7 nalli 2000 square feet ಸಾಕು ಅಂತ ಬರೀತಾರೆ. Page 12 ನಲ್ಲಿ.
Pre-primary
imparting only pre-education.
Pre-primary is only for fresh and play school.
The pre-primary.
Play school ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಕರೆ ಅಲ್ಲ ಹೇಳಿದ್ದು
play school ಮಾಡ್ತೀರಾ?
ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಆಗೋದಿಲ್ಲ ಅಂತ ನಾವು ಇದು ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ ಹಿಂಗೆ.
This court should
ವಾರ್ಡ್ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ ಅಂತ ಅಷ್ಟೇ. ಇದು ಅವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಇನ್ವೈಟ್ ಮಾಡಿದ್ದು ಮಚ್ ಪ್ರಯರ್ ಟು ಆಯ್ತಾ ಹೇಳಿದ್ದ.
This court ought to exercise its power of judicial review in the present matter. A civic community has been defined under Rule 2B of the aforesaid rules of 91 to mean a site earmarked for civic community in a layout formed by the authority or a site earmarked for civic community in a private layout approved by the authority and relinquished to it. A civic amenity is required to be formed in a particular layout or area so as to provide certain amenities which are required for the residents of that area. It is but required that the concerned planning authority takes into consideration the requirement of the area, requirement in that area, the availability of other amenities in that area, and plan the allocation of civic amenity sites to different kinds of amenities, so that all amenities are available to the citizens within a short distance. In the present case, when the notification was issued, it made it possible for an applicant. It denoted this particular civic amenity site to be capable of being used for a community hall, from an education institution or a health center. Thus, it had been open for any applicant to apply for any of the above categories. The petitioner applied for allotment of the site for establishment of a community hall. Whereas respondent number 2 applied for all three categories, namely community hall, education institution, and health center. The offer which has been made by respondent number 2 is in consonance with section rule 3 of the rules of 1991. Inasmuch as the offer is made of a particular type of civic amenity in the locality by way of necessary publication. In terms of sub-rule 7, in terms of rule 7, the principles of selection of institution for leasing out civic amenity sites have been provided, which reads as under. Essentially, what is required under Rule 7 is a comparative analysis to be made of each of the applicants so as to determine who is best suited to receive a lease of a civic amenity site and for what purpose. In the present case, respondent number 2, as aforestated, applied for community hall, education and health center, allegedly enclosing certain documents. Now, what was required was to firstly ascertain what is required by subcommittee to do was to ascertain firstly as to which of the with reference to all the applicants, as to which applicant and which purpose was more required in that particular civic amenity. Merely because a person were to approach the Urban Development Authority stating that he or it is willing to establish any of the civic amenity cannot do away with the requirement of a comparative analysis of the applicants. It was but required for the authority to consider the comparative merit of both the parties, or rather all the applicants, in respect of each of the three categories. And if it were to be considered with reference to the petitioner, the application of the respondent number 2 was to be considered as if it was for a Samudaya Bhavana, for community hall, and not for education or health center, since respondent number 2 itself is not clear as to what it wants to establish in the same civic amenity. If the comparative merit was in favor of respondent number 2 as regards the community hall. The same could have been allotted to respondent number 2. It is not open for, it is expressly clear that it was not open for respondent number 1 to allotted the civil community site for the purpose of establishment of educational institutions without determining comparative merit between the petitioner and respondent number 2. This, in my considered opinion, falls foul of the Wednesbury principles of arbitrariness as applied to both in Tata Cellulose case and Mahadev Real Estate and others. Inasmuch as if there is any manifest injustice which is caused to any of the parties, this court would be bound to interfere in the matter to correct the injustice on account of such manifest arbitrariness which has occurred by a administrative action. The requirement of Rule 7 not having been followed by the respondent number 1, as also respondent number 1 not having considered the applicability of rules of the Karnataka Education Institutions Classification and Registration Rules 2018, which had by then come into force, which they made it clear that no education institution could have been established except for a pre-primary within area of less than 2,000 square meters. It was but required for the decision-making authority to have referred to the same and have categorically classified that it is being provided for education purposes for pre-primary, which is also not being done. Thus, there is absolutely no application of mind by the subcommittee which has occurred in the matter, resulting in a decision which has been taken allotting the land to respondent number 2 without complying with the rules. As such, I am of the considered opinion that the decision taken on 13/3/2018 at Annexure G would have to be quashed. As such, I pass the following order. The decision dated 13/3/2018 passed by the committee of the first respondent insofar as sale number site, insofar as site-wide sale number 31, notified sale number 42, bearing number 333, 336, and 337, measuring 1,500 square meters of Belvedere, Mysore at Annexure G is hereby quashed. The respondent number 1 is directed to redo the exercise of comparative evaluation, keeping in mind the above principles, as also the requirement of rules of 91, and more particularly rule 7 thereof, within a period of
3 months. Now, the reason is the election is ensuing that the board meetings cannot be conducted during the code of conduct.
Because of
12 weeks on the date of receipt.
I may be considered because there is no, when the invited application, there is no restriction. That now that restriction has come. Therefore, I may be confined to my time only in respect of any one of this. I may be permitted to file additional statement before that.
The
reason is not the
respondent number 1 is permitted to restrict its application for one particular category by furnishing supporting documents in relation thereto.
Respondent number 2.
Respondent number 2.
Please.
12 minutes.
Next week.
At the request of counsel for respondent number 2 and 3 released on 30th.
Please.
No shareholding, no loan, no assistance. And ಹೇಳ್ತಾರೆ. So this would have to be quashed alone.
ERCS himself is present, my lord. And his instructions I am saying.
In pursuance the order dated 9/3/2023, what's his name and designation? So and so is present before this court. There is on instruction, on his instruction, submit that the government is not holding any shareholding, has not issued any loan, nor has provided any financial assistance or guarantee to respond number 3 society. Right. The same is taken on record. And the petitioner is before this court seeking for the following reliefs. The contention of Sri Devi Prasad Shetty, and counsel for the petitioner, is that no action could be taken against respondent number 3 under section 30 of the Karnataka Cooperative Societies Act 1959. Since it is only if the government were holding any shareholding, as it had issued any loan or provided financial assistance or any guarantee that it would derive its power to take action against the office bearers of respondent number 3. Taking note of the said submission, while order dated 9/3/2023, learned AGA was called upon to make a submission in regard to the above. Today, the ARCS says so. Taking into account the said submission made, and the considered opinion that respondent number 2 did not have derived any right under section 30 of the Karnataka Cooperative Societies Act 1959 to take any action against respondent number 3 and or its directors, let alone former directors. As such, I pass the following order. Petitions allowed, a certiorari is issued. Annexure A1 dated 27/12/2022, bearing number so and so, passed by respondent number 2, is the other point.
Serial number 47.
Wait for a week's time.
I will request to the petition released on 30th.
Serial number 50. Naveen C. Call number 6 to 10. For a short of
Appearing to petitioners in this matter, they had to, we have served everything. They had to file their
Petitions file agilva. Where R5
R6 to 10.
6 to 10. Sri KV Munish Kumar is entered appearance for respondent number 5. B. Sanjeev has that appearing for respondent number 5. You have filed your objection, Mr. Pawan Kumar?
No, my lord, I will file.
Counsels for respondent seek for and are granted 2 weeks time to file their respective objections. Objections, if any, by 31st, released on 6th.
51.
51, please, my lords, for the petitioner. It's only an innocuous prayer, my lords. Tar haki anta kelta idare. 5 years in the road is not tarred. Therefore, they have made your representations, my lord. What I'm seeking before your lordships is to consider that representation.
Last time what happened, well, as per my instruction, and BBMP have been to the spot for road, faulting a road. BWSSP said that we will put some lines, water pipe something. So on that ground, they have implemented BWSSP. In the afternoon, Monish Kumar said made a mention also that he needs to seek.
So now the lines have been laid or not laid?
That is what, as per my instruction, not even some tender notifications also issued from our side as per my instruction.
For what?
For road, I think so. I will just clarify it. Next.
Then you will form the road and then they'll again come and take the.
That is what clarification is needed from BWSSP side also.
Next,
My
please.
apprehension, my lords, is that once the code of conduct is effectuated, my lords, then again 3 or 4 months it would get delayed. That is my intention.
We'll have it on Thursday.
Grateful. It's very well.
We'll have it on Friday.
Very well, my lords.
Shri Monish Kumar is directed to make a submission as regards whether the VWSB sanitary lines have been laid in the road under question. If not, is there any proposal to lay such pipes? We list on 17th March.
Grateful.
52, Sarvana S.
Unequal planning.
Yogesh D. Nayak.
Yogesh D. Nayak accept notice for respond number 2, 3, 4 also. Ask for the petitioner to serve copy of the petition along with annexures thereof. None appears for the petitioner. We list on objections, if any, by 31st, we list on 6th.
Applied for the sanction of a development plan. The proposed road is shown in the master plan. I have also incorporated this at the proposed road in my master in my development plan. Now they want to be relinquished to them free of cost, covered by decision of my lord.
Without regulation, regulation itself clearly stated as per the journal regulations. In regulations, proposed road is not relinquished to the authority without challenging that, my lord.
Now regulation.
Connect properly.
How can you even have a regulation like that saying you relinquish free of cost to the government?
Nandu commercial.
Your duty that you have to do for forming roads.
If road is my lord.
Tomorrow tell them whoever is going to use the road, all of you contribute, then only will.
And only say that, my lord, as per the regulation, my lord, if lordship crash that regulation, my lord.
ಇಲ್ಲ ರೆಗ್ಯುಲೇಷನ್ ಇಲ್ಲ ಇದಕ್ಕೆ ಶಾರ್ಟ್ ಟೈಮ್ ಸಬ್ ಇಲ್ಲಿದೆ ಇಲ್ಲ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ
ನೋಡಿ ಏನೋ ಬುಕ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ
ಮಾಸ್ಟರ್ ಪ್ಲಾನ್
regulation, journal regulation.
What I sought for is consider my interplay subject to result of the petition.
How can we do that without your challenge? This will go. We'll have to dismiss it now only.
Friday, my lord.
Counsel for the petitioner seeks for and is granted 3 days time to file amendment application. We list on 17.
Hello.
This is the property tax matter. May I just pass on the similar matters.
Connection.
Connect ಆಗಬೇಕು. Interim order ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ. May I just pass on this? Detailed order is at page in page 6, 14, the order dated 19/21, in writ petition 15872 of 21. Alala. In fact, there was a proposal to the chief minister.
It's a blanket stay.
Blanket stay. This.
Access notice for respond number 1 and 2. In view of the order dated 1/9/2021 passed in
15872 of 2020.
15872 of 2021. The order of reassessment demand notice dated
28/3/2022 at Annexure D.
28/3/2022 at Annexure D is stated for the next date of hearing. Connect the above matter with?
Connect same the other batch.
So also and post it before.
Naga.
Connect so and so.
Document serial number 55. Robert D'Souza.
For the petition.
Yes. Taluk Panchayat, yeah. Taluk Panchayat, Bangalore South. Ms. Devraj is directed to accept notice for respond number 3. Mangala Lakshmath is 5, 6. So you serve a copy on Mr. Ms. Devraj. Counsel for the petition serve a copy of the petition of the connections on Mr. Ms. Devraj. Objections if any by 31st, released on 6th.
Number 2. Serial number 1. R.V. Jayaprakash.
I appear for the petitioner. Although on the last date of hearing,
Corporation to produce form number 3, is demand notice, and as well as other records. Old records, it pertains 2011. Matter was heard at length before the Lordship Justice Suraj Govind. S.G. Pandit. Sorry. At that point of time, these records were sought.
Yav produce Martirapa.
2 weeks, and they are the old records.
Counsel for respond number 1 and 2 seeks for and is granted 2 weeks time finally to produce the original records as directed on 17/2/2023. If the documents are not produced on or before 31st, adverse inference would have to be drawn. Released on 6th April.
6th.
Or you decide whether you want to produce or not.
the date may not.
6th April. 6th April.
6th April.
Serial number 2.
What will you do, Mr. Chandrasekhar? You will appear for R2 or no?
Hardship in this case, after verifying the records, M. Pradeep is filed Wakalat R1.
R1.
MS Prakash only for R2. Subsequently, they have implemented as a CMC Miller. Thereafter, will file Wakalat.
So Pradeep will also be there, Prakash will also be there, you will also be there. MS Prakash has filed Wakalatnama only for respond number 2. Registry is directed to correct the appearance in the first list. Counsel for the petitioner seeks for
2 weeks time.
Yenike. Seeks for 2 weeks time to get ready and address his arguments. Released 3rd April.
Serial number 3.
I appear for the petition. I seek a week's adjournment.
Who is respond number 2? Respond number 2.
Who
Director.
is the director of town planning?
Of which? BDA, BBMP?
So this is for the urban development authority Markara.
Yaudu? Bayapana?
Illa. Markara urban development authority.
Who is the standing counsel?
3K euro, Nagendra Naik. 3K.
2K, 2K.
2K, I have no idea. I have no idea.
And AG accepts notice for respond number 2. Counsel for the.
Petitioner, I request a week's time may be granted.
For what?
Senior is unable to come down today due to personal inconvenience.
One submission. Illi respond number 4 to 10. But directed to be implemented by way of writ appeal by an order. Now the amended petition has not been filed and given to us as a copy for us to file our objections. Writ appeal was allowed.
That you can give, your senior is not required.
That I'll give.
When will it be? And counsel for the petition.
Writ appeal was allowed in 2017.
You are asking for it only today. Counsel for the petitioner seeks for and is granted 2 days time to furnish a copy of the petition along with annexures on counsel for respond number 4 to 10, who seeks for 3 weeks time thereafter.
Yes.
File a statement of objection.
Yes,
Objection is pending by 6th April, released on 13th April.
What?
Or third.
KV Narasimhan.
7 or dismissal. Infractions.
Third.
Infractions. Kate appeal available.
3rd April.
Yeah.
7 serial number
7
7.
3rd April. Okay. 7 3rd April. 8
KV Narasimhan.
3rd April.
Serial
8
number
9
9.
3rd April.
10.
Yavudu?
9.
3rd April.
Serial number 10. Raju, yes.
None appears 3rd April.
7.
6th April. Objection for impleading.
Yes, my lord, I will file, but they have not served the copy, my lord.
Officer Raju. So Nishant. None appears for the impleading applicant. Copy thereof has also not been served on the counsel for the petitioner.
Yes, my lord.
If the service is not affected by 31st, the application will be liable to dismiss the non-prosecution released on 6th April.
17. PM Siddhamalappa.
On 6th April.
PM Madhav Reddy.
Infractions.
ನಿಮ್ಮ ಹೆಸರು?
Venkatesh D9.
Sri Venkatesh also appear on behalf of the Madhav Reddy, counsel for the petition, submit that the above petition is being rendered infractious. Accepting the said submission, the petition is dismissed as infractious.
20. Yes, Mahadesh.
Short question of action taken against the petitioner under the provisions of PP Act. 401 notice is a very self-explanatory.
Shopping complex, sir.
It's a joint development, and we put up the construction for 30 years of lease. One fine day they issue.
Lease is expired and it is not renewed. And MA is also dismissed practice.
Released on 28th.
21. Girish Ravi.
Oh, ಇದರಲ್ಲಿ ನೀವು ತಗೊಂತೀರಾ 22 ಆರ್ ರಾಮಚಂದ್ರನ್.
Ramchandran, sir. 22.
Ramchandran, who had entered appearance, is stated to be no more. S.G. Puranik, who had earlier appeared, is discharged.
Puranik sir appears. He is in panel.
He is now on the panel.
He is in panel. His name.
Sri S.J. Puranik has entered appearance for respond 1 and 2. Delete D.R. Ramchandran and that appearance for R. 24, the Mohan Bhatt has entered appearance for respond number 1, delete S.C. Shivama.
24, I appeal for respondent number 3 to 6.
1 and 3. Okay. 1 and 3.
1023. 4393. 1023 of 17.
Yes.
I appeal for respondent 1 and 3.
1 and
3.
3. Who is for 2? S.C. Shivama has also appeared for 1 and 3. Mohan Bhatt also.
Now they are not on panel.
Pallava has entered appearance for R1 and 3. Delete Mohan Bhatt and S.C. Shivama.
I appeal for all the 3.
All the 3.
Really?
Pallava.
Serial number 18 now actually I appeal for the respondent corporation.
Yes, for R1 to 3. Delete Mohan Bhatt and S.C. Shivama. At the request of counsel for respond. Objections file ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಈಗ
Points 2 weeks time is granted to file objection. Objection is any by 31st, released on 6th.
Serial number 11 inspections ಆಗುತ್ತೆ ನಾನು 11 inspection
for serial number 18 withdraw on the petition. I appeal for the respondent corporation 3 to 6 ಇದರಲ್ಲಿ.
So 18 ಅಲ್ವಾ ಅದು?
18 11
Apologized.
18 adjourned to 6/11. Counsel for the petitioner submitted the petition has become ineffective. 27, and AGA accepts notice for respond number 1 and 2. None appears for the petitioner. Counsel for the petitioner is directed to furnish copy of the petition along with annexes on the said counsel. 30. Shri Pawan Kumar accepts notice for respond number 1 to 4. Delete R. Ramchandran. List on 6.
43 my lords, in the morning round it got passed over.
43. 43 ಇವಾಗ ಶ್ರೀನಿವಾಸ came and took adjourn.
Again, it was not there, I think. Second round.
ಅವರಿದ್ರು ನೀವಿರ್ಲಿಲ್ಲ.
Shorter date, my lord.
ಯಾವ date?
30th March.
30th March. 30th is shorter.
57.
6 months. If you want to give 1 hour's time every day, it's not even coming to half an hour. Only 15 minutes, madam, we have a meeting also. A meeting in the till 5 o'clock.
I will try to finish as much as at least 3 parts.
We'll take installments only. Can't help it.
Yesterday I was just reading,
Baden Powell is over now.
Baden Powell is all that he says is that it is Ghana lands are part of the Sanad, and that there is a Nazar Kanike and Gati fee paid when they take on these lands. The lordships immediately after the memoirs of political survey, I have a single page which is taken out of the Cook memoirs by several more. And just taken out single page in that, but it's very relevant. Page 62 of this.
Yes, page 62.
With regard to the worshipping. Lordships at page 62. The principal, the last paragraph.
Yes.
The principal place in Cook idolatry is held by the worship of the dead. Every family offers a sacrifice to departed ancestors once a year, sometime during the 2 months preceding the monsoon. A fowl, generally a cock, is offered on these occasions upon a stone devoted to the Karuna, somewhere in the jungle land belonging to the family estate. So the jungle land is purely the Bane lands. So if it belongs to the government, I'm certain nobody would put up their iron houses and the temple for their ancestors in a public property. So, for this purpose, I have just factored out of this, your lordship. Karana is the name given to the head of the families, whether living or dead. Your lordships, I'll take your lordships through the gazetteer of Cook.
Yes.
Your lordships, the first listing at page 48 is with regard to the.
Page?
This is with regard to the cow slaughter, which was prohibited even during
Page number?
British time.
Page number?
That is page 48, may not be relevant to case 48. It is regarding cow slaughter, which is
Yes.
The Europeans were also prevented from eating beef in food district, in province. Page 117. The occupation and general character of the foods. Worships, I just want to point out the first two sentences. The Cougs or Kodagas, as they are properly called, are the principal tribe of the country, and from time immemorial, the lord of the soil. So they were first peasants, and then only they were warriors. Lordships at page 130. Page 130, Your Lordships, the
130.
paragraph. Page 130.
Yes.
As already remarked, the Cook house is the domicile of all the male relatives with their wives and children belonging to one parental stock. The landed property or Jamapum is vested in the house and cannot be alienated from it or divided amongst its members. Lordships, the whole idea is that the amount of significance given to the land which is attached to which belongs to the family. Lordships, thereafter, page 252. 51. Third paragraph, page 251. The Jama Cougs holding their land by a military tenure in return for the immunities which they enjoyed, all able-bodied men of this active and warlike peasantry constituted the Raja's military force, which though irregular in its organization was kept in the constant practice of its duties. These personal services of the Chaudigaras or Coug soldiers as guards for a period of 15 days at a time enjoyed by the Raja and admitted by the riots were rendered with cheerful obedience. Under the chief command of the Raja, the force numbering at times from 6 to 10,000 Cougs was subdivided into bodies of various strengths. The smallest numbering from 10 to 100 men under a Jamindar. Any larger and more indefinite number was commanded by a Karyagara who again acted under the Sarva Karyagara or general. Both were distinguished by a gold banded scarlet headdress, the Kumbi Topi. As the Coug force was not a standing army, it received no pay. Whilst on active duty as guards or during warfare, the soldiers were maintained at the public expense, and being remarkable predatory habitats, they largely shared with the Raja in the spoils. Without discipline or organization, the Cougs displayed their strength chiefly behind the stockades and kadangas. In the open field, they rarely faced the attacks of regular troops. This is I mean, it's a quasi-feudal tenure because the land was already available with the people. When the Raja came in, they were ruled by the Coug chieftains. At that time also they had their own lands. They were first cultivators, then after that they would, of course the country was foremost for them. And they would, so it was a peasant who was also a soldier. So
Whenever there is
he
a
was
war,
doing
he'll be
all
a soldier, when otherwise he'll be a peasant.
Yes.
He's a farmer.
Yes, and he was serving in the army of the Raja, for which the Raja gave this thing was that he was given half the he wouldn't have to pay the full assessment. He just paid half the assessment of what the Sagu holder had. And again, in the Jama properties, the Banas, Jama Banas were part of the Sanad. But the same thing does not apply to a Sagu land. The Bane, they are provided with Bane. Every time there is, when work lands are given, automatically there should be a jungle land handed over along with the this thing. That was the system, even before the Rajas. Yes,
That would be common crop.
yes. It would be common for that family.
For the
Whoever
Ain
inhabiting.
money, that would be the common crop.
Lordships?
For the Ain money, that would be the common crop.
Yes, yes. And the other thing is that though the wetlands were held severally, the Jamma Banes were never partitioned or divided among the thing. It used to be common to all the family members. And that is being followed even to this day. Lordships, page 365 is regarding the gun exemption which is given to Jamma holders because they are worshippers. We have the festival arms where we worship weapons. Then comes 401. The Jamma tenure from the Sanskrit word, page 401, your lordship, the last paragraph.
Yes.
The Jamma tenure from the Sanskrit Janma, a word conveying the meaning of hereditary by birth, is the holding of the privileged class called Jamma Riots, comprising Kug, Amma Kugs, Hegres, Aimbicolas, Iris, Koyavas, Maplas, and Gaudas. The light assessment of ₹5 per 100 battis of wetland with its accompanying Bane and Barike was made originally on condition of military and general services to the state. The Jamma riots are still liable to be called out to repel outward aggression or quell internal disturbances and to furnish all police and treasury guards, escorts, etc. in time of peace. Excepting old men and boys, there are now 7,070 active Jamma riots, of whom 4,910 are Kuls, and the next in number is 1,244 Gaudas. So all these persons who have been listed out here, except the Hamakodo Kugs. The others are settlers who have come. The Moplas also are converts from Kug at the time of Tipu.
Moplas are from Kerala who had come.
Lordships?
Moplas are from Kerala.
Moplas are from Kerala, but the Kodwa Moplas are also there. They were converted by Tipu.
Okay.
They did not get back into the fold, though they were asked to do so. Your Lordship, 402, again, there is Bane, a kind of definition. Bane, it is on the last, the second, third para. Bane, the highland adjoining generally clothed with forest from which each farm obtains its firewood, manure, grass, etc. That was the utility at that time. It was a jungle land, but it was when coffee came in that a good lot of damage was done by the Europeans who cleared out a good lot of forests and they were holding it in with high acreages. Whereas these Jamma Bane holders, some of them were very reluctant to cut their trees, so it belonged to them. But later, the judgments that came in said that the trees don't belong to them. There is a difference. There are two types of this thing. Up to 1886, there were these families which held the lands for which the king gave the sanad. Thereafter, the king has also given some Jamma lands. In terms of Jamma lands, he has allotted certain lands, same as having a Varg and Bane. And such lands have been given for distinction and in war and etc. And some of them have been just given to them. The king was more in favor of encouraging division of property so that more land would go on to cultivation. But he has given many people Jamma lands. But as far as that Suryanath Kamat's Gazetteer is concerned, it says that they have not found any one Jamma sanad of that kind. And and they were being treated up to 1886, they were being given different treatment as far as the lands were concerned, Your Lordship. The British also granted some Jama lands. Your Lordships, I'll try and finish this, Your Lordships. I think you're running out of time.
Yeah, this book we can finish today.
Yes, I'll. Page 4 and 5.
415.
The farm, in this first sentence itself, the last word, the farms produce also oranges, vegetables, and coffee free of tax on plots of banana land less than 10 acres, which add to the income of the proprietor. But on the other hand, as all the members of the family lived under the same roof and subsist on the produce of the same farm, there's little real profit left. So that means that they were collecting some tax in terms in kind also. But, the king was collecting tax in kind. Further, however, the assessment of Jama riots may appear to be, the changes effected in general administration of the country and the imposition of various taxes have greatly modified the relative value of this tenure. Establishment of a number of departments, the officers of which with their subordinates are frequently on the move, imposes almost of necessity services on the Jama riots for the performance of which formerly their slaves were used and which consequently now the masters with their crude portion of free trade very unwillingly perform. Of the cook whose pride as a martial race has always been fostered by government, it can hardly be expected that they should readily carry the camp loads, etc., of the public functionaries and the exigencies of the Sirkar. In this respect, might perhaps be fulfilled without too much wounding the self-respect of the cooks. Many Jama riots, it is said, are on the point of resigning their Jama with the intention of holding the land on Sago tenure and thus escaping this vexatious service. In 1869 to 70, the revenue from Jama lands amounted to rupees 50,893. Your Lordships, page 410.
Yes.
They have page 410.
410.
410.
Yes.
The second para. With the year 1866 to 67, a new source of land revenue arose from the assessment on land taken up for coffee cultivation. After much deliberation and correspondence on the part of the Cook Planters Association and government, we later finally resolved in October 1863 to abolish the halat or excise duty of 4 annas per bond of 28 LDs or 1 rupee per 100 weight of clear coffee and to substitute on acreage rental on the following terms. So there were certain, the halat was removed, that's the excise or transit tax.
Yes.
And they charged it on the basis of
Acreage.
acreage, and that was also disadvantage.
Hearing on this man.
No, we are not on that. Your Lordships, and the other thing is with regard to the disposal of wastelands, the following rules have been framed by the government. There is a thing called paisari lands that belongs to the government.
Yes.
And and somewhere in one of the books it says private paisari. Private paisari is the one which have been granted to the people, and they call, but it is a government land. And the government holds some kind of a, they have a hold over those properties. And they're not the same, who they may be.
Even on the private paisa.
Yes, some restrictions have been laid.
Where is that?
In this 411, the first sentence is with regard, this is third para. With regard to disposal of wastelands, the following rules have been framed by government. Wastelands in which no rights of private proprietorship or exclusive occupancy exist and which may not be reserved as hereunder. But by and by in the rules, they are permitted to take over these lands. Your Lordships, and once it is being taken over, there is a condition which there's a thing called redeemed and unredeemed. where they'll have to, once they take it up,
And that also won't have any bearing on.
No, the trees have a significance because most of the judgments say that since the tree is old, it doesn't belong to us. So that land is not, particularly a Chikera case, it says that the land does not belong to us because we have no right over the trees itself. But that is not the real case. That is where the grants have been, this thing, there is a question of redeemed and unredeemed. And then as regards the registration of the sanads is at 416, Your Lordship. The registration of these assurances according to Act, this is 16 of 1864, appears not to be much appreciated by the natives, who shrewdly remark that if the Chief Commissioner's signature to their title deeds cannot assure their validity unless registered by a local official, what is the good at all of these documents? In fact, they do not seem to care for them and are likewise prejudiced against the obligatory registration of these Jama sanads. So but at that time, they were, the Jama sanads were to be registered. So it was an authentic document which was recognized by the British also. Then comes the amended rules for carrying out the substitution of an acreage on coffee lands for the halat or excise duty. Here again at Roman number 12, page 417. The Bane lands of the Cougs being included in their sanads as part of a tenure with a permanently fixed rent and assigned hereditarily to them forever, not to be subject to the assessment to coffee lands unless when cultivation is over 10 acres. Such land be separated from the Vargo or farm. So here again they say the Bane lands are part of the sanad. So again the ownership lies with the owners of the sanad. And one other thing that should indicate that the ownership is not with the government but with the individuals is the fact that at page 420, it talks about the revenue survey. The last paragraph on page 423. There are still about 21 European and 1,753 native.
What is page number?
423.
423. Yes. There's still about 21 minutes.
There are still about 21 Europeans and 1,753 natives estates to be surveyed. The cost to the planter of surveying his estate has been fixed by government at the rate of 3 annas per acre. So here this clearly indicates when survey was conducted, it was the private persons who paid for it. So if it is government, this thing, it would have been, they wouldn't have had to pay that amount. So these are reasons why.
So this would also include Jama Bane land is what you.
Yes, yes. Lordship, this book is not fair.
We will continue again tomorrow. All further arguments. We will tomorrow.
ಅದರಲ್ಲಿ ಲೇಬರ್ ಅನ್ನು ಸೇರ್ಕೊಂಡ್ಬಿಟ್ಟಿರುತ್ತೆ ಸಿಕ್ಕೋಟ್ ಟಿಕೆಟ್ ಆಗಿ ಆಗತ್ತೆ ಲೇಬರು ಫುಲ್ ವರ್ಕ್ ಕೊಡ್ತಾರೆ ಇದನ್ನ ಸೇರಿ ಬರ್ತದೆ ಅದು ಒಂದ್ಸತಿ ಕೋಡ್ ಹಾಕಿ ಎಂಟ್ರಿ ಮಾಡಿದ ತಕ್ಷಣ ಅದು ನಾವು ಡೇಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಆಗ 6 ವರ್ಷದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಇದ್ರ ಮೇಲೆ ಮಾಡಿದಾಗ 20 ಕೇಸಸ್ ಯಾವ್ದು ಅಂತ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಾಗ ಲೇಬರೇ ಅರ್ಧ ತೋರಿಸ್ತಿದೆ. ಇವಾಗ
I couldn't reset or made it.
Okay.
I voted one. I think that not much, but you will follow. Tomorrow, 4 o'clock.
I think All 2 days, Vishnu is not getting up. Vishnu is not getting up. Is the reason we are not getting there. Otherwise, another matter is get stuck up. Today 44 got stuck up for almost. And then again 41 was passed over and it 44 it was taken up in the morning.
No, 44.
It started in the morning, it ended up to 3:30.
Yeah, I was watching the list.
Again 41 was passed over and again that also took some time.
Yeah,
So the least get over it.
I thought just 57. I was planning to come early.
Oh,
By
yeah,
chance, if I
yeah,
get
yeah,
up.
When I was thinking that we blow it, we play. Have it.